Tuesday. Tuesday. What is that urgency? Monday. Yes.
Revision. Urgency is this. Not a association of apartment owners. They filed a petition suit for recovery, small cost suit.
Yes.
That is dismissed. That they cannot seek maintenance charges. About 380 apartments are there. Now everybody is saying that we will not pay because we need. Court has said that petition is not maintainable. There is great urgency because 380 apartments we have to manage.
No, you are challenging that order of dismissal.
Yes, rejection of the claim.
Rejection of claim.
Yes,
Monday. Yes. Monday.
my lord,
Tomorrow. Yes.
Yes.
One matter, MSC.
Yes.
It was moved in the last week. The date was given today. The file is with the board. Before the trial court, there is appointment of petitioner order and they are visiting the property tomorrow.
Monday.
Nadigalli date tomorrow.
Tomorrow.
Over by judgment of export in Kunjuvan.
Witness. Page wise.
Page judgment, page number 1, page number 1, serial number 3, page number 2, serial number 4 to 11.
Serial number 7.
7. Yes.
I had complied with office objections. I think court fee has to be paid. 2 days accommodation. I will.
Yes. Week's time is granted to complete that obstacles.
Serial number 8.
Yes.
Serial number 8.
Yes. Week's time is granted to do the needful.
Please, Mary.
Page number 3, serial number 12 to 17.
Serial number 16.
Yes.
Withdrawal of the appeal. Already filed memo.
Yes. Learned counsel for the appellant has filed a memo. Taking of this court to withdraw this appeal. Memo is taken on record. The appeal is dismissed as.
So one more matter. MAP 4/08/22. Matter may be tomorrow postponed.
Memo padi. Yes.
Page number 4, serial number 18 to 22. Page number 5, serial number 23 to 30. Page number 6, serial number 31 to 37.
My lord. 32, my lord. Greatly grant 2 weeks time, my
See,
lord.
Baswara,
2 weeks
Major
time
office objections have been complied with, my lord.
2 weeks to comply of this objection.
Page number 7, serial number 38 to 42. Page number 8, serial number 43 to 50.
My lord, serial number 50, my lords.
47. Yes. Yes, at the request of counsel for petition next week. Interim order granted or is extended till next date of hearing.
Serial number 50, my lords, page 8.
50.
Please, my lords, I appear for the appellant. My lords,
Yes.
some inconvenience today. I am seeking a short accommodation. Any date next week, my lords.
Yes,
Yes,
sir.
Kumar, yes.
At the request of counsel for the appellant, use this matter of 2 weeks. Yes.
Any date may be fixed, my lords.
Not yet. Yes.
Page number 9, serial number 51 to 53.
Not serial number 51.
Yes.
I appeal for the appellate process, my lord. I am ready, my lord. Ready next week, my lord. Ready. They have taken about 4 of the senior council, my lord.
No, what is that urgency?
Urgency ಏನಂದ್ರೆ ಅಲ್ಲಿ ಇದ್ರ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಅಂಡ್ ನಾಟ್ ಟು ಇಂಟರ್ಫಿಯರ್ ವಿತ್ ಮೈ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ ಮೈ ಬೇಸ್ಡ್ ಆನ್ ದಿ fraudulent documents they have created a sale deed. ಆಗ್ತಾ ಇದ್ದಾರೆ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪೊಸಿಷನ್ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
It is his suit. Suit has filed by him.
Yes, my lord.
Injunction is not to interfere by you.
And also, my lord, not to alienate. My lord, she has created a fraudulent document sale deed. Right tips appeal. 39 ನಾವು
Injunction order has 39-112 ಯಾರ್ದು the order?
ನಮ್ಮ suit.
39-112 who has filed? You don't know who has filed that application.
Kindly have this matter after 10 days, my lord.
Next week.
Yes, my lord. No, my lord. Next date may be 9th, so Monday.
10th.
11th, my lord.
11th is the motor vehicles matter. 12th.
12th.
Yes. At the request of counsel for the respondent, read this matter on 12th.
Page number 10, serial number 54 to 58. Page number 11. Page number 12, serial number 59 to 64. Page number 13, serial number 65. Page number 1 for page number 2, serial number 1.
Yes, not passed.
No, that is the only clarification.
Like ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ advocate earlier suit is not mentioned. The suit in which my lord a compromise was entered into between the parties. That the suit number has not been mentioned.
Why
Because-
that is not necessary.
On the last occasion, my lord, a submission was made that my lord, by virtue of the compromise that was entered into in the previous suit.
Submitted that counterclaim filed is not in respect of the reopening of that compromise degree dated 29/7/25 passed in that OS number ಹಾಕಿದೀವಲ್ಲ. Yes.
Para 9, if my lord.
In view of that,
Yes,
it will not survive. ಅದ್ರಲ್ಲಿ ಯಾಕೆ ಹೇಳ್ಬೇಕು ಅವರು they have undertaking that this is not for reopening of that compromise petition that I have stated in view of.
ಅವ್ರು ಹೇಳಿದ್ರು that they will not reopen the earlier compromise
Hmm.
in the present suit ಅಂತ.
Hmm.
That my lords have observed at para number 8.
Hmm.
Just read para number 8. my lord.
Hmm.
The learned senior counsel appearing for respondent number 3, defendant number 4 has categorically submitted that the counterclaim filed is not in respect of reopening of compromise decree
Hmm.
dated 22/7/2005, passed in OS number 2673 of 2004. Therefore, bar under 23 rule 3A of CPC is not applicable.
Hmm.
My lord, this was the contention. Further, my lords have observed at para 9, in view of the submission made by the learned counsel for respondent number 3,
Hmm.
the contention raised by the plaintiff will not survive for consideration.
Hmm.
The trial court has rightly rejected the application. Accordingly, the civil division petition stands disposed of. But since my lord, if my lords were to clarify, my lord, stating that in view of the undertaking, my lord, given by the respondent number 3, that they would not insist for reopening of the previous compromise. Not the present civil revision petition stands disposed of. Antandre.
No.
Otherwise, my lord, what happens is, my lord, this will give to a lot of interpretation and.
No,
debate,
no,
my
no.
lord.
See, they have undertaking that
Yes, my lord. If my
their
lord,
written statement is reopening of the compromise.
yes,
Now, tomorrow they cannot say that they are filing in a written statement of reopening of the compromise. That has been undertaken by them.
what
See,
yes,
tomorrow they can file in another written statement, if court may permit. There they may take in present written statement, your allegation is that in the counterclaim, they have made it that reopening of the compromise, which cannot be permissible because they have to approach the same court. By reading that written statement in the counterclaim also, it is not there for that reopening of that compromise. They have also undertaken that will not reopen.
such observation, if my lords were to clarify, my lord, in para number 9, that my lord, in view of the submission made by the learned counsel for respondent number 3,
Hmm.
only that they would not reopen the earlier compromise.
No, not reopen. That right is there in the written statement filed now. It is not for reopening. You can't curtail the right to reopen.
That was my entire case, my lord,
Now,
because
see, you have said that by counterclaim, they are seeking for a reopening of
of
that.
the earlier compromise. Yes,
By reading that counterclaim, there is no such specific that for reopening. They have also said that counterclaim filed present, it is not for reopening.
ಅಲ್ಲ, ಅದೇ ಆ undertaking ಅವ್ರು
That is
ಹೇಳಿದ್ದಾರೆ.
what I have taken that.
ಸ್ವಲ್ಪ explicit ಆಗಿ if my lords were-
No, that it is there, their undertaking is there on that record. They said it is, this counterclaim is not for reopening. They can file another counterclaim, we don't know that, but present is that, your allegation is that it is for that reopening of that. Now they said it is not by reopening, therefore that contention will not arise.
Only thing is,
Hmm.
trial court has rightly rejected the application ಅಂತ ಇದೆ. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಹೇಳ್ತಾರೆ, ಆರ್ಡರ್ 23 ರೂಲ್ 3, ಐ ವಿಲ್ ಸಿ ಅಟ್ ದಿ ಟೈಮ್ ಆಫ್ ಟ್ರಯಲ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, that trial court, ಅದು ಅಷ್ಟೇ.
ಅಷ್ಟೇ, ಅದೊಂದು ಮಾತ್ರ ಅಷ್ಟೇ.
Yes.
The trial court has rightly rejected the application
The
ಇದೆಯಲ್ಲ.
review of the submission made by the learned counsel for courts, the review, see, that line will delete.
ಅಷ್ಟೇ, ಅದೊಂದು ಮಾಡ್ಬಿಟ್ರೆ, ಯಾಕಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್
That I have-
23 ರೂಲ್ 3, we will see at the time of trial ಅಂತ ಹೇಳ್ತಾರೆ. So therefore, in view of that,
Yes.
ಅಷ್ಟೇ ಅದೊಂದೇ.
In matter is posted for being spoken to. A typographical error in para 9, page 8. The line, the trial court has rightly rejected that application. Deleted. Ali correct ಆಗುತ್ತೆ. Contention raised by the
ಹೌದು,
plaintiff
ಸರಿ
is not
ಹೋಗುತ್ತೆ,
covered.
ಸರಿ ಹೋಗುತ್ತೆ.
Accordingly, yes.
Para
And
10
also
in view
para
of
10,
the disposal ಬರ್ಬೇಕು.
yes, by typographical error. Instead of disposal, this has been typed as a dismiss, same has been corrected as disposal. The office is directed to issue a corrected.
That's all. Great.
Serial number 2, consecutive inquiry for appellate.
Very good.
Yes, Mr. Kulkarni, that Supreme Court, recent Supreme Court, directly on the point.
If I am not wrong, my lord, it is that Satyanath case.
Huh?
Satyanath case.
2020.
Satyanath. Correct.
Ah.
There is nothing in that. There is nothing.
No, they said it cannot be a preliminary issue. It is contrary to the provisions of so and so.
That is, no, your lordship may guide in the para number 62.
Yes.
Conclusion is there. 62. Number 62, the legislators have said, in view of the above discussion above, we summarize our finding as below.
Para
Para 62 month.
62 ಏನು ಇಲ್ಲಲ್ಲ. Para 34 is that last 35.
Just above para.
No,
29 ಆದ್ಮೇಲೆ 29 ಆದ್ಮೇಲೆ.
29 ಆದ್ಮೇಲೆ 62 in view of the submission.
ಹಾ.
ಅದು ಯಾವ್ದೋ ಬೇರೆದ್ರದ್ದು extraction ಅಲ್ಲಿ. It is not the finding of that court. Extraction of the judgment. See para 29 appellant before this court, it was considered whether the res judicata mixed question of law facts court has held under. Para 26, in view of the discussion above, we summarized our finding below issue regarding so and so. It is in respect of that
31, 32, 33, 34.
62 is not that it is in a judgment of that other case has been extracted. Otherwise, when that case itself is, once there is a mixed question of law and fact, it has to be tried along with that other, it cannot be by, I will fix the time limits within 1 year, it has to be completed, Mr. I will make it that along with that other issues, this also has to be issued and tried together.
That's
You can take this contention also, that way you modify.
I make one request. So what for assistance of senior counsel, you know?
For now, for being spoken to. Being spoken to, how can that assistance of after disposal of that? Now that Supreme Court said, see, our main contention itself is that it is a mixed question of facts and law. It cannot be rejected as a res judicata. It has to be tried. Now we said it has to be tried as a preliminary issue. Supreme Court said, no, it cannot be. It has to be tried as an issue.
Along with
That other issue.
along with
That I will clarify that this can be one of the issue. Along with that other issue, it can be
Yes.
tried. It can be disposed of.
issues are already, other issues are already framed.
This can be framed as an additional issue and
Yes.
Yes, disposed of within 1 year from the date of rest of copies.
Hey, make some investigation or research and make submission.
For what? This is what that,
About this only, my lord, that there is any other further.
yes, tomorrow.
In fact, there is another judgment also, same.
Yes. Subsequent judgment is also there.
It-
No,
it
that is
cannot-
not that. See, the object is that when you are trying for one issues, why can't you try for others and dispose of
It
those?
will save time.
That is what that.
But question of now senior counsel, my lord, not that I
Now,
have.
you are not arguing any case. Now that this is the issue where we said it should be it should try as only one issue. Now that Supreme Court said it cannot be one issue, try along with that other
Along
issue.
with the other issue. It is.
Then I will say that within 1 year from date of appearance, it has to be
Yes,
disposed.
my lord, yes, that.
Yes. Senate Council for the parties. The trial court is directed to frame Rectification as one of the additional issue. Try along with that other issues, for giving an opportunity to both the parties and dispose of the suit within 1 year from the date of appearance of the party. Yes.
That's serial number 3. This one on the
It's just waiting for a petition. As
Yes.
for postal track melody, showing like item is delivered to the LRs of the respondent number 1 million, but the cost is wrongly shown as no such person.
Yeah, relay.
For R1 million,
Hmm.
as per postal track melody, showing like item is delivered to the respondent number 1A million.
Hmm.
Yes, submit the copy. It's downloaded from the online website from High Court website only million. Second thing now 18/7 I have taken a process million.
Issue notice to the respondent R1. Local charge, no such charge.
ಎರಡು address ಇತ್ತು, ಎರಡು address ತಗೊಂಡಿದ್ದೀವಿ. We have taken for the 2 addresses million. ಒಂದು address ಗೆ ವಾಪಸ್ ಬಂದಿದೆ, ಇನ್ನೊಂದು address ಗೆ item is delivered.
Acknowledgement.
Acknowledgement ಆ postal tracker is.
It is not come back to that office.
Office to may
We'll wait for that. Yes,
office to verify that.
yes, avoid service of notice
Manchawai.
to respondent number
1A million.
1A. Yes.
Serial number 4. Sandhya, you remove petitioner.
Non-compliance of office objection, week's time is granted to do the needful.
Serial number 5. Vijay Kumar TN.
Petitioner number 1 already death ಆಗಿರೋ ಇದು ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Yes.
12/9 ಅವೇ ಡೆತ್ ರಿಪೋರ್ಟ್ ಅಂತ ತಂದಿದ್ದೀನಿ.
Memo to be treated petitioner
Petitioner
25
number 2 to
LR
5 already
deceased petitioner number 1. 2 to 5 ah?
2 to 5 2 ಇಂದ 2 ಇಂದ 5 wife
Who is dead now?
wife one is dead.
Yaro?
Parmashivamurthy.
Parashivamurthy is dead.
Yes.
Who are that LRs? Wife ah?
Wife, mothers, wife,
2
sons.
to 5. Yes.
3, 4, 5.
Yes, learned counsel for the petitioner has filed a memo stating that petitioner number 2 to 5 are the only LRs of deceased petitioner number 1. Petitioner number 2 to 5 may be treated as LRs of deceased petitioner number 1. Memo is taken on record. Petitioner number 2 to 5 are treated as LRs of deceased petitioner number 1. Learned counsel for the petitioner is permitted to amend the constitution.
Serial number 6. R Kumar for petitioner.
Yes, non-compliance.
Office has raised 2 objection.
Hmm.
One is in regarding extent of the schedule.
Hmm.
That respondent filed 2 suits. One is for declaration, another one is for partition.
Hmm.
In the declaration suit,
Hmm.
he has restricted his claim only for the 24 quintal. This is the certificate copy of the OS 800 of 2000.
871 of 2019. What is that suit scheduled property?
Is suit schedule property page number 37.
Hmm.
Only for 5 quintals.
Scheduled
Same
by
schedule.
1 acre 5 quintas. Hmm.
In declaration suit, it is restricted his claim only for 24 quintals.
24 quintas.
ಇದರಲ್ಲಿ ಅದನ್ನ ಮಾಡಿಲ್ಲ.
Petitioner, no, subsequently has amended.
Yes, amended.
That's you have not produced that amended. Therefore, office has
Raise that objection
Yes.
regarding extent of property.
you could have produced this amendment. Yes, learned counsel. What is that other office objection?
Other office objection regarding provisions regard. We filed a IA for 7 rule 11 D, mentioning the provision 11 A, B, C, A, B and D of section 151. In the order, we are trying to see page number 29 of the page.
The defendant is rejected.
Rejected,
Plain.
but mentioning the provision 7, 11 A and B.
D.
B is the reference. B and section 151 is the reference.
All 151 ildiದ್ರೆ ಏನಂತೆ?
ಅಲ್ಲ ಅದನ್ನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿ.
Why? 151 is not necessary for rejection of the plaint. Order 7 rule 11 is ಎಲ್ಲಿದೆ office objection?
Cover it maybe
Court fee.
P1 photo is APD.
Valuation per of petition to be stated correctly as per print copy of OS schedule to be stated correctly. ಅಷ್ಟೇ ಇದೆ sir, ಬೇರೆ ಒಂದು.
Court fee cutting. Court fee has to be
What we
paid.
put it is, what we put it.
Learned counsel for the petitioner submits that in respect of office objection number 1 regarding court fee, submits that court fee has been paid, office to verify. In respect of valuation, in respect valuation term of the petition to be stated correctly again. ಮಾಡಿದಿರಾ valuation
What we put ಮೇಲೆ ಸರಿಯಾಗಿ.
yes, in respect of 1 and 2.
In respect of extent is concerned, they are.
No, they have non-compliance of 1 and 2 only they are saying. Plain copy to be scheduled to be stated, other than office objection raised.
ಅದನ್ನ ಕೊಡ್ತೀನಿ sir.
Office objection 3 comes to commission. Yes, in respect of 1 and 2, office objection in respect of 1 and 2. Learned counsel for petitioner has submitted that it has been complied, office to verify and proceed further. In respect of office objection 3 is concerned, submission of learned counsel for the petitioner is accepted, office objection is overruled.
Yes.
Number 7, 8, serial number 9, minus and errors for the.
Yes,
Original pending consideration trial court, but trial ಅಂತ ಬರ್ದಿದ್ದೀವಿ. ತಿರ್ಗಾ ಅದು ಏನ್ ಹೇಳ್ಬೇಕು ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
non-compliance ನೋಡಿ.
Para 7 ನಲ್ಲಿ in page
Now we'll see what is that objection.
objection is
7, sir.
ಹೌದು,
993.
pending proceedings to be stated.
Serial number 9, minus the errors.
ಅಂದ್ರೆ I have to put this objection.
Pending proceedings to be stated. ಇದೇ ಒಂದು.
ಅದಕ್ಕೆ ನಾನು ಬರ್ದಿರುವಂತದ್ದು
Hmm.
suit is pending consideration before the trial court or trial ಅಂತ ಬರ್ದಿದ್ದೀನಿ. ಅದಕ್ಕಿಂತ
Yes.
ಇನ್ನೇನ್ ಬರೀಕಂತೆ.
Counsel, submission of learned counsel for the petitioner in respect of office objection is accepted. Office objection is overruled. Yes. It's matter for admission.
Serial number 10, CM Allotment for petitioner, D. Shivakumar.
Yes.
This matter regard, I am filing in the due course of the day, I file powers are R2 to 5.
Yes, madam. Waiting service of 2 to 5 will file and what? What is your name?
MN Munireddy.
MN Munireddy, undertake to file wakalat for R2 to 5 office. is
R3.
directed. R
3 to 5.
3 to 5 or 2 again?
2 is no more.
Yes, R3 to 5 office is directed to show his name. Learned counsel for the petitioner submits that respondent number 2 is dead. Press 2 weeks time to file necessary application to bring a loss. Order granted earlier is extended till next date of appeal.
Number 11, this order to be for petitioner.
Lord, though the impugned order first on 17/7/2023, but the same was signed on 18/7/2023. Office has raised the objection stating that, my lord, there is a discrepancy in the date. My lord. In page number 16, kindly turn it.
On arriving is a dependent number 1 to 4 to 6 as
ಅದೆಲ್ಲ ಬೇರೆ ಎಲ್ಲ compliance ಆಗಿದೆ.
submission of learned counsel for petitioner in respect of office objection is accepted. Office objection is overruled. Post this matter.
Kindly fix some date, my lord.
Yes, post this matter for admission Tuesday.
Serial number 12, complete case for petitioner.
Yes,
The last occasion, your lordships had remarked on the maintainability of the
Hmm.
CRP, my lords. In fact, I have submitted a case law of a coordinate bench of this honorable court, 1994 Karnataka 2353,
Hmm.
where it clearly says, my lords, against a decree passed in terms of section 6 of the specific relief act, civil revision petition in terms of section 115 CPC is maintainable.
now that what is that order you are challenging?
My lords will kindly see the judgment is at page number 33.
Hmm.
It is a judgment by a lessee, my lords, seeking for recovery of possession and damages.
Hmm.
The suit is partly allowed. The claim for damages is rejected and the recovery of possession is allowed, my lords.
Hmm.
Insofar as recovery of possession is concerned, my lords, my humble submission is this.
In the very
Suit of
first,
the plaintiff is hereby decreed in part, not accordingly, it is hereby directed to handed over the position of the suit should be property to the plaintiff within 30 days of the date of the suit of the plaintiff against the defendant for the damages against the defendant in respect of permanent injunction is dismissed. Yes, it is a decree.
decree. Now, even against this decree, a section 115 CPC revision is maintainable. I've just submitted the judgment on 26th. I have filed it, my lords. If your lordships may kindly take that judgment, there is a judgment filed along. If it's not there, I'll just pass on to lords.
Yes.
Just mark, this is my copy, I'm sorry, my lords. Paragraph 10 onwards, till paragraph 12, if your lordships kindly see.
Myself to agree with that contention of the what is that violation of section 6 of the Act?
My lords, in fact, there is absolutely no pleading either in the plaint, my lords, or in the arguments by the plaintiff's counsel regarding that the plaint is under section 6. The learned trial judge, my lords, considers that it is a plaint under section 6 and proceeds to make the pass the decree, my lords. If your lordships kindly sees, the relevant portion is at paragraph 18 of the impugned judgment in page 50, my lords, we kindly see.
Yes.
It just says herein on, looking to the pleadings of both the parties, the present suit filed by the plaintiff is under section 6 of the specific relief act. Kindly see the plaint, my lords. I have annexed the plaint at page 75. There is not a whisper, my lords, about this being a suit in terms of section 6. Also, my lords may kindly see, even in the pleadings of the plaintiff, which is captured, my lords, at paragraph numbers.
What is the relief he has got? Injunction directing the defendant to amend for.
I am not the plaintiff, my lords. It's the defendant's petition. The decree will operate as against me.
No, by reading that prior, it's look like it is under 6. Is it not?
My lords, it is a suit for recovery of possession and for damages. If your lordships kindly sees,
Where is that plaint?
the plaint is at annexure B at page 74 onwards, my lords. 75, sorry.
Yes.
75 onwards. And the prayer, if your lordships may kindly see, it is at page 80. In
What
page
is that
80.
facts of the case?
The facts of the case are this, my lords. The plaintiff entered into a lease deed with my father in the year 2016.
Yes.
In the year 2018, my lords, my father dies.
Yes.
Thereafter, he does not renew the sale lease deed. Subsequently, my lords, in May 2018, he says that he wants to start a different restaurant. It is leased out for the purpose of a restaurant. And he says, I want to lease it for a different restaurant, and he moves away. He hands over the key, everything to me. Now, in his admission, my lords, he clearly says that he has opened another restaurant. All the staff were moved out, and 1.5 months the restaurant was closed. It is there forthcoming from his very evidence, my lords. May I just demonstrate to your lordships? If your lordships kindly sees the evidence of PW1 at 108, my lords.
What is that? Have you produced that agreement?
My lords,
Agreement.
even in fact, he has not produced the agreement. It is not even marked, my lords. My lords may kindly see, it is not
What
even
is the
marked.
relief which is granted now?
It is directing us to restore possession, my lords.
Redelivery of
Hand over
possession
possession.
and the enjoyment of the termination of the lease immediately without any delay by cancelling that. The degree is
And if your lordship sees, the lease deed is not at all marked.
Accordingly, it is hereby directed defendant to hand over possession 30 days from the date. The receipt of the credit by
No, my lords, without even marking.
No,
the
why,
receipt.
why you can't file an appeal against this degree?
My lords, no appeal lies. In fact, the Honorable Supreme Court has recently held, my lords, under section 6, if it is a decree under section 6, no appeal lies. May I just pass on, this is a recent judgment of the Honorable Supreme Court, my lords. Under section 6, in the next page, your lordships may kindly see, I have
Yes.
marked it.
You need to remain.
Now, the suit is treated in terms of section 6.
Yes.
Whether or not there is a pleading to that effect, it is treated under section 6. I am now stopped from filing an appeal. Therefore, I am before your lordships in this.
Office objection regarding maintainability is kept open. Yes, issue notice.
And I have sought for a stay, my lord, since
Why?
because he will seek for recovery of possession and I had to deliver possession within 30
They have
days.
not filed any execution.
I believe they are in the process of filing, my lords, and they have filed, but we haven't received the notices what I have been instructed.
Now, where is that complaint?
The plaint, my lords, will kindly see at page 75. Annexure B.
Yeah, then you maintain status quo with respect of suit scheduled property.
I will maintain status quo, my lords. It is already, even in the judgment, it is seen that I have already leased it to another third party.
Parties are directed to maintain status quo in respect of suit scheduled property till next date of appeal.
I'm grateful.
Yes.
Number 13, petitioner of petitioner Satish Kumar.
Notice that the.
Issue of court notice in respect of R1 and R2.
I am appearing for the respondent number 1, my lord.
My friend has also appeared last time.
Hmm.
That may be dispensed with.
Matter has been posted on the website.
Just be heard now.
In interest of- You are taking notice.
Mr.
Sir, you are appear ಆಗ್ತಾ ಇದ್ದಾರೆ.
I am appearing for the respondent number 1. Last title ಕೂಡ appear ಆಗಿದೆ.
ಪಕ್ಕಲ ತಾಕಿದ್ದೀರಾ?
Already on record.
Yes. Satish Kumar. Take appear for respondent number 1 and 2. Office is directed to show his name.
It is already.
Already shown.
ಎಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ? ಎಷ್ಟು
ಇದೆ,
serious?
ಇದೆ. Contest ಅಲ್ಲಿ ಇದೆ.
13.
Please.
No, he has been shown as a caveator. Now he has accepting that notice. Caveator is different and yes. He is accepting notice for 1 and 2. Office is directed to show his name. Is this matter for hearing? It's already.
ನಾಳೆ
Not, I don't think.
That is.
from last 9 years it is pending.
Let us see.
Any date my lord next week.
For this matter for hearing on 12th.
Please.
Yes.
Just after 25th or 20th.
ನೋಡೋಣ if it is possible on that day. Otherwise,
Second out time close to ಗೊತ್ತಿದೆ. 25 or 26 ಹಾಕೊಂಡಿದ್ದಾರೆ.
25th reopening.
25th reopening day ಇದೆ.
Reopening ಬೇಡ 26th.
ಅಲ್ಲ.
At least ಅದನ್ನ
See, it was last time he said he is ready to argue the matter today. It was understood that it was to be heard. Again, ಆರ್ಡರ್ ಪೋಸ್ಟ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಇವಾಗ
26th. 26th.
ಇವತ್ತೇ ಆರ್ಗ್ಯುಮೆಂಟ್
26th.
26th list. Yes. Is this matter for hearing on 26th.
Serial number 14, D. Siddhartha, petitioner.
Office note says the suit is valued more than 15 lakhs. And suppose this matter before the division bench having in a roster.
Serial number 50, Siddhartha Rajesh, complaint.
Yes, non-compliance, Mr.
Complaint with officer objections twice.
What is the cause of objection? Value of the appeal to be correctly stated. Necessary requisite court fee should be made. Value has to be correctly
I
stated.
have stated correctly. 2023, minute I have not filed a detailed valuation thing.
Extent of acquired so and so. Market value claim above appeal is 8,000. Solacium ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
ಇದು page number 13 ಅಲ್ಲಿ.
Hmm.
Detailed valuation is made. Valuation additional market value.
Permission to that. As possible, let us see, we'll verify why the talk is possible to that.
Number 16, before that, serial number 17, Vansa wasn't be clear for appellant.
Yes. Appears 2 weeks time is granted to comply the top subjection.
Serial number 18, Ashok Kumar Gowda.
The appeal for the appellant, my lord. The correct name of the appellant number 4 is my lord, July, my lord. The respondent by filing the suit wrongly stated as Amaya. For that, use the documents, my lord, along with the memo.
Name of the appellant number 4 to be stated correctly.
Yes, my lord. Last date, my lord says asked me to produce the ID cards, my lord, along with
Respondent number 4
appellant number 4, my lord.
Manjula.
Manjula,
ಇದ್ರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಂತ ಇದೆ?
Amaya ಅಂತ ಇದೆ.
ಎಲ್ಲಿದೆ? ಅಯ್ಯ.
My lord, annexure B, page number 29, my lord.
ಯಾಕೆ ಅಮಯ್ಯ ಅಂತಾರೆ?
Pet name Amaya ಅಂತ ಇತ್ತು, so
When you are appear before the trial court, should you not ask for any this thing?
I insisted,
Correction of
my
that.
lord, I insisted they have filed the memo, my lord.
Yes, appudi.
ID cards have produced, my lord, along with memo on 2/2/2020. The mass card, it's a daughter of Nanjundappa.
ಎಲ್ಲಿದೆ?
Document, page number 3, my lord. Next document.
Why you have made as a daughter when she has married?
My lord, the cost title, the plaintiff while filing the suit is stated like that, my lord.
Now you could have stated that she is a wife of so-and-so.
But here the office will not accept we change the cost
Yes.
title, my lord.
Submission of motion for the appellant in respect of office objection is accepted. Office objection is overruled. Yes, post this matter for admission.
Serial number 19, case Karnataka for appellant, connected matter, counsel CTA.
My lord, next week, date may
Next week, yes.
Appeal, my lord. Arised out of one OSP. Both application filed by my lord is one by the plaintiff, one by the defendant. My application, that is my lord in MFA, his application in RFA, that is the defendant application. I filed my lord under order 39 rule 1 and 2 with respect to the my lord deposit the my lord 50 the whatever the rent amount before the learned trial court, it came to be allowed. This application is my lord order 6 rule 70 order 7 rule 11 A for rejection of plaintiff. Accordingly, his application came to be rejected. Now, my lord, being accrued by the order of the my lord learned trial court, he came in both appeal, my lord.
Yes.
My lord, my humble submission before this honorable court.
No, he is not there.
He is not there, but my lord, he obtained the initial my lord interim order. Subsequently, my lord referred to the my lord mediator, that is learned advocate of the bar. It has his name as shown in the my lord cause list. Accordingly, my lord, we went in the during the time of the my lord vacation. However, my lord, fruitful result not as came up.
No,
That-
now that interim order is operating against you.
Yes, my lord.
Where is that order?
Begin in the initially, my lord, this interim order has been granted by this honorable court, my lord.
Wait.
My lord, appearing on behalf of the appellant, my lords.
Yes.
My lords, in
Very
the
short
cause
point
list,
is involved, my lord, with respect to
Where is that interim order?
interim order. Yes.
my
It
lords,
is in CRP, my lord. In CRP, there is an interim order, not in MFA.
yes, my lords, on behalf of the respondent, my lords, in the cause list today, my lords, it states that no, the office note mentions that we have
No, we are searching for the appellant, not respondent.
appellant, my
You are
lords. I
also
am for
appearing
the
for the
appellant, my
respondent.
lords. I am appearing on behalf of the appellant only, my lords.
He is the appellant. I am for the respondent.
No, one more, yes. What you say, Mr. Brijesh
My
Kalapa?
lords, my lords, in the cause list, my lords, it shows that the respondent number 2 to 22 have not been arrayed. My lords,
My lord, they are
with
all
regard
formal
to that-
parties, my lord. They don't have any business. They have, my lord, tenants.
Yes, my lords.
They don't have any role, my lord, to play before this honorable court. It is
Yes,
a
my
husband
lords.
and a wife dispute before the learned trial court with respect to the, my lord, declaration. The declaring that the scheduled property of the suit, my lord, it is a joint family
What
property.
is the interim order passed by that?
And also it states to await
Please.
for the mediation report, my lords, if I may kindly be permitted to submit that, we know that nowhere it is inconsistent, even in my records, that respondent number 2 to
Yeah.
22 has to be arrayed. One thing is that, my lords, and the waiting of mediation report, it says, my lords. Kindly have the matter posted after vacation, my lords, for hearing only, my
My
lords.
lord, I and my client went.
No, that's, see, you file an application for vacating interim order. It has been
My lord,
admitted by that.
my lord, my humble submission before this honorable court is that initially,
And-
my lord, they advocate, they engaged one advocate. When it is mediation, my lord, some dispute has happened, my lord, accordingly, that wife has changed the advocate, that is defendant has changed the advocate. Now, my lord, new advocate has came. He has not came before the mediator. Now he is saying, my lord, I am.
Now that all mediation is over.
Yes, my lord.
This matter has been admitted.
Yes, my lord.
Now that either I have to post it for hearing, for final hearing, or if you want that vacating, you have to file an
My
application.
lord, last date of hearing, my lord, he has
Kindly
asked the time
post
before
the
this
matter
honorable
for
court to
hearing, my
file a
lords.
NOC
And
wakala.
kindly extend
Accordingly,
the
this
interim
honorable.
order, my lords.
No, that is different. Now you forget about him.
Yes, my lord.
Now, if you want to vacate that interim order, you have to file an application
Yes, my lord.
because it is matter is admitted. After hearing, it is admitted. Either it has to be posted for hearing for a final hearing, or if there is any urgency, it is affected your rights, you have to file an application for vacating.
May I make one submission, my lord?
Yes.
Last date of a hearing, this honorable court not extend the interim order. Because this honorable court refused because, my lord, he was not ready to argue when it was come for the final.
It is an absolute interim order has been granted.
That is in MFA then. Because
No,
both
it-
as connected, that is the
My
biggest
lords,
problem.
kindly extend the
It is
interim
in the
order. One thing.
CRC.
that, my lords.
Yes, my lord.
See, there is an order passed by this court, learned counsel for the petitioner submitted that so and so. 1.5 page order has been recorded. Judgment of the other high courts has been referred, then heard, admit, further proceedings in so and so is stayed.
Then, my lord, I kindly have it on Tuesday, my lord, I will.
File an application,
Tuesday, kindly have it Tuesday.
file it and move it.
My lords, kindly post the
In the
matter for
meantime, I will
hearing,
do
my
my work,
lords.
my lord.
You file that application and move it, Mr. Before
Please.
that, don't ask that.
Please, yes.
Yes.
Number 20, Prakash Ambedkar leave for appellant.
My lord, I appear for appellant in this case, my lord. There is small two objections, my lord. I will complain now itself, my lord.
Pass
Since
out. Pass out, pass
the
out.
execution.
You complete first.
Yes.
Yes.
Stability. Yes, pass on.
Number 22, Prakash Ambedkar leave.
My lord, this is regarding the nomenclature of the appeal, my lord, as commercial appeal, my lord, wherein but the order is passed by the district court, my lord, which was conferred the power of commercial court also, my lord. But the dispute is
Commercial appeal, this is.
no, this is the dispute land acquisition matter, my lord. This is not the commercial dispute as.
No, but number has been given as a
My
commercial
lord,
appeal.
what happened, my lord, after the Commercial Courts Act came into force, my lord, the district courts which were functioning are conferred the powers of commercial court also, my lord.
No, they, wherever that appeal is there, they will classify it as an appeal. If it
But
is,
we made so many efforts, my lord, but in spite of that, they classified, once the classification is done, they are not.
because if once it is in a commercial appeal classified, it has to go before that commercial court only.
My lord, section.
And I have no jurisdiction.
My lord, under section 34 of the Arbitration Cancellation Act, I have filed suit. Now the appeal lies under section 37 of the Arbitration and Cancellation Act, my lord. But if I am going to invoke the section 13 of the Commercial Court Act, I have no cause of action and the subject matter does not involve the commercial dispute, my lords. Wherein the subject matter involved is the land acquisition matter, whereas it is not
No, why you have not asked that to classify properly there?
My lord, we made a in the open court, we have made a submission, my lord. Some of the courts have accepted and some of the courts have refused to accept because saying that this is a national highways matter and it is a commercial in nature, they are saying, my lord. In that regard, the classification was done, my lord, that was
No,
not.
that in respect of that similar matters filed by you, it has been disposed of with liberty to approach that commercial court.
ಅಲ್ಲ ಒಂದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಲ್ಲಿ
Other
ಕಮರ್ಷಿಯಲ್
benches has passed an order. Following that, I think I have also passed some order.
otherwise
What has
the
happened to that,
registry may be directed to convert this appeal as a commercial appeal. Why I am making this submission?
ಅದೇನದು ಬಾಕಿದ್ ಮ್ಯಾಟರ್ಗಳಲ್ಲ.
ಬಾಕಿ ಕೆಲವು ಒಂದು ಕಮರ್ಷಿಯಲ್ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ ಕೆಲವು ಹಾಗೆ ಅಪೀಲ್ ಆಗಿ ಇದಾಗಿ MFA ಆಗೇನಿದೆ ಕೆಲವು ಮಾತ್ರ ಕಮರ್ಷಿಯಲ್ ಅಪೀಲ್ ಆಗಿ ಇದಾಗಿ
Miscellaneous first appeal. ನೋಡಿ, in view of that circular dated court, miscellaneous first appeal is not maintainable. Appellant is required to file.
ಅದು ತಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿದೆ ಸುಮ್ಮನೆ ಒಂದು
ಅಲ್ಲ ಇದು ಜಸ್ಟಿಸ್ ರವಿ ಹೊಸ್ಮನಿ ಅವ್ರ ಮುಂದೆ ನಿಮ್ದು ಆಗಿತ್ತಲ್ಲ, ಏನ್ ಮಾಡಿದ್ರಿ ಅವ್ರನ್ನ?
ಅದು ಮತ್ತೆ ಕಮರ್ಷಿಯಲ್ ಅಪೀಲ್ ಅಂತ ಹೇಳಿ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಅಲ್ಲೇ ಇದು ಅದ್ರಲ್ಲೇ ಮತ್ತೆ ಹೊಸದಾಗಿ ಫೈಲ್ ಮಾಡಿಲ್ಲ. ರಿಜಿಸ್ಟ್ರಿ ಹ್ಯಾಸ್ been directed to convert the same as commercial appeal and we have complied.
Yes. So we have done the miscellaneous appeal. Yes, I will permit you to convert.
But the execution case is pending,
No, that has to go before the same court.
In identical matters, in this your lordship has
No,
granted.
that is not that commercial classification. That is what that there is a judgment order passed in your own cases by this court.
My lord, what happened, my lord, is if that provision is invoked, my lord, my hands are tied because I have to file.
Let the commercial see, because that commercial court act says
Appeal has to be filed in within.
not only that, a chief justice has to constitute the judge who has expert in that field, who has alone has to hear. Therefore, tomorrow it should not be hurdles because it has been constituted for particular judge. Then it has to go before.
My lord, what happened, my lord? I myself went to the several district courts and.
No, I have also verified from the office, especially in Davangere. This is
not only in Davangere, in all districts.
Also, I think Mangalore also there.
Yes, my lord, Mangalore, Chamarajanagar, in all the districts they are making because they were saying that there is an order by the Honorable High Court.
Yes. In similar matter, this court in miscellaneous appeal number 8412 of 2022 on 14 December 2022 as is that appeal liberty to file a commercial appeal. In view of the above, the appellant is permitted to convert this as a commercial appeal. Instead of filing that, I will committed commercial appeal. Yes.
Till then, the
post before, after conversion, post before the appropriate.
Kindly fix the date, my lords. Kindly have it.
No. You have to move before that court, Mister. I can't fix their this thing. Yes. Convert this as a commercial appeal. You convert it and move before that court. Yes. Instead of filing, withdrawing and filing and all.
Yes.
For the statistic purpose, the appeal is disposed.
Respondent number 1 in this case.
Appellant, my lords.
Yes.
My lords, I had filed a memo, my lords. The memo has not been put up. I think a similar memo to dispense of it from respondents 2 to 11, my lords.
Why non-compliance of office objection? What is that office objection?
My lords, office objection is that respondent number 3 and respondent number 9 as dead, my lords.
No, whether the documents produced along with the appeal memo are filed before the trial court. As verified from the order sheet, OS number so and so, there is an order of IA, but same is not forthcoming in that impugn order. Defendant number 3 from the plaintiff of constituted is stated to be dead. The impugn order differs from that order. There are 4 office objections. So not seeing that.
Yes. I'll complete.
Yes. Week's time is granted to complete the constitution. Yes, Mr.
Case your lordship again say,
Hmm.
that is the section regarding a jurisdiction. Your lordship can at least see section 19 of the Karnataka Civil Codes Act.
Hmm.
That about 10 lakhs,
Hmm.
does not exceed 10 lakhs, that the district court. Here your lordship can see exactly 10 lakhs shown in the valuation slip.
Now, what is that value?
Valuation, valuation shown in the valuation slip is 10 lakhs.
Hmm.
But your lordship say they have challenged this sale deed. That is sale deed is for 13 lakhs.
So 10 lakhs you have filed before that
District,
senior civil judge.
no,
No, that
district
is
judge,
huh?
senior civil, judge,
Senior civil judge.
yes. Now your lordship can see the suit is for declaration and injunction.
Then appeal is lies to that district court.
No, what happened in this case? That the suit value is 13 lakhs and that is not for declaration. Declaring that the power of attorney as well as the sale deed is not binding on him. Sale deed is for 13 lakhs. The value is not shown properly.
No, have you taken that contention in the written statement?
Yes,
Where is that?
even if a lordship will say, I'm reducing the sale deed and.
No. See, unless you have taken that contention, that court will not frame that issue. Otherwise, that your suit is trying by that civil judge junior division. Appeal is before the high court. In between that district courts, there is no that is the provision. Appeal has to go that unless you've taken. See, suppose if you have taken that contention. his
No,
appeal
the
will be
suit is filed before the senior civil judge, JMFC.
Senior civil judge. Next appeal lies to the district court.
Yes. If it is 10 lakhs, district court.
No, see, he has mentioned it is
Yes, 10 lakhs only.
10 lakhs. Then appeal has to go to the district court.
The value is mentioned as that. is 10
No,
lakhs.
you can't, defendant cannot take that, changing that value to file and.
Because he challenged this sale deed.
No, that
The
is what
suit
that,
itself has challenged the sale deed.
see,
The sale deed value is 13 lakhs.
no, that you have to take in a contention before the senior civil judge. Suit is not properly valued. This court has no jurisdiction. Then that will be dismissed. If you are, suppose you are contesting the case in the senior civil judge senior division. You are filing an appeal before the high court. Law said there is an appeal before the district court.
Correct.
Yes. If it is an appeal before the district court, you can come before this court. That's what that office raised an objection. You have approached that district court filing an appeal.
No problem for approach because 13 lakhs is shown because of that reason high court will come.
That you have to take in a contention before the senior civil judge. This court has no pecuniary jurisdiction. At present,
Just taken a convention. That they have paid the required court fee as per the separate valuation slip next to the time. These are all the false, incorrect and baseless statement of the plaintiff. The plaintiff must take proof of this. But he has not stated that the value of the property mentioned in the sale deed is 13 lakhs. That was not mentioned.
yes, permitted to file an- yes. The counsel for appellant has filed a memo. It's liberty to withdraw this appeal with seeking an leave of this court to withdraw this appeal with liberty to approach appropriate legal forum. The memo is taken on record. The above appeal is dismissed as withdrawn with liberty to approach appropriate legal.
Number 25, N. Kumar for appellate.
Yes.
Millard. The arbitration is Millard. Production of the valuation is Millard. The order impute is Millard. The allowing the order 39-102 application filed by the plaintiff Millard. Here the production of the valuation doesn't arise Millard.
ಯಾಕೆಂದ್ರೆ appeal ಇದೆ. This is by the senior civil judge.
I have there's no part. I have a valuation slip Millard.
Produce ಮಾಡಿ ನಾವು find out ಮಾಡಕ್ಕೆ whether
I fail Millard. There's no part. 50 ಲಕ್ಷದ ಮೇಲಿದೆ. Before the
produce ಮಾಡಿದ್ರೆ ಆಯ್ತು office will not raise an objection.
The urgency is Millard. The
Why
appellate.
you have not produced? We are all filing in a regular appeals every day. That is that rule. You have to
Yes,
see
Millard.
the
I do
purpose
agree.
is if it is less than 50 lakhs, your appeal lies to that district court.
So my
You
case
can't
is-
come to this
is
here.
More than 50 lakhs, man.
That you have to say before that. Yes.
Millard, you have the urgency,
You
Millard.
comply. We will have it on Tuesday. Yes. 2 days time is 2 days time is granted to comply that office objection.
Number 26, secondary declaration.
Tuesday, Millard.
Yes. You move that matter after complying that, will take next day itself. Yes.
For the appellant,
Is it restricted?
not the office objection raised with regard to defendant number 4 before the trial court, who is an insane person, is not being made party here. My lord, my humble submission is, my lord, he is an insane person.
Correctly. There are other office objections also.
My lord, I'll comply within the, in the due course of the day. There is an urgency in the matter.
Not due course of that, you have to serve a copy to that cave.
I will serve a copy to them as well, my lord.
Then,
My lord, the thing is this one, I have filed the appeal. After 1 week of filing this appeal, they have filed the caveat.
ಆಯ್ತು ಕೇವೇಟರಿ ಕಾಪಿ ಕೊಡಕ್ಕೇನಪ್ಪ?
According to me, I will give it to the,
Yes.
I will give it to them.
Yes.
May I request the matter to be listed on Tuesday, my lord? There is an urgency in the matter.
2 days time is granted to comply with office objection. Leave this matter on Tuesday. Yes.
Number 27, addition to the pleading for appellant. Sir, Ravi Prakash.
Yes. Memo for retirement filed by the council for the respondent number 1.
Already filed.
Yes.
Why is is retiring?
Yes, now that
Find the.
Ravi, you have filed an wakala. Who is appearing for that appellant? Yes. Office is directed to delete the name of O. Shivram but for R1 and continue to show the name of R. Ravi Prakash.
Yes, sir.
Yes, sir, Ravi Prakash.
On submission,
Yes.
the rank of the party is not shown before my name. Who might be very.
Yes, R1. Delete the name of Ravi Shivram but for R1 and show the name of S. R. Ravi Prakash for respondent number 1.
Number 58, Ravi Prakash.
ಮಿಲಡ್ 28 to 31 ಮಿಲಡ್ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಬೇಕಿಲ್ಲಿ ಅವರು ಕೂರಿದ್ದಾರೆ ಮಿಲಡ್ ಕೈಂಡ್ಲಿ ಗ್ರಾಂಟ್ 3 weeks ಟೈಮ್ ಮಿಲಡ್.
Yes, 3 weeks time is granted.
31 up to 31 ಮಿಲಡ್.
ಎಲ್ಲ ವಸ್ತುಗಳು, yes.
Oblige.
Yes.
32 attempts, number 33, Mandula T for appellant.
Yes.
Number 33,
Vijulati, weeks time is granted to comply the constitution.
number 34, Barbara JC.
For 2 weeks time.
2 weeks time is granted to comply the constitution.
Number 35, Madhu SP.
Non-compliance of subjection, 2 weeks time is granted to comply the constitution.
Number 36, Ajay Dubian.
There are 2 objections. One is regarding court fee, which I have paid online. Another is regarding provision to be mentioned in the IA. I will complete today's.
Yes, password.
Matter. Number 37, Secretary for appellant, corrected matter.
Respondent number 10 days. They have taken a steps against the respondent number 4 minutes.
Bringing a loss of deceased R1.
This one.
Yes, notice ಹೋಗಿದ್ಯಾ? ಇಲ್ಲ.
Yes, sir.
Are you taking notice for LRs?
I informed to them. If they are engaged me to.
No, that. Then I will issue notice.
This one.
Yes, issue notice on IA 1 of 2023.
The 3 matters are one and the same.
Yes, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅಷ್ಟೇ. IA 1 of 2023. IA 1 of 23, yes.
Number 20, 38, Raymond Malaya. Rupesh Abi.
Yes. Yes,
What is filing the.
yes, we'll condone the delay. What is this matter, Mr.
2017,
in
order of injunction is operating against.
Grant PI came to be confirmed against which I have filed an appeal.
No, the suit for
Permanent injunction.
For injunction.
you are in a defendant. Now that what is that?
Restriction ಇದೆ.
Alla, what is that interim injunction passed by the court?
I mean, not to restrain the defendant from interfering with my possession.
No,
Restriction is there,
Now, what is the stage of the suit now?
evidence ಆಗಿದೆ, ಅವ್ರು ಕ್ರಾಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
I will direct the suit to be disposed of. Now, already interim order there from last
17.
The lordship may. I have cross examine, your lordship will fix up some time.
Yes, within 6 months, let them dispose of.
8 months ಅಂತ ಇಲ್ಲಿ.
6 months after, it's only injunction suit.
Injunction suit ಆದ್ರೆ ಏನಾಗಿದೆ, ಸೊಸೈಟಿಯಿಂದ ನಮ್ಗೆ ಮೊದಲು ಸೇಲ್ ಆಗಿದೆ. ಅದನ್ನ ಅವರೆಲ್ಲ ಸೇರ್ಕೊಂಡು ಚಾಲೆಂಜ್
confirmation evidence, yes, tell it. There is a delay of 249 days in filing an appeal. IA 1 of 2023 is filed for condonation of delay. There is that affidavit for the reason stated in that accompanying affidavit. Delay of 249 days in filing an appeal is condoned, even though matter is posted for orders at the consent of the parties. Matter has been heard finally and disposed of. This appeal is filed by defendant challenging order dated 12 January 2022, passed by 25th Additional City Civil and Session Judge, Bangalore, in OS number 6283 of 2017, whereby IA filed by the plaintiff under order 39 rule 1 and 2 has been allowed. For convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed a suit for their injunction. Along with that client, he has filed IA number 1 under order 39 rule 1 and 2 for temporary injunction, restraining the defendant from interfering with the plaintiff peaceful possession and enjoyment of the suit scheduled property. After service of summons, defendant appear through their counsel has filed a written statement. After hearing the parties, trial court by order dated 12th January 2022 allowed that IA number 1 filed by the plaintiff, restrain the defendant, agent, servants, or any other person claiming under him from interfering with the plaintiff peaceful possession and enjoyment of the suit scheduled property.
Confirm in the temporary.
Yes, yes, being agreed by the same. The defendant has filed this appeal. Now, the matter is set down for evidence of the parties. The order passed by the trial court dated 12th January 2022, confirming that temporary injunction order granted, then order dated 12th January 2022 is operating till today. In these circumstances, the only relief can be granted that the trial court may be directed to dispose of the suit as expeditiously as possible. Accordingly, the appeal is dismissed. Order dated 12th January 2022 is confirmed. The trial court is directed to dispose of that appeal as expeditiously as possible, not later than 6 months from date of receipt of copy of this order. Both the parties are directed to cooperate for early disposal.
Contentions that have come up. Kept open.
All the contentions of the parties are left. Yes. Applications are disposed of.
Number 38, Revolution Open Applied, Sheila.
Yes,
This is plaintiff's first appeal.
yes, IA 1 of 2023 is dismissed as not pressed.
Delay itu ಅಂತ ಹಾಕಿದ್ವಿ ಅದೇ
Now
delay
it's-
ಇಲ್ಲ ಅಂತ
Yes.
Your lordship may kindly take page 58 minutes. The suit was filed for partition and other reliefs.
Yes, 58,
58.
yes.
Your lordship will get the plaint. Application for injunction has been rejected as against that we are before your. Your lordship may kindly see minutes, page 58, your lordship will get the memorandum of plaint.
8 is written statement. Ajay.
Your number the page edition or the ಸ್ವಲ್ಪ ತಪ್ಪಿರ್ಬೋದು. Otherwise, melons the
No, your suit for partition.
suit for part. Setting aside various deeds are asked melons.
Yes. Now, what is that injunction you have sought?
Sought is not to alienate ಅಂತ ಕೇಳಿದ್ವಿ. Problem here is melons. The one ಇದು plaint ತಾವು ತಗೊಂಡ್ರೆ 1 ನಿಮಿಷ genealogical tree ನಮ್ಗೆ ಸಿಗ್ತಾ ಇತ್ತು. Plaint ಅದರಲ್ಲಿ.
No, not to alienate. Who is objecting that? Purchaser.
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ class 2 case now. One Chikka Chandigappa and Irama are father and mother. They had 3 sons and 3 daughters.
Yes.
There was a partition during the lifetime of father itself. A, B, C, D, E schedule anta madkondo. One schedule, that is E schedule, might fall into the share of Shivanna annavage.
Yes.
That Shivanna died in 2019. 2019 allo sutthogiದ್ರೆ
Yes.
class 1 case was Thai ಆಗ್ತಾ ಇತ್ತು.
Yes.
Thai had predeceased him in 2011 itself.
Yes.
ತಂದೆನೂ 2011 ಅಲ್ಲಿ ಸತ್ತೋಗಿದ್ರು. So the question of those people coming as class 1 case will not arise.
Yes.
He had a wife who had divorced. So the wife will also be not there. No children. That Shivanna's property had to be
Share among them.
among other siblings.
Yes.
ಇನ್ನು 6 ಜನ ಮಕ್ಕಳಲ್ಲಿ ಶಿವಣ್ಣ ಸತ್ತೋದ್ರೆ 5 ಮಕ್ಕಳಿಗೆ ಈಕ್ವಲ್ ಬರ್ಬೇಕು. D1 ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ನನಗೆ ಆತ ಗಿಫ್ಟ್ ಡೀಡ್ಸ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಸದರಲ್ಲೂ. ಆಮೇಲೆ ಅವ್ರು ಬದುಕಿದ್ದಾಗೂ ಸದರಲ್ಲಿ ಗಿಫ್ಟ್
That is the subject matter has to be decided by that. Don't alienate. If you alienate that, it will create.
D1 ಸನ್ಗೆ ಆತ ಇದನ್ನು ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನೋ ಒಂದು ನಾಮಿನಿ ಮಾಡಿದಾರಂತೆ. Nominee is only a receiving hand.
It is for the trial court to decide after trial.
ಇವರು
Now that should not, suppose if you alienate, then it will create third party interest.
ಫುಲ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇವರು. ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, let it do.
During lifetime of Shivanna, alienated the item number 1 of the item in favor of respondent number 6 and 7. They have claimed the interim order against, they have taken the contention, he is a mental illness. The first time, the appellants filed a various suit. They not kindly see that during the lifetime father of the.
No, I am not deciding
Not decided.
whether that gift is proper, whether it is
The
valid
first
or
time, my
not.
lord, even this day, during the lifetime of Shivanna, not taken the contention is the mental illness. During the lifetime of Shivanna, leaving along with the first defendant.
Yes.
During like, you don't kindly see the first time, the appellant not disputed the entire land was acquired by the Bangalore Development Authority for formation of Kempegowda layer. At that time, Shivanna filed a representation before the BDA. The BDA allotted a site in his name. During his lifetime, he executed the sale deeds and gifted in his brother.
Yes.
The first defendant, plaintiff not disputed even this day or the time of filing institution of the suit. First time he have filed a suit after death of Shivanna. During Shivanna is mental illness. First defendant forcefully executed a registered gift deed, taken the contention. During his lifetime, Shivanna executed a registered gift deed in favor of the first defendant in some of the properties, and some of the properties alienated in purchaser of the 6th and 7th defendant.
Yes.
The plaintiff are claiming the relief against the first defendant and defendant number 6 and 7. 6 and 7 is the Bonafide purchaser. They have invested huge hard money. And also the first defendant, the Shivanna executed a gift deed at time of gift.
No, see, what is your plan to do in that property? Are you want to construct or you want to alienate? No, if you want to construct, if you have any plan, everything, I will not prohibit for construction, but not to create third party interest because it is multiplicity of the proceedings. Construction, you go ahead because you have a purchaser. It has to be decided whether that gift is proper or not. But alienation is concerned, till that dispute has to be decided.
The appellant is no right title interest over.
But he will decide that.
Don't kindly see the.
I can't decide now. If I say that, then the suit is.
ಆಲ್ರೆಡಿ ಮಾಡ್ತಿದ್ದಾರೆ ಅವರೆಲ್ಲ.
Don't kindly record. If both the family members entered a partition, even this day defender respond number 6 is not served, 7 is not served the summons. Notice issued by the summons. He is the one of the purchaser. And also don't kindly even this day, the appellant not challenged the registered partition dated 23/10/2010. After lapse of 19 years, not disputed the mental illness of the first DC Shivanna.
Yes.
And the wife of the Shivanna filed a suit against deceased Shivanna before the family court.
Yes.
She has not taken the contention is the mental illness.
Yes.
And also, you know, the appellants filed a various suit before the revenue authorities have produced the documents. You are kindly see the first defendant appellant has no right to produce the documents. But a very suit itself is not maintainable. You are kindly see it.
No, you file an application for rejection of the claim if it is not.
You are going to file the objection. The trial court allow the dismiss the application and merits. Okay, various documents, not the first suit. First time filed a suit against the.
No, you are appearing for whom?
I appear for the respond number 1 and 6, my lord.
1 and 6.
1 and 6. One is the brother of the appellant and another one 6 is the purchaser of the site.
30 gift deeds.
Really first to
That
that
you have your suit is for the 2019
19th suit your up.
injunction, temporary injunction. That till the disposal of that application, is there any order in your favor?
There was no order.
Already matter is set down for cross of TW1.
Export injunction order.
You can direct them to dispose of the suit early, but before that, don't create any third party interest. You do whatever you want. You
Already Sivanna doing straight
whatever it is created, it is already there. But it should not be created from today onwards. That is what that. We are not saying that restoring that already the sale deed has been executed. You don't create one more sale deed from today.
And other properties, my lords, where
Any
Is- is
interim
the
order is
purchaser.
passed from only prospective from today onwards.
is
If it is already alienated, it's good.
Kindly see the documents produced by the respondent. Page number one, kindly first page number 1, dated 23/10/2000. The case of the appellant before the trial court, only ground taken the mental illness, but the father and mother executed a partition, did not taken the contention. The BC1 is the mental illness. During
Granting any temporary injunction, we can't decide all these things. Only thing is that as on the date of filing the suit, whether they are in the possession or not. If you are in the possession, if they are not in the possession, if you are creating any third party interest also, that can be.
not for permanent injunction suit. During kindly see the Bangalore Development Authority executed stated in favor of the BC1. The documents kindly see the page number. Number 48, my lord.
Yes.
Serial number 7. Chandigappa, Challagatta village, 19 but ನಾಡಪುರ ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಯ ಚಂದ್ರಘಟ್ಟ ಭೂ ಮಾಲೀಕರುಗಳಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿರುವ ವಿವಿಧ ಅಳತೆಯ ನಿವೇಶನಗಳ ಖಚಿತ ಅಳತೆ ವಹಿಗಳು ಸಲ್ಲಿಸುವ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಬಿ ಚೆನ್ನಪ್ಪ ಶಿವಣ್ಣ ಅವರಿಗೆ ಸೈಟ್ ನಂಬರ್ 3251 3258 3259 kindly the same appellant also received the entire compensation amount.
Let him
Same.
satisfy himself that yes.
Same appellant has received the compensation amount and alienated the third parties. Only the extent of the BC1, the BDA allotted the site during the lifetime of appellant not to take care of the BC1. The first respondent is take care during his lifetime. During love and affection, the deceased BC1 executed a registered gift deed in favor of the first respondent. Kindly see the next.
See, that is now it is disputed. Suppose if they prove that gift deed is not valid, then they are entitled for the same. If you are alienated, then it will create third party interest. That is what that they are saying.
Kindly see, well, one submission.
Yes.
19 years, not disputed during his lifetime of Sivanna, enjoying all the whatever share allotted to him, not disputed. After death of Sivanna, he has taken the contention. Only ground is mental illness. Kindly during his lifetime, entire responsibility of Sivanna is taken the first respondent. Hence, love and affection, he executed a registered gift deed. The Sivanna
take notice to others.
Others
parties are maintain status quo till next date of hearing. Issue notice. You are taking notice to whom?
Nominee, can nominee receive
No,
the
that you
entire
are appearing for whom?
respond number 1 and 6.
Yes, so and so, Kivator undertake to respondent number 1 and 6. Issue emergent notice to other respondents. Parties are directed to maintain status quo till next date of hearing.
Party, for appellant, SBR Mohan.
Yes. Defendants appealing a suit for injunction filed by the plaintiffs.
Before his submission, before yesterday, sort of the advocates who appeared on the lawyer.
Yes.
Tuesday or not?
Tuesday.
No, they are not even on caveat. Out of courtesy, my clerk went and served them. Now they are coming and asking for time.
No, which is that serial number?
Serial number 40. They are not on caveat.
Who is the J.R. Mohan?
J.R. Mohan is on that record.
His name is shown. Why?
Correct. Out of courtesy, we served him. Why should my relative ask for time?
Even court notice is
No,
not
his
ordered.
name has been shown. Why I am asking that he is not a caveator. If he is not vakalat is filed, why that office has shown his name? That's what I.
He has filed wakalat, so the office has shown.
The court notice has not been ordered.
Correct. Therefore, they can't be heard.
Yes. What is that urgency?
Well, I'll explain. I'll explain.
Yes, what is that? We'll
But
see. If
at
there is
ink
no
page-
urgency, then we'll accommodate.
No difficulty. If I'm unable to persuade my lords about lack of urgency, then certainly we'll accommodate. The urgency, I'll explain what is the
Yes.
position.
Yes.
Ink page 21 is the impugned order.
What is the suit for?
Suit is for bare injunction.
Yes.
In respect of land comprised in 172/2. 172/2.
Yes.
At ink page 27, the reasons begin.
You are the plaintiff or a defendant?
I am the defendant. I have suffered an injunction
Yes.
from the trial court. At ink page 27 is the reasons. Where they say that they were owners of 4 acres, 29 guntas of land, out of which the BDA has left behind 1 acre, 10 guntas. 27. Ink page 27. Internal page 9, ink page 27.
Yes.
Point number 1 on a careful perusal.
Yes.
According to the plaintiffs, they are the joint owners and in peaceful possession and enjoyment of suit schedule
Oh,
property.
you are reading that reasoning. Correct.
Reason.
Correct.
Para 10.
Yes.
Somewhere in the middle, my lord.
Yes.
According to the plaintiffs.
Yes.
They are the joint owners and in peaceful possession and enjoyment of the suit schedule property. Originally, the land bearing survey number 172, new survey 172/2B of Bedkalli village, totally measuring 4 acres, 29 guntas of land was acquired by the father of the plaintiffs through a registered sale deed. Revenue entries were entered in the name of the father of the plaintiffs. Father of the plaintiff died on so and so, leaving behind the plaintiffs. After the death of father, the plaintiffs continuously enjoying the said property. Out of this, my lord will see, out of total 4 acres, 29 guntas of land, the BDA, BBMP have taken a portion of the property for formation of road and construction of sanitary system, and 1 acre, 10 guntas of land which was retained by the plaintiff, which is the scheduled property. I'll pause here for a moment. This is a false statement made by them because they themselves have challenged the acquisition of entire 4 acres, 29 guntas before this honorable court, and they have not succeeded. Court of extra set 4 acres, 29 guntas fully was notified.
Yes.
My lord, we'll see on internal page 2.
172, na? 172.
172/2, correct.
2B.
2B.
Yes.
Second page, my lord. This petition is filed under Articles 226 and 227 of the Constitution of India, praying to declare that the acquisition proceedings in respect of the land in survey number 172/2B, measuring 4 acres, 29 guntas.
Then who are you?
I am the defendant, owner of 173/2. They are confusing the trial court. That also the trial court has taken note of.
No, you are adjacent landowner.
I am not even adjacent. I am my land parcel is some 20 guntas away from them. They are now trying to confuse the honorable court, take an injunction, and come in respect of 173/1, my land.
See, what is that suit schedule property?
172.
No, suit schedule properties is that your suit schedule, your properties are that 172.
No. That is not even their case.
No. See, now that injunction is granted in respect of suit schedule property.
That's right.
What is that schedule?
172. My lord, I have produced a
No,
play.
yours is 173.
Correct.
It is a different.
Correct.
If he is taking an injunction to his property, it is not in your property. Why do you worry?
No difficulty. Let me explain why I worry. What they are doing is they are coming to the property there and saying that my property is 172/2B.
You have to explain before that persons who are coming, this is not that 172. Suppose injunction has been granted in respect of the Vidhan Sabha. Person who is coming to that high court saying that this is belongs to. We have to say that no, this is ours.
I will say. And then what they do? 50 people come with khadagas and everything and try to attack me saying that it's court order. My lord will hear me what's happening. Then I rush to the police. Police said this is a civil matter, I will not interfere. Well, the position of law is this. When the court at that stage, at the prima facie stage, when the court has to arrive at two conclusions. One, that he is in possession, lawful possession. If the plaintiff is seeking an injunction, he has to demonstrate that he is in lawful possession of the land. That is one. Second, that there is a prima facie case of interference. What has come before the honorable trial court is the plaintiff has made a false submission before the trial court that out of 4 acres, 29 guntas, 1 acre, 10 guntas, that is the social property.
See, now that injunction is granted to that some property which is not belongs to yours.
But it does not belong to the plaintiff either.
No, Suppose person who is taking an injunction is the Bangalore, he will go to that Mysore saying that, no, this is an injunction. Can that,
No, it can.
that person has to be protected by filing in another
That is-
suit?
That is true.
I
Second
see.
consideration, my lord. Second consideration. Our possession in the, if my lord says it's a matter of trial and evidence, we will see. Second contention is that he says, I am interfering in his land. There has to be some material. Because court is saying, yen tondre nimge yen apyantara, avrnu injunction kotta idivalla. Injunction is against me from interfering in his land. There has to be some material. The court itself says there is no material, it is only a contention. If it is, that is his contention, look at my written statement for me. In my written statement, I have categorically stated, I have nothing to do with your land. I am not interfering in your land. Then, my lord, I ask myself the question, on what grounds will the trial court grant an injunction against me? A restraint order which I have to suffer as a citizen of this country can only be, I be made to suffer if there is some demonstration that I am creating commotion, I am interfering. Anyway, let there be an order against you. That is not the principle. In my written statement, so what the trial court today has, contention of the plaintiff saying I am interfering.
No,
My contention saying I am not interfering.
Both of them maintain status quo in respect of suits and property.
No difficulty. No difficulty, man.
What is
I am
the-
perfect.
If you are in that position
No,
of.
no, no, my lord, your lordship kindly see, the claim of the defendant on the basis of the agreement to sell said to have been executed in favor of him by third person in the year 1990. Till today, there no conveyance deed has been executed in favor of me.
No, that is 73.
Yes,
Yes.
No, you are see,
but just your, and then your lordship kindly see the written statement para 5. The defendant categorically stated they have nothing to do with the suit scheduled property and have not interfered with the plaintiff's possession and suit scheduled property in any manner whatsoever. It is in fact the plaintiff who have tried to illegally trespass into the defendant's property and have threatened to dispose the defendant from the suit scheduled property. Even such contention is taken by the defendant hearing. What is how the order passed with the trial court is causing harm to the defendant.
no, where is your property?
My lord, my property is
By the
there.
PDA.
My property, no, my lord, PDA has acquired or something, and now, as on now, I am in possession of the property.
No, if it suit for.
Suit for injunction,
Suit for bare injunction.
Bare
Even that acquisition, you are saying that you are not been disposed.
not been disposed. We have been, he has admitted, defendant has admitted, I am in possession of the property.
No, that suppose if it is a status quo in respect of that, if you are in that position.
No,
what is
no,
the
my lord,
problem?
your lordship, I kindly see, they have, he has admitted by the defendant himself, he had been to the police station and he has lodged a complaint alleging that the plaintiff has caused a offense against me, and he has lodged a complaint to initiate the proceedings and the Prevention of Atrocities Act. Your lordship, once status quo is granted, that itself is sufficient to dispossess me. Status quo is an order of an ambiguity. The learned judges discretion had passed by the learned judge. It has been observed by the learned judge that I have been in possession of the property. They have not even produced except an RTC subsequent to the 2003 onwards. 1990, the agreement
No,
was
that his case is that. Yes, it is acquired, but he has not been disposed.
Dispossessed.
But he is right to continue.
But I am, if I have said,
No,
if
at all the land is acquired, it is between me and the
The
PDA.
lordship is asking me a question, one second.
No, now that injunction is only in respect of that survey number 79.
172. But
172 bar 2.
That
That is not your property.
my lord, may I explain? I have nothing to do with 172 bar 2. I have categorically stated at in page 43 in the compilation that I've given that I am not interfering in his property. Page 43, my lord, in the
And then trial
compilation.
court, therefore they said,
No,
if you are not interfering, then
therefore, what is the material before the honorable trial? Plaintiff's contention that I'm interfering. My contention that I'm not interfering. ನಿಮ್ಗೆ ತೊಂದರೆ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು judicial order cannot be passed is my submission.
no, not ತೊಂದ್ರೆ ಆಗಲ್ಲ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ.
They
See,
demolished.
The trial court has to have
The
material.
purpose is that if you are not interfering, it is proved at the trial.
Correct.
Because it is an injunction suit.
That's
Now, prima facie, he shows that he is the owner of the property.
No, with
No, he is
respect.
not. No,
With respect,
no,
he is
that
not.
ownership is also not necessary
Correct.
because it's an injunction
Correct.
suit. See, earlier he was a owner of the property. Even if it is acquired, he is not dispossessed. He wants to injunction to that property.
Correct.
Your property is somewhere else.
Therefore, what fell from this honorable court is the correct and true proper order. That no, at this stage, 173 L is there, 172 L is there. Yaar in position is there, gottilla. Defendant to band helta idare that we will not interfere in your property. Both parties maintain status quo. Is the perfectly proper order. Why should I suffer an order when I'm saying I'm not interfering? Bring material. Let them show that my pleadings are false before the honorable trial court. I have in fact demonstrated before the trial court that his pleadings are false. He has contended ownership. He has misled the honorable trial court. In fact, one more thing. Even from his own title document, the boundaries which he has shown in the scheduled property are wrong, and the trial court only has given a finding. To the southern side, as per his sale deed where he acquired the property, there is a Rajkaluvel. Then there is one more parcel of land. Then 173/2, 173/1.
What is that document to show that even today you are in the position of correct?
The RTC you have produced. So, RTC, Nane produced RTC that the entire land has been notified for acquisition.
Your property is different.
Our property.
Your lordship,
Our RTC.
your lordship came to see. Para 16 of the improved order, your lordship came to see. From sixth line. Apart from the copy of the judgment produced by the plaintiff, passed on page 16.
Page 16.
After
Page 16 is something is different.
from sixth line.
16 is affidavit.
Idರಲ್ಲಿ improved order.
Internal page 16. It's internal page 16.
Internal page 16 ಅಲ್ಲಿ after fifth line.
Yes.
Apart from the copy of the judgment produced by the plaintiff passed in OS number 476 on the file of the additional city civil and Bangalore further discloses that the defendant number 1 has suffered the degree in the said suit and relief of declaration and injunction was granted against them in respect of the property bearing survey number 173. This ground also the interference of the part and defendant.
No, that there is an injunction against
No,
you.
I have filed an appeal. I have filed. Let me say.
I will ask them to answer.
What asks me a question? Permit me to respond, sir.
Yes.
173 is a separate dispute that I have with somebody else, not with him. There I suffered a decree. I have filed an RFA, and in the RFA that decree has been stayed. That fact also has been suppressed by them. They don't mention that their land has been notified by the BDA. They don't mention the fact that though I have suffered a decree in respect of my land, 173, that land I have filed an appeal and have got an injunction also. That RFA order also I produced before the trial court. The trial court does not mention that.
See, if there is an injunction, RFA order before this court in favor of you in 173.
Correct.
If he is trying to interfere 173, file an contempt.
That is all right. 173 the
173 you have a protection. He cannot come there. 172 is his property.
Correct.
You are saying that you are not interfering. His
Correct.
court has granted that not to interfere. That's
But
all.
no, the material, my lord, is all that I'm
That shows
asking.
that you are specifically, when you are saying that you are not interfering, you are specifically showed that there is no material. That intention shows that you want to interfere.
No, not necessarily, my
Why
lord.
are worried?
My lord, may just look at the
No, Mr.
decision.
Counsel, don't be on technicality.
I'm not on technicality.
No, if you are not interfering, when there is an injunction, what is the problem?
That cannot, with respect, my lord,
No,
with
that's-
respect,
see-
that cannot be one of the grounds. Prima facie case, balance of convenience, irreparable injury.
Yes, that will be decided at that.
That has to be decided now.
Yes.
That has to be a view taken now.
Yes.
When I am saying I'm not interfering, there has to be some material. The reason I tell my lord what is going on, the mischief that is being played is, on the basis of such an injunction order, they come before 173 land and say that this is my land. When I approach the police and say, no, please protect me, this is my land, like my lord said. Vidhana Sabha ಮೇಲೆ injunction ತಗೊಂಡು high court ಬಂದ್ರೆ,
You have an order of injunction in 173.
well, I do not. I have an order in respect of somebody else, not in respect of him. That is a dispute, different dispute. A complete misleading of the trial court. The dispute which is referred to in this OS number 4730 of 2006 is with somebody else. That is a different dispute. As against that person who claims ownership of 173, I have got an injunction demonstrating that prima facie I am the owner. He does not make a claim on 173. He tries to get an order in respect of 172 and then comes before the property in 173 and says, give me this. What my lord first said is the correct order. In fact, this court has in similar dispute passed exactly such an order. In fact, in one case, the court has gone forward and appointed a court commissioner and said, let us at least look at where is 172, where is 172.
Yes, we'll appoint the court commissioner. We'll appoint the court commissioner.
Please, ma'am.
To verify.
No difficulty. Let the court commissioner. In one of the matters where the identity of the property itself is in doubt, this court has appointed court commissioner. Please.
Yes, where is that?
Judgment I just gave, my lord will see.
Appointing the court commissioner.
Court commissioner into one where there is confusion, it has not to be appointed, injunction should not be granted. My lord may see the judgment in page 12. Third
Judgment. Okay.
Third judgment. In that,
Yes, sir.
internal page 7, paragraph 4.
MFA 6866.
Yes, my.
Yes.
6866. Internal page 7, paragraph 4.
Yes.
In the above facts and circumstances, as could be seen from the order passed by the trial court, the court observed that the possession of a disputed 10 guntas of land has to be established only after ascertaining the exact measurement of the entire property and to find out exactly where the disputed 10 guntas of land falls to the plaintiff or to the defendant. Unless that particular area is bifurcated and identified by the court cannot grant any injunction order in favor of the plaintiffs. At the initial stage itself, the plaintiffs show that said 10 guntas had been in their exclusive possession, then the said property can very well be identified at this stage itself so as to prevent anybody from doing anything, because both the parties are claiming possession in same survey number. In the circumstances, it is absolutely necessary to first locate and identify the properties in respect of the parties, and thereafter only the court can pass appropriate orders. Therefore, in the above facts and circumstances,
We will appoint the court commissioner to verify.
No
whether it is
difficulty.
in the Possession of that survey number.
172 to be L ಬರುತ್ತೆ 173 ಬಾರಿ L ಬರುತ್ತೆ ಅಲ್ಲಿವರೆಗೂ ಸ್ಟೇಟಸ್
ತೊಂದರೆ ಇಲ್ಲ ಬಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ವಾಟ್ ಇಸ್ whatever my learned read the judgment
No, that judgment is not relevant.
Not
That is there
relevant
in
so far
respect
as-
of that
yes
same property. there is a
disputed
difference.
so far as in my case they have admitted my position and enjoyment is so far as 172 in written statement itself. The learned judges also observed it under the same paragraphs in the imputed order.
Now this they cannot have any problem with when my court when my
No,
lord
no,
is
I am
suggesting.
not coming the way to avoid.
ಹಾಗೆ ಮಾಡ್ಬಿಡೋಣ ಯಾಕೆ ಸುಮ್ಮನೆ
Yes, suggest some advocates will appoint them.
Well, ಬೇಡ let us qualified surveyor be appointed as well, because if there is no qualification then identifying the property by revenue records becomes difficult. For somebody from the ADLR office and the direction ಕೊಟ್ರೆ the ADLR office will appoint somebody. That's the usual order that comes.
Otherwise, advocates can take the assistance of that ADLR and submit. a-
ADLR or a
Permitted
Berlin.
the advocate to take services of a ADL.
ಹಾಗೆ let the government advocate be appointed with the to take the assistance of ADLR.
Government advocate appoint ಮಾಡಕ್ ಬರಲ್ಲ. Private appoint ಮಾಡ್ಬಿಟ್ಟು government advocate may be directed to give an assistance of
Yes,
that
yes.
ADLR.
ಹಾಗೆ
Where is this property? Which place?
ಬೆಳಕಲ್ಲಿ ಅದು schedule.
Bangalore. It's in Bangalore.
It's in Bangalore.
Yes.
Clear.
Oh, it's coming within that BBMP limit.
BBMP limit.
Now that who asked whether surveyor in that BBMP or your
ADLR. Survey report will be prepared by ADLR.
yes,
Let the survey report be prepared.
that suggest any advocate can both of them has to bear that
Cost, certainly.
yes, Mr.
Better, sorry. I believe they are from the same chambers. Let there be somebody new.
Yeah.
I believe they are from the same chamber.
You see?
Let it.
I will file an affidavit. He is not my chamber.
No, Mr.
How can he?
No, if he is objected.
But ಬೇಡ ಅಂದಿದ್ದು ಒಪ್ತಾನೆ. He is from his chamber ಅಂತ
Leave
ಹೇಳಿದ್ರೆ.
it, Mr. See, that needs to say he
Don't
has
make
an
such I am not stooped to that level.
No, Mr.
I'm not
Gopal.
suggesting my name.
No,
No.
Mr. Gopal.
ಅಷ್ಟೇ ಹೇಳಿ ಸಾಕು. It's the same chamber ಅಂತ ಯಾಕೆ
No,
ಹೇಳ್ತೀರಾ?
Gopal Swami. See, this is humiliation to that advocate.
Correct.
That's what I'm telling. He is not my.
That's why I did
Leave
not
that
look
out of
behind.
things.
That's why I did
Nobody
not
will
look
come
behind.
forward to become an.
That is the way. It is not for me to look behind and point to somebody. Somebody will volunteer.
Not ready to take such an implications.
See, he has not that, see, he has seen him and he has asked him.
Let him suggest.
Yes.
Let him say.
If somebody is volunteering ಆಗ್ಲಿ ಅಥವಾ ತಾವು ಯಾರನ್ನು appoint ಮಾಡ್ತಾರೆ.
ತಾವೇ appoint ಮಾಡಿ.
Not that anybody
Anybody
Yes,
volunteer?
Mr. Shilpa, you can. The advocates. There is a youngsters. Yes, Mr. You can. You have any idea?
Usually trial court ನಲ್ಲಿ directly ADLR direction ಹೋಗುತ್ತೆ. So ನಾವು ಅದನ್ನು ಮಾಡಬಹುದು. Direct the ADLR to conduct survey.
To that some of the advocates, that's all. Yes, let that thing, advocates can. You both are capable of bearing that expenses. Let give an opportunity to an advocate. Yes, Mr. Shiram, anybody from the bar, you can. You are sometime you are the leader of the bar.
ತಮ್ಮದೇ ಯಾರು ಜೂನಿಯರ್ ಹೇಳಿದ್ರಿ ಅವ್ರದೇ
Youngsters, we can.
ಆಗ್ಬೋದು, ನನಗೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಯಾರು ಮಾಡಿದ್ರು
Yes, madam, you can do it. Yes. Yes. This appeal is filed by defendant. Challenging. Order dated 7th September 2023. Passed by 8th Additional City Civil and Section Judge, Bangalore, bias number 4869 of 2023. Again, for one filed by the plaintiff under Order 39, Rule 1 and 2. Restrain the defendant from interfering with the peaceful possession and enjoyment of suit scheduled property. The plaintiff, the suit scheduled properties as mentioned as below. A suit scheduled property extract money. Definite counsel for the appellant defendant has contended that scheduled properties is survey number 72
172 bar 2B.
173 bar 2
172 bar 2B.
173 bar 2.
ಇಲ್ಲ ಅದು ನಂದು. Plaintiff suit scheduled properties 172 bar 2B.
172 bar 2B.
ಹೌದು. Page 27 as well.
Taking this advantage of this injunction order, the plaintiff is interfering into that. Land belongs to the defendant in survey number 173, situated in same village. Same village. The same has been disputed by the counsel appearing for senior counsel appearing for the plaintiff respondent. They are contending that the injunction is granted in favor of the suit scheduled property. The possession of the defendant is plaintiff is also admitted by the defendant. Therefore, he has contended that they are not interfering into that. Survey number 173 bar 2. If there is a dispute respect of the survey number, since there is since the parties are disputed regarding that interference, for better assistance of the court, this court has of the opinion that to appoint court commissioner to get in a report to considering this appeal.
It lost one submission. Yeah, written statement schedule is also there. Someone court has to.
Our 170. Please, they are going to interfere into that. Survey number 173 or 2. Scheduled extract. In that order, I will say that to verify.
Identify both the properties.
Yes. Manjula, the advocate, has been appointed as a court commissioner, directed to find out whether defendant, whether the plaintiff, after taking a temporary injunction order in respect of suit scheduled property, are interfering into that. Survey number 173 bar 2, measuring zones of the boundary act. And submitting a report to identification of the property. The court commissioner can take assistance of Who is that officer?
ADLR.
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 ADLR. The government advocate is also directed to. Advocate is also directed that to communicate this order and direct that ADLR to assist court commissioner to find out that
Location and identification of the two properties.
With reference to the pleadings.
find out
Location
the
and
location of the identification of the properties.
With reference to the pleadings.
Yes. Court commissioner is directed to,
With reference to pleadings.
yes, identification of the properties now extract
Correct.
Yes. Identification of the properties and submit a report to this court. When you leave, both the parties are directed to be present.
With reference to the pleading of the parties. Yes.
No, I have given
Does not go to
boundaries,
pleadings.
both the boundaries of the properties.
Correct.
They have to take an assistance.
The parties have stated before the courts below that ಒಂದು ಶಾಪ್ ಇದೆ ಒಂದು ಕಾರ್ ವರ್ಕ್ ಶಾಪ್ ಇದೆ ಇದೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. That has to, therefore, my request before this honorable court with reference to the pleading, the survey has to be done.
ಅಲ್ಲ ಅದು ಬರುತ್ತೆ. I am not quarrel with this proposition, but ಬರುತ್ತೆ. Because when the survey report is submitted, the report will describe the properties.
That see, we have given a boundaries. We have given a boundaries. They will go to that boundary and see whether it is their shop is there, building is there, it is immaterial. See, you are now want to try to interfere into that boundaries which is given to him, or that you are
Your own property.
taking a benefit in respect of only your property. That has to identify. And
Please hush.
yes, submit a report. The parties are directed to be present on the day the court commissioner is inspecting that property. When you want any particular date,
We may need to coordinate with the ADLR's office for availability of the surveyor.
that's the, they will, you have to communicate by phone and have to tell them. We have already, we'll fix the date on 12th. 12th we can, or any Saturday you want. 14th. 14th, second Saturday, we can government rachana. Twenty-first, yes, 21st. Leave this matter on 31st. 31st, we can file an report. Yes.
Until then, my lord, status.
No.
Nothing will happen.
No.
No, they will interfere.
No,
I will-
they
no,
admitted.
No,
See,
1 second. My lord will hear me. No, that this is the purpose.
That cannot be
1 second.
possible. When we
See,
give office
Yeah,
admission.
make my submission at least without being
No,
interfered.
Mr.
Or
that there is a-
always you are making submissions. I should
Wait,
keep
Mr.
quiet.
Then I'll say one more thing. Today, as of today, the trial court has not even released the certified copy of the order. They have not even brought the certified copy of the order to the parties. They have already filed an IA for police protection, and the trial court heard me and said, I am going to allow the IA.
No.
Therefore, now they are going to
No,
take
no,
the assistance of the
that-
police and come.
Now matter has been seized by this court.
Correct.
In respect of very dispute, there is an order for court commissioner.
Correct.
Even after that, if you are coming to your land and doing that, that is easy for the court commissioner to identify that they are interfering into the your land.
But this is just muscle power. They will just simply
No,
muscle.
When there is an order, they cannot do it. If they do it, you come before the court and make that.
Well, then may I make one more request, because this definitely still puts the appellant in a precarious position. I will only seek the assistance of
Your
the court.
lordship,
I will only request this honorable court. Let me make my submission.
Always you are making, you are not allowing me to make a submission.
Let me
Your lordship
make this submission.
has already lodged a complaint before the police to the effect that the petition respondent has committed an offence under Prevention of Atrocities Act. Who is putting in dangerous position? Your lordship.
No, that is not that. Now,
I am saying I have
No,
a different request.
no, Mr. Even now, if he has tried to come to your land, then it is an advantage for the court commissioner to find out that taking an order of that and interfering.
By
Now
then encroachment, trespass, all that will happen. May I have one more request then? Anyway, my lord has said that the identification has to be ascertained. My lord is saying let the injunction remain. I am saying I am not interfering. There is no occasion for police protection. Let the trial court not pass any orders on that IA for police protection.
No,
ಅದಕ್ಕೂ material ಎಲ್ಲಿದೆ? ನಾನೇ ಸ್ವತಃ ಪ್ಲೇಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ನಾ ಅಡ್ಡ ಬರ್ತಾ ಇಲ್ಲ. ಇಲ್ಲ, ಪೊಲೀಸ್ ನ ಕರ್ಕೊಂಡು ಬರ್ತೀವಿ.
press for that application.
ಅಷ್ಟೇ. Please,
Yes.
ಅದು ಮಾಡಿ.
No, office is directed to furnish this copy to the both the council and court commissioner and government.
Well, it was a request of the trial court, and therefore my learned friend has said that they will not press. I definitely respect that. Trial court had instructed me, stay order ತಗೊಂಡ್ ಬನ್ನಿ, an order pass ಮಾಡ್ತೀವಿ.
Now,
Let there be an observation.
now this is an order passed by this court. He has also said, in spite of the trial court passing any order, move immediately before this court. I will take at 2:30 and pass an order.
Great.
After informing all these things, if trial court has taken.
Grateful. Great.
Then you have to pay that court commissioner fee. Both of them has to pay 15,000 each, 30,000. Yes. Court commissioner fee is fixed 30,000. Both the parties has to be paid 15,000 each.
Number 41.
For the appellant, my lord.
Yes.
There is a delay in filing this MFA, my lord, MSC regarding the announcement compensation. The delay is there.
Now special land acquisition officer will take it. There.
Copy on this road, you want to.
Service ಆಗಿದೆ, but special land Hemavati reservoir project ನೀವೇನಾ? Yes. Government respondent number 1 is served, unrepresented. Government advocate is directed to take notice. ಒಂದು ಕಾಪಿ ಇದೆಯಾ? ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅಮ್ಮ.
Short words, Mali. Short the long back.
ಅಲ್ಲ ಅದಿಲ್ಲ, ಅದೆಲ್ಲ ಹೋಗಿದೆ, ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಎಲ್ಲಿ ಯಾವಾಗ? ಅದಲ್ಲಿ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗುತ್ತೆ, ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ how it will work and one more copies you give. Yes, next week you verify, you will is the delay is concerned, you find out and will. Bandilwa? Yes, office is directed to secure original records from the trial.
Number 42, government advocate.
Time will be granted with this case.
Yes, week's time is granted to the request of counsel.
Number 43,
Please, my lord, in this case, I'm filing a recalling the order.
Why is that dismissed?
Non-compliance of office objection.
Have you complained?
Please, I'll comply, my lord.
Yes,
After
pending
recalling.
consideration of IA 1 and 2 of 2023. 2 weeks time is granted to comply that office objection.
Please.
number 44.
Preparing for the appellate, my
My lord,
lord.
in this case, apparent of the petitioner, my lord, and RPFC.
I would like to make a small submission, my lord. My lord, the respondent has not paid the maintenance for the past 3 to 4 years. And furthermore, all negotiations have failed. And it has come to our attention that after 3 weeks of divorce, the respondent has already gone into a second marriage. Hence, we are requesting that this present matter be listed for final hearing either next week or the second week of November.
Yes, we'll post this matter for hearing, madam. We'll hear that matter.
Please, my lord,
Yes.
second week of November, my lord.
God admit. This matter. Hearing. Yes. IA 1 of 2023 is heard and disposed of. IA is allowed to post this matter for hearing on 15th November.
15th one.
Yes.
Please, my lord. Interim order to continue, my lord.
Interim order granted earlier, if any, is extended till next day.
Obliged, my lord.
Number 45, Sampath Kumar hearing on petitioner.
Petition, my lord, sir. There is a delay of 34 days.
Notice.
Petition matters, number 46, that is into petitioner, Varakanath case.
Yes. It's a case where simple suit for ejectment was filed before the small causes court lordship.
Yes.
But the evidence was recorded, documents were burned. At the time of final judgment lordships, the court takes up an issue sumoto regarding maintainability and dismisses it on the ground that the small court has no jurisdiction because it's a site measuring 30 into 40. Page 13 may be seen, lordships.
Yes.
I have clearly said that all the piece and parcel of converted property bearing site number 1. And my lord, the defendants themselves have admitted that page 21, lordships, page 10 of the judgment.
Yes.
The suit shuttle property consists of compound with 3 squares pump house in it with 4 borewells and are supplied with electricity also.
But the court comes to a conclusion that since Karnataka Rent Act is not applicable, therefore, my lord, the suit before the small causes court, my lord, it outs the jurisdiction. My lord, it is against the judgment of this honorable court. Constitution bench, my lord, which are produced also, 2011.
Full bench.
Full bench. My lord, it says, even if, my lord, Karnataka Rent Act is not applicable,
Yes.
if it is a simplicity of lordships, suit for
No, yes,
adjustment,
madam, is on that ground it is dismissed.
on that ground itself, it is dismissed, my lord.
This, the court has dismissed on the ground that the court
Why?
actually complete, your lordship may come to implement page 12 of the judgment. Where order 14, implement page 2 points, because the plaintiff order 14 of CPC provides that court is the opinion that to be disposed of. Issue of law. Then
No, we are not disputing all that.
First in relating to that,
What is that not, why it is not maintainable?
because your lordship may kindly come to section 8 of Karnataka's month of the sports act. I will read out section 8.
Yes, Mr. Goraknath.
Section 8.
He was held up in the other.
No, that is it dismissed that since Rent Act is not applicable, therefore small cause court has no jurisdiction.
Small cause court has no jurisdiction. That is the basis on which the case has been dismissed.
Why?
May lordship may kindly come to section 8 of the Small Cause Courts Act.
Yes.
Section 8. A court of small causes shall not take cognizance of the suit. Specifies accepted causes.
Yes.
Schedule 4C. A suit for possession of immovable property.
No, 4C. 4C. No, you are reading 4. Adhe 4 correct. Amele ABC.
Yes, yes. I'll have to read from the beginning.
Yes,
That is the reason.
Yes.
A suit for the possession of immovable property or for the recovery of an interest in such property, but not including a suit for ejectment. So the court says ejectment suits are maintainable.
Yes.
That is qualified for that. Ejectment, where the property has been left under a lease or permitted to be occupied by a written instrument or orally. B, the court of small causes would be, Your Honor may kindly see the word used and. A agodu and another. Then B, the court of small causes would be competent to take cognizance of a suit of the rent of the property and C is not satisfied here. The only substantial issue arising for the decision is as to whether the lease has been determined by efflux of the time limited thereby or has been determined by a notice in accordance with law for the time being imposed in respect of such lease or the permission to occupy has been withdrawn. In this case, what has happened is only this question should be involved. Here, the tenancy is disputed. The ownership is disputed. We have said under an agreement of sale, we are in possession. These things cannot be looked into. Normally, the law is the jurisdiction of the court is decided based on the averments in the plain, not based on the averments in the written statement. It is a normal law. But as far as this one is concerned, there are any number of decisions which say it is totally dependent on the written statement. Well, it was argued earlier, I had given decisions, your lordship may kindly take those decisions.
No, that even that written statement can also look into. But here is the case that in a dispute regarding that
Ownership. Yeah.
ownership, then
You-
that has to be referred to that civil court.
Yeah, it has to go to civil.
No, that during pendency, the small cause court can direct the civil court to decide that issue and is it-
Either it can be transferred or they can be, he can be permitted to file a fresh suit. No, it is dismissed. He has to file a fresh suit. Your Honor may kindly see internal page 7 of the judgment. Internal page 7 of the judgment.
yes.
Further contended that suit only in the hands of the plaintiff is not maintainable, is not only the owner, etc. So that is one contention, he is not the owner. Then further contended that the defendant had entered into an agreement to purchase a suit schedule property and the plaintiff and other co-owners had put the defendant in possession of suit schedule property in part performance of said agreement of sale. The defendant was throughout ready and willing to perform his part of the contract, etc. Now that I have taken such a contention and foresee the suit is not maintained.
No, that I think somewhere I read, just because the contention has been taken, that there is a landlord and tenant relationship. It cannot be said that unless prima facie it has to be proved.
No,
No, otherwise, in all cases, they will deny that this thing. If he prima facie satisfy the court that yes, he is his tenant, there is an agreement, then
there is no such thing.
no, has he produced
Your Lordship may kindly come to the decisions that I have produced.
no, that is, has he produced any document regarding rent or any other things?
In
I have
fact,
produced the lease agreement, Lordships.
Has he paying that rent?
Well, rent also, they, they don't deny that I am the owner. They say that suit fund, that is not considered by the trial court. That is not the reason on which it is dismissed. Reason on which it is dismissed is that Rent Act is not applicable, that's why it is being dismissed. Nothing beyond. Kindly read the judgment.
Your Lordship, it only says, before that, I have not paid any rents. The rental agreement that has been produced is in dispute. Number 3, they do not dispute that there was an agreement of sale with me. That they do not dispute that there was an agreement of sale with me. That is admitted.
What is the position of law then? If the subsequently tenant becoming a purchaser of that property, then what is that when it's a dispute? It is not maintainable before the small cause court.
The moment I take up a contention that you are not the landlord, I am not your tenant, this court has no jurisdiction.
No, just because the contention, it cannot be. Show me
No,
that.
Your Lordship, I kindly take the decisions. Again, 3 decisions.
It is not the grounds on which it is dismissed, Lordships.
Now we'll see what is the ground on which.
Ground on which it is dismissed.
Then we'll go that why unnecessary.
Unnecessary, my lord.
Yes, where is that?
My lord, kindly see that, Lordship, the page 25. Para 25.
Yes.
My lord, even from the beginning also, my lord, from paragraph 18 onwards.
Yes.
My lord, it all along, my lord, it discusses about Karnataka Rent Act.
Yes.
Paragraph 18, para 19, 312, para 20, 312, para 21, 312, para 22, section 40 of the Rent Act. And page 23 also, my lord, para 25, Lordships. Therefore, looking into the facts and circumstances of the case, Honorable High Court of Karnataka made it clear that eviction petition.
No, which paragraph?
Para 25, Lordship, sorry.
Yes.
Therefore, looking into the facts and circumstances detailed in the above case, cited decision in the Honorable High Court of Karnataka, made it clear that eviction petition in respect of vacant land is maintainable under section 40 of the Karnataka Rent Act. The facts and circumstances of the present case on hand is also similar. The present suit property is also vacant land having measurement 30-40. That's also wrong, Lordship. Same is not used for agriculture purpose. Looking into the measurement and nature of the land, it is considered opinion of this court that present suit is not maintainable before small causes court. Since the plaintiff prosecuted the matter years together, reject the plaintiff doesn't arise as he read oral and documentary evidence. When the suit is not maintainable before this court, appreciation of other materials also does not arise. When the suit itself is not maintainable, return the plaintiff would not serve
However, the liberty is given to the plaintiff to initiate necessary proceedings.
No, what is the reason given for?
Reason given, my lord, all along, my lord, it says that, my lord, Karnataka Rent Act section 40. This is only 13 to 40 site.
No, that eviction petition in respect of the vacant land
Uh,
is maintainable under the section 40 of the Karnataka Rent Act.
Karnataka Rent Act.
Then
That is why, my lord, the court says that it is not maintainable. But virtually this order is against the full bench decision of this court. My lord,
what is that meaning if it is in a vacant land? Vacant land rent act is applicable.
But the court says that the present is a rent act, same is not used for agriculture purpose. Looking at the measurement, but it simply says that it is not maintainable.
No, even vacant side.
No, my lord.
Is
He himself
rent
has
act is
said.
applicable. What
My
is that
lord,
meaning?
My lord, I will not say that this judgment is correct. See, rent act applicability was not a question that was considered as right.
Yes.
What I am submitting is, anyway, the court has no jurisdiction.
Let them decide. Let them decide on that point.
On
Yeah,
its,
if you are, now that, if you are not able to remand the matter, again, it will be, same thing will be held. I have no problems. But, it said it is better that they go to civil court because
No,
civil court alone has jurisdiction.
See, there are a lot of things has to be considered. Just because denial by the tenant saying that it is not in a landlord, it is not roosted the jurisdiction of the
No,
small cause court.
They
have
have
to
to
look at-
respect my respectful submission to your lordship.
Yes.
That understanding of this court may not be right.
Which is that judgment you say that the moment,
I give three judgments.
the moment that the landlord said,
Yes, ma'am.
the tenant said that.
I am sorry, I have a little different view of the position of
Yes,
law.
yes. Sure.
also produce the straight decisions of the Supreme Court.
88 Bombay 142, that is one I had given.
No, you don't find any judgment of our.
That also, the Karnataka High Court judgments also have produced.
Yes,
Because of the beauty of the language, I have produced one Bombay. My lord,
No, we can understand that our high court's language easy than that beauty of that.
then your lordship may come to second decision that I have produced, our Karnataka High Court decision.
Yes.
Your lordship,
Yes.
I have paginated, your lordship may kindly come to ink page 15, 1-5.
Yes.
Para 16 of the judgment.
Yes, it's a full bench. Full bench judgment. It is.
No, man, single judge.
Para 15 is a full bench judgment.
Huh?
No, page 15, ink page
Page
15,
15.
ink page 15.
Yeah.
No, Abdul Wajid is the full bench judgment.
No,
Well, this is the one which I have given lordships.
No, this is yours.
That entire, including whatever were the contentions raised,
Nimdelli then.
it is also argued before the trial court, my lord, but the court.
Let.
Oh,
he is
please,
fighting out
please.
this. Yes. Yes, I
page
got
of
it.
ink page 15, para 16.
Yes.
The general principles is the jurisdiction of the court shall be determined by the government in the line. Under the Small Causes Courts Act, Article 4 makes a departure from the principle and the jurisdiction of court is made dependent upon the content placed in the written statement and at the will of the defendant. Your lordship may kindly see
Yes,
the word
will.
at the will of the defendant. In the written statement, if the defendant were to deny the relationship of landlord and tenant, denies the title or take any other claim it gives rise to issue other than one mentioned in clause C of section 4, the small cause court has to return the claim for presentation before the civil court for adjudication. Therefore, it is implied that till the written statement is filed, the jurisdiction of the small cause court remains uncertain. In the present legal proceedings, the defendant from the date of appearance has 90 days time to file a written statement. Till then, unreasonably, likely person is waiting to make issue of his court. Then next page 16, fourth line. But the working of the provisions of the act causes more harm than a favor in the category of landlord who came under the jurisdiction of small court, since they have spent uncertain moments regarding quorum until the filing of the written statement. Para 18, fourth line. It is high time that the idea of small cause jurisdiction should be done away with. My Lord Disco said the law is such that it is not good. But this is the law.
a direction was given or an observation was made that the law should be amended. The law has not been amended till today. In that view of the matter, that decision applies. I have taken up a contention. The correct thing to be done is that the plaint has to be returned. I do not know why the judge took a view to dismiss the suit. The correct judgment should have been, it should have been written for presentation to the court.
Yes, Mr.
The next decision is also of Karnataka High Court. The next decision is also of Karnataka High Court.
Yes.
Your Lordship may kindly come to ink page number 19,
Yes,
para 5.
yes,
About 5th line.
yes.
Whether a question or title is involved or is in a dispute in a small cause court, the jurisdiction of the small causes court stands ousted. The lower court has not looked into this matter. Further, when a contention is raised, the jurisdiction of the civil court is barred on account of such circumstances, and the area in question is agricultural land. The court ought to have applied its maintenance.
Yes.
Shall I?
Yes.
Sorry, he has finished like this. Millard,
Let him complete.
Millard, in this case,
No, yes.
sorry.
Yes.
Millard, in this case, initial objections were not taken. Millard, just 2 minutes, Millard, I'll conclude.
No, you just answer that. See, regarding this issue, it has not been discussed by the small courts. It is different. I will see what you say about that question he has raised.
Millard, my submission is
Is it the law that the moment in the written statement, landlord taken the contention
that there
that
is
you
no
are not the tenant has taken a contention, you are not a landlord. It
Millard.
is boosted the jurisdiction of the small cost.
Now, Millard, my only submission is, in this case, the facts of the case needs to be seen. In this case, he has not taken a defense that the plaintiff is not the landlord. What he says is, Millard, if suit filed by a co-owner is not maintained. That's what, Millard, my learned friend also read out. He is not only the owner, but other owners are there.
Now, where is that written?
Millard, kindly turn to page 18 of the judgment itself.
No, that written statement means, have you produced it?
Not have a written statement. In the written statement, we take inconsistent alternate stands. I have one contention I have taken is he is not the absolute owner. I have not admitted that I am the tenant. I have not admitted him to be the landlord. I have admitted that he is the owner. Owner of the property.
One submission. Millard, all these things, Millard, put into test. Evidence has been recorded. We have cross-examined in length about these aspects. Millard, 3 aspects I need to satisfy. Number 1, Lordships, the basis on which the trial court has rejected the plaint or dismissed the suit is that Karnataka Rent Act is not applicable, Millard, may not be correct.
No, that
I leave it,
No,
Millard,
Mr.
because
it can be sent back within the minute. Now that I want to see that what is the
true, Millard, true.
see
No.
now that court has decided on that other aspects, the aspect which is raised by the parties has not been touched into.
Not
I
been
can
touched.
direct it to do it. Whether is it the law, I want to know that, Mr.
Millard, no, Millard, that's why,
Now he
Millard,
has submitted that judgment.
true, Lordship. Page 103 may be seen. That the decisions what I have given. Straight on the point, Lordship. 3 judges, 103, 105 precisely, Lordships.
Not 3.
103 start from the judgment. 104, Millard. In the second paragraph, Millard, rent control so establish the relationship of landlord and tenant between them.
No,
As
very
divided.
Point out that the judge has to take out that para, which is that
Millard,
105.
page 105, the 4th line, Millard. The owner of the suit premises and that by raising a plea that they were not the tenants in respect of the premises described by inner application, it cannot be said that they are denied their title. The High Court also held that raising of a plea that there was an agreement for sale did not amount to denial of landlady's title. As regards the claim of the permanent tenants on so and so, some evidence in this case to support it, and therefore it cannot be regarded as a malafide claim. There are 2 things, Millard, I would submit. But he says that suit by a co-owner is not maintainable. He doesn't deny my ownership. For that, my lord, petition reported in.
No, Mr. Don't check.
My lord,
He said in one of the paras, he has denied that you are not a landlord. Other paragraph, he said that you are an owner. Just because you are an owner, you cannot be a landlord.
my lord,
He said that, see, has he denied that? Has he denied in the written statement? If he
I'm
denied,
afraid he has
right,
denied
you have to be sure when you are arguing. These points, very two simple points he has argued.
Yes, my lord.
You have to point out the
How can you
judgment.
say- My lord, written statement, what he has said is,
No, if that is the law, saying that once that tenant is denied, it is boosted the jurisdiction of that small cause court. If that pleading is there, what is that use in send it back? That's what I am thinking that.
well,
Therefore, you have to canvass.
this is the answer, lordships. No doubt, he has denied the relationship of a landlord and tenant. I have produced the lease agreement. My lord, we have put to
No,
test.
that he has shown the judgment where this court said in the written statement, if he has taken a contention that he is not a landlord, then it is boosted. Any other judgment, it is point out, it is not that law laid down by this court. There is so many other judgment. You have to point out that.
My lord, this is what I have said. This
What is this said? He
The-
said that in that
raising a plea that they are not the tenants in respect of the premises described. By in a loan application, it cannot be said that they have denied a title.
yes,
This is squarely applicable, my lord.
there is that.
The
What is the facts of this case?
my lord, facts of the case also, my lord, is the same. They also, my lord, they claim that in my lord, page 104.
Have you given that copy?
I have given it.
He has to show some judgment where small cause code act is discussed. He is showing judgment where small cause code act is not referred to. It is for him to show small causes code act being applied in a
Yes.
particular manner.
My lord,
He is reading something which is.
my lord, at one, my lord, nth number of pleas can be taken to oust the jurisdiction of the court. The court has to see whether there is a malafide intention in the said pleadings or not. My lord, kindly see at one breath, he says that I am the owner, he is an agreement holder. Agreement is not produced at all.
No, you forget, he has not taken that contention.
My lord,
But
the answer
convince
is,
the court on the law that if the, suppose in your case, he has not taken, take it that he is not taken. Suppose in cases where the contention has been taken, is it a boosted the jurisdiction of the small cause? On that, you have to give the judgment.
my lord, except he has not denied my title.
No, Mr.
Only he has
Forget
denied
about your
the
case.
relationship of landlord and tenant.
If he, suppose in one case, if it is denied, then it is boosted the jurisdiction of the small cause. That you answer first.
My lord,
If
this is.
that is not the case, whether it is denied or not will not be immaterial. That's what I am saying.
My lord, page 105, my lord. Since, my lord, we concentrated more on the Karnataka rent act.
You
On
we
that-
will have it on Tuesday. You get that judgment. And that's
Yes,
fine.
Vacation.
No, my lord. My lord, for 30 years, he's staying in the property without paying rent, without anything. He takes up a plea of agreement to sell. He doesn't produce agreement to
No,
sell.
that if you are
Suit is
accept,
filed, it is
if you are
dismissed.
accepted your arguments, I have to send it back again to rehear. Consider that contention he has raised. Again, that small cause court, tomorrow if it is dismissed, again it will be that delay.
I'll convince me.
Yes, when you want, next week.
Immediately after vacation.
Vacation, whichever about this. Tuesday or Wednesday.
Yes, and 12th.
Please,
10th. 10th anyway, I am coming.
Yes, 10.
thanks.
Number 47 and 10, number 48, and we are mentioned as open house on a plan. And Madam B. Ramesh,
Forty-seven.
48,
Yes, Mr. He wants password.
Please,
Next week.
pass on.
Password. No, there is an delay.
The delay on the admission is.
Huh?
Yeah,
Delay, will condone that and post it for admission.
Yes.
Call for records, already records ಬಂದಿದೆ sir. Kindly pass on madam.
You don't want to condone the delay. Password, he wants to pass.
Please.
Yes.
Otherwise, you might be taken up on 12th, my lords, similar matter.
No, that it is 2022 matter. If there is any case, it has to be posted for hearing. All that matter.
My lords, what has happened, my lords, ex parte judgment and decree was set aside. The suit is restored. My lords, I have filed the return statement, my lords. Suit is going on. My lords, it's a bare injunction suit, my lords.
No, his application for rejection of the plaint.
No, lords. He has challenged the order passed by the learned trial judge where the suit has been restored. Miscellaneous has been allowed.
Miscellaneous.
Yes, my lords. Ex parte judgment and decree.
ಸಮಸ್ಯೆ ಸ್ವಲ್ಪ ಆಗಿದೆ ಅಂತ ನಾವು ಕಂಡೀಷನ್ ತಗೊಂಡಿದ್ವಿ.
ಆಯ್ತು. Miscellaneous is allowed to CRP ಬರುತ್ತೆ.
ಹೌದು.
That suit has been decreed.
Restored, my lords. Suit was decreed.
Suit has decreed.
My lords, I have filed a miscellaneous, my lords, for
Your
restoration.
Restoration has been allowed.
That has been allowed.
Yes. Yes. Mr.
Negative parts of minutes. Negative for the 1 minute.
12th award.
Yes. 12th.
Please.
Yes. Please this matter.
Much.
Kindly pass out the matter. Senior is engaged in.
Pass out. Pass out. Yes. Yes. Yes.
May kindly recollect that the appellant is prevented from entering the garden. ನೀರು ಹಾಕ್ಲಿಕ್ಕೂ ಬಿಡ್ತಾ ಇಲ್ಲ ಅವರು ಥ್ರೂ ಔಟ್ ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರು ಇಲ್ಲ ಎಪಿಲ್ ಅಡ್ಮಿಟ್ ಆಗಿ ಆಮೇಲೆ ಹಿಯರಿಂಗ್ ಆಗ್ಲಿ ಅಂತ. ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, ಆದ್ರೆ ಅಲ್ಲಿ ಗಾರ್ಡನ್ ಇದೆ, ಎರೆಕ ಬೆಳೀತಾ ಇದ್ದೇವೆ, ಅದಕ್ಕೆ ನೀರು ಹಾಕ್ಬೇಕಲ್ಲ, ಅದಕ್ಕೂ ಬಿಡದೇ ಇದ್ರೆ ಐ ಆಮ್ ಸ್ಟೇಯಿಂಗ್ ದೇರ್.
Why last week it is urgent today?
Because they said no, I will also produce a document that he is in possession ಅಂತ ಹೇಳಿದ್ರು.
Where is he? Pass out.
Yes, but ಬೇರೆ ಏನಿಲ್ಲ, ನನಗೆ ಮನೆಯಲ್ಲಿ ಇರ್ಲಿಕ್ಕೆ, ನಾನ್ ಮನೆಯಲ್ಲಿ ಇದ್ದೇನೆ, ಇರ್ಲಿಕ್ಕೆ there is an order, yes, but ಪಕ್ಕದಲ್ಲಿ ಗಾರ್ಡನ್ ಇದೆ. For the past 50 years.
So you said you are not in that position of that garden.
My lord, he is at Mangalore at a distance of about 80 kilometers from this place, and the suit was filed.
What is that measurement of that property garden?
Maybe about 2 acres of Areka. It is there.
So what is the document to show that it is in your possession?
My lord, it is never disputed. For this reason, suit is filed for partition, and that suit came to be dismissed, against which an appeal was filed by them. Identical that also remanded. After remand, they have not taken steps. Suit came to be dismissed. After dismissal of the suit, the present suit is filed by the very same persons on the very same property. And there was earlier a partition in the year 1966, and there is a preliminary decree, and the preliminary decree is not put into final decree proceedings. And without seeking the final decree, how can they seek again partition of the very same property? 3 times, and there was no interim order.
Get your friend.
Because it is withering away.
Yes, let us see that somebody has to maintain that property then.
Yes.
No, but the problem is that who has to take that crop then?
ಅಲ್ಲ ಅದೆಲ್ಲ ಬೇಕಾದ್ರೆ ಅಕೌಂಟಿಂಗ್ ಮಾಡ್ಲಿ, ಆಮೇಲೆ ಮಾಡ್ಲಿ.
Let him come.
ಬಟ್ ನಾನು ಬೆಳೆಸಿದ ಮರ ಗಿಡ ಎಲ್ಲ ಒಣಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ, and 2 times he failed. Partition of the very same property.
Yes.
Because what happens, admit andre, my lord knows, it will not see the end of the day.
Yes, at least that. Bandrala Jaikar. Yes, Mr. Jaikar. Yes. What is the suit for?
Suit for
partition.
Injunction and partition. Kindly see the plaint, my lord. I have.
Relationship is not in dispute.
That is not in dispute.
Yes.
Relationship is not in dispute. The appellant and the respondents are the children of one Lingappa Muraya. Lord, Lingappa Muraya died on 2/7/99.
Genealogical tree produce
ಇಲ್ಲ ಅದ ಇದಕ್ಕೆ ಬೇಕಾಗಿಲ್ಲ ಬೇಕಾದ
Yes.
My lord, their whole Lingappa Muraya died on 2/7/1999. And they claim that the daughter claimed that he has executed a will on the basis of the will. Then he files a suit for partition in OS number 53 of 2008. Kindly see the plaint at page 1. Page 1 of the separate paper book. All that is placed before the court.
Yes.
Prema.
Filed against whom?
Against me and few others, all family members. All family members. This suit came to be, there is a preliminary decree at page 43. Yes. That preliminary decree is in OS 285 of 1968 between the members of a larger family. There was a decree in which, kindly see page 43. Serial number 4 is Lingappa Muraya. That is our father. He was also a party to the said
Yeah, no,
suit.
this property has fallen your share.
No, it is not. It's a Kutumba share. Divide agilla because preliminary decree matra agirodu. This preliminary decree is has not attained finality by filing a final FTP agilla. Then the present suit is filed at the plain, my lord, saw at page 1. Prayer may kindly be seen. Page page 11. Page 9, paragraph 6, for partition. And
No, why that one more partition suit?
That is why, how can another partition
No,
suit?
you are a defendant or?
I am a defendant. And very same persons file a second partition suit without the final decree being passed there. Now, for partition and division of plaint C and D schedule into 12 fair and equal shares. My lord saw that, then come to page 50, page 72.
No,
Page 7.
you have not filed any application for rejection of the plaint since there is already a partition.
ಇಲ್ಲ. Allala. Then the court went into that. When they filed the suit, court went into that at page 72. Page 70, the suit is.
Three suits, my lord, whether he is referring which suit is a question.
Yes, I will refer to the whichever suit I will refer to.
No, present suit is for injunction, permanent injunction.
Not only for injunction, it is seeking division of properties. I will draw my lord's attention to that.
One more suit was there, that has been dismissed, and in RA, my lord, it has been remanded. I think.
I will step by step, I will take my lord through those proceedings.
Yes.
Now, my friend refers to the earlier suit filed by his clients. That is at page 72. Page 72.
Yes.
This is a suit filed by Prema and Nirmala, the very same respondents hearing against me and others. My lord, I am shown as a different number 2 at the internal page 73, number 2.
No, now that.
Now that suit came to be, kindly see page 102. I will, page 102.
Yes, given me a paper book, my lord, in that it shows 1 to 15. There is some mistake in the.
Not telling.
Plaint, it was produced first, my lord, not 72, my lord. There is some.
My lord, there is no mistake.
Not mistake, there is some mistake, ma'am. Mistake.
mistake may be in numbering, not on facts.
Yes.
Kindly see page 72. That is the judgment in OS 53. of-
72, you don't have a judgment. Page 72.
I have got judgment.
No, 72, that is
Yes.
not this.
Now kindly come to page 102. This is the suit for partition filed by them. Suit is dismissed. Suit is dismissed. Now, would your lordship kindly come to page, against this, they filed RA 6 of 2014. The copy of the judgment is at page 104.
Yes.
This is by Prema and Nirmala.
ನನಗೆ ಬೇರೆ ಬೇರೆನೂ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋ ಡೌಟ್.
ಅಲ್ಲ ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾನೆ ಎಲ್ಲ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತಾನೆ ರೆಲೆವೆಂಟ್ ಏನಿದೆ
ಪೇಜಿನೇಷನ್ ಆಚೆ ಈಚೆ ಇರ್ತದೆ.
Is that is, you give that to proper copy, 2:30 or tomorrow.
Right now.
Monday.
ಅಲ್ಲ ಬೇಡ because I can't see the blanks. My lord, the blanks are withering. What is his object? What could be his objection? Who is not?
See, when you are referring something, he has also.
ನಾನು ತಮಗೆ ಕೊಡ್ತೀನಿ ನೋಡಿ ಅದು ಟ್ಯಾಲಿ ಆದ್ರೆ ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟರೆ
Ink page numbers may be mistake. Facts are not in dispute. Facts are in black and white before this honorable court. My concern is this, my lord. My lord, 4 months and 5 months have lapsed and the plants are withering. My lord, I can't.
Now suit for what?
Suit for injunction and for division of C and D schedule. Kindly see the page. There is no dispute about that.
Where is that plaintiff in this present suit?
Yes.
You are in a plaintiff.
I am the defendant. My
Now
lord.
you have filed in a suit.
Yes.
Yes, where is the plaintiff?
Yes. My lord, copy of the plaint is here. I'll pass on. Prayer is for permanent injunction restraining the first defendant, that is myself. Men, agents or anybody claiming through or under him from trespassing into the A and B schedule properties, that's the garden and the house. Then directing the first defendant to deliver vacant possession of the house. Next, directing the division of the suit sheet, C and D schedule, very same schedule which was earlier division. So basically it is a suit for partition and for delivery of vacant possession, basing their right that they have a right in the family property.
No, in that plaintiff pleading.
Yes.
Have they stated anywhere that they are in the position of that suit schedule property?
I will take my lord, because in a suit for partition, my lord, as the court knows, it's a joint possession.
Joint possession.
Yes. Exclusive possession is not.
Not.
No.
Have you filed in a written statement?
Yes.
What is your stand in the written statement?
That it is the family property and it is to be and they are not entitled for a share.
No, have you stated that you are in the possession of the property?
Yes.
That is.
Have stated. My lord, now kindly come to I was referring to RA 104, my lord. RA 6 of 2014 at page 104.
No, that you just show me that your written statement.
Yes. Not a very. Because I fear that it has not yes, written statement. Not in the written statement, it said that he is in possession. And
Order it says.
he is in possession.
Not find the
And
para 10 ನಲ್ಲಿ ಇದೆ.
ಯಾರು?
ಅಲ್ಲ ಇದರಲ್ಲಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇನ್ನು ಹಾಕಿಲ್ಲ.
ಇದರಲ್ಲಿ
ಇದರಲ್ಲಿ ಇನ್ನು ಹಾಕಿಲ್ಲ. ಬಟ್ ಮುಂಚಿದ್ದು OS 53
ಅದು ಇದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಹಾಕಿಲ್ಲ.
Now what is the order passed by the trial court now?
Yes, kindly see the
what is that IA he has filed?
IA for injunction to restrain the defendant, IA is at page 33. Page 33. The honorable court may be pleased to pass an order of.
Where is that application?
My lord, page 33, along with the appeal memo.
Yes. What is that contention in that? Whether they are stated that he is in the position?
Kindly see the affidavit, my lord, they. No.
It appears that he is in the position. Now,
Kindly see.
your prayer is not to pluck that fruits means you are not in the position.
Only with regard to house, my lord, that is the order passed by the learned trial judge also. I will just explain what had happened.
No, now the problem is
That-
no. See,
Kindly see. So far as possession is concerned, even earlier proceedings also, Arya court remanded the matter and held that my lord RTC entries as per the bill, my lord, registered bill, which has been proved by the finding is that my lord will is proved. So as per the bill, my lord, I have got that both the plaintiffs have got A and B scheduled property. That is my case. And he has also got property, my lord, under that bill. Bill is still there, my lord, it is proved. And both the courts have held that it is proved. So learned judge, trial judge now present suit, my lord, as per the bill and the RTC entries, the parties are in separate possession. And so far as property is concerned, because he has also availed a loan as per the property allotted to him. And the plaintiffs have also allotted availed a loan. There is no dispute in that. Even the judge also observes that.
No.
So far as house is concerned, there is a dispute. So excluding that house, my lord, injunction was granted. So far as A and B is concerned.
no, that A and B is in a Arcanet garden.
Landed property.
No, it's an Arcanet garden.
Please, my lord.
Who is in the position?
That is my as per the bill, my lord, I have been in possession.
No, will
And
may
he
be.
is in exclusive possession of his property. As per the bill. Because that is the whole, even learned judge says, my lord, since the bill has been proved earlier proceeding. So as per the bill, parties are in separate possession. So far as possession of the property allotted under the bill is concerned, they are entitled for protection. So far as the house is concerned, excluding the house, injunction is granted.
No, under that bill, what is the extent of the property?
My lord, sorry for
Wait.
sorry for interjecting.
That is suit
My
property.
lord, they say that there is a bill. My lord, let us assume that there is a bill. But the fact remains that the suit earlier filed has not attained to finality. My father, Lingappa Mudya, is not declared to be the exclusive owner of any property because final degree is not yet passed. Unless a final degree is passed, how can a person say that, carve out a share and say that? That is.
No, Mr.
Yes,
In respect of title is concerned, still it is in dispute. Now to find out the possession.
yes.
See, both are claiming on the will.
I'm not claiming.
No, anybody is claiming on
Yes,
the will.
they have to prove it.
No,
No,
that
it has been proved.
the person who has to execute the will, he has not yet get the property because final degree has not been drawn. That is your case. Now that.
No,
present-
I'm
No.
not that. I'm not-
Now the present situation is,
Yes,
it is only for the temporary injunction.
yes.
Who is in the possession of the
Yes.
property?
Now,
Whether you are.
would your lordship kindly turn to page 42.
Yes.
Page 42. Right now, I will come to that. Government in the affidavit, page 42, paragraph 5.
Yes.
It is submitted that this defendant is in actual possession and enjoyment of the entire suit property. Late father of the first defendant himself was not competent to execute the bill. The subject matter of the suit is the subject matter of the.
What is that document? Should both of them produce who is in the possession?
My lord,
Revenue records.
That is RTC, my lord.
Where is that revenue records to show that who is in the possession? That
my
is.
lord, these are the governments.
No, our benches should be supported by that document.
Yes, and their own statement. Would your lordship now kindly come to the next page of the next paper book, my lord, at page 154.
Yes.
This is the evidence of the respondent, that is the plaintiff in the earlier suit.
No, you forget about
No,
that earlier.
because they say that they themselves say.
154 is not there.
My lord, they themselves say that I am in possession.
Riga, it is a landed property. You show me that RTC as on today, it stands in whose name? They are entitled for that injunction.
Yes, my lord, yes, I will address that. Before that, my lord, kindly see page 155 for a minute.
Yes.
This is the deposition of the respondent number 1 hearing, that is
Yes.
the plaintiff. Page 155, internal page 12, first sentence. ಅವರು ವಾಸವಿರುವ ಜಾಗದಲ್ಲಿ ಸ್ವಲ್ಪ ತೆಂಗಿನ ತೋಟ ಹಾಗೂ ಭತ್ತ ಬೆಳೆಯುವ ಸಾಗುವಳಿ ಇದೆ. ಎರಡನೇ ಪ್ರತಿವಾದಿಯ ಸ್ವಾಧೀನದಲ್ಲಿ, ದಟ್ ಈಸ್ ಮೈಸೆಲ್ಫ್ ಸೆಕೆಂಡ್ ಡಿಪೆಂಡೆಂಟ್, ಅಡಿಕೆ ಹಾಗೂ ತೆಂಗಿನ ತೋಟವಿದೆ, ಸ್ವಲ್ಪ ಸಾಗುವಳಿ ಸಹ ಇದೆ. ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿ 1.36 ಎಕರೆ, ನನ್ನ ಅಣ್ಣನ ಸ್ವಾಧೀನದಲ್ಲಿ, ದಟ್ ಇಸ್ ಮೈಸೆಲ್ಫ್, 1 ಎಕರೆ 93 ಸೆಂಟ್ಸ್ ಜಾಗ ಇದೆ. ನನಗೆ ಕೊಟ್ಟ ಆಸ್ತಿಯಲ್ಲಿ ಸಾಗುವಳಿ ಎರಡನೇ ಪ್ರತಿವಾದಿ ಮಾಡುತ್ತಾರೆ. ನನಗೆ ಹೋಗಲು ಸಹ ಬಿಡುವುದಿಲ್ಲ. ನಾನು ಮಂಗಳೂರಿನಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ. ಎರಡನೇ ವಾದಿ ಸಹ ಮಂಗಳೂರಿನಲ್ಲಿ ವಾಸ ಇದ್ದಾರೆ. ಬೋತ್ ಪ್ಲೇಂಟಿವ್ಸ್. ದಾವಾಸ್ತಿಯಲ್ಲಿ ಎರಡನೇ ಪ್ರತಿವಾದಿಯ ಮನೆಗೆ ವಿದ್ಯುತ್ ಕಂಬ ಹಾಗೂ ತಂತಿಗಳನ್ನು ಎಳೆದಿದ್ದಾರೆ. ಸದ್ರಿ ವಿದ್ಯುತ್ ಕಂಬ ಹಾಗೂ ತಂತಿಗಳನ್ನು ಯಾವಾಗ ಎಳೆದಿದ್ದಾರೆ ಎಂದು ನೆನಪಿಲ್ಲ. All these deposition would prove at an undisputed time before the suit was filed that I was in possession of the property.
This is 2008.
Yes, yes.
You show me that present situation by that artist.
Yes.
Show me that who is in the position.
This is their own admission and they.
No, if you are in the possession from 2008.
No, my lord, not to 2008. Since my father's time.
Even 2008 when the suit is filed, if they are there, you are in the possession.
My lord, RTC may be in the name of my father because it is not divided.
Let me see whether it is in your name or your father name or the defendant name. Then I will decide.
Yes. Also,
kindly have it tomorrow.
Tomorrow better.
Monday. Yes, Monday.
My lord, because every day I can't see the plants being withered. ಮಂಗಳೂರಿಂದ ಬಂದು 80 ಕಿಲೋಮೀಟರ್ ಬಸ್ ಅಲ್ಲಿ ಬಂದು ನೀರು ಹಾಕಿ ಪುನಃ ಸಂಜೆ 4 ಗಂಟೆಗೆ
ಮಂಗಳೂರಲ್ಲಿ ಮಳೆ ಬೇಕಾದಷ್ಟು ಬರ್ತಿದೆ. ಈಗ ಅಡಿಕೆ ತೋಟಕ್ಕೆ ನೀರು ಹಾಕಬೇಕಾಗಿಲ್ಲ.
ಇಲ್ಲ ಈ ಸಲ that is the situation in Coorg and in Dakshina Kannada.
Yes.
I can't see the plants being withered.
Yes, we'll see on Monday. Yes. That who is in that position? Mister, you are not in that. Residing nearby. Let him maintain that property. He should not take up that crop.
We are just maintaining because it is there, my lord.
And equitable remedy is always.
Lordship may kindly see.
See,
he wants to have the entire property of father.
No, it is only for the maintenance.
Your Lordship may
For that taking in a crop, will appoint in a receiver. Let it be kept it in that Tahsildar office. After actioning that product and keep that money, that will do it. After the partition, who are there, they will get it.
And that too in
Right.
that may be.
Yes.
My lord, that is.
See,
I will make my submission.
Once if you not properly maintain that plant, if it is destroyed,
Yes.
then it will take years together to grow.
Somebody should maintain.
And somebody outside.
No, if he is nearby, if he is maintaining, why do you worry? You will get that crop. If it is-
I will convince you. On Monday we will.
It's only to spite.
Everything can be
It's only
decided.
to spite.
Let us see.
Please.
Yes, on Monday.
He wants the root of that will, my lord, so far as his property is concerned. And we delays
No,
the
we are
other.
not concerned all these things. Now that present situation, property has to be maintained. Yes. Yes. Yes.
This matter
Clear for the appellant in the first case. MFA 59.
First case, appellant is there. You are in second case.
both
It's
the
considered connected matter.
Yes.
5198 may Allotment appear your last.
Yes.
I appear, MFA is 57.
What is this?
I have filed application. What has happened, your lordship? Both the appellants, your lordship,
But
both the.
I am the plaintiff.
Whereas the suit has been filed for the relief of permanent ejection.
Hmm.
Whereas the suit schedule property is the site property measuring to an extent of 40 into 20.
Hmm.
Whereas I have filed this restraining the defendants, that is the respondents. Whereas they are the defendants before the trial court. Restraining them, it's not to put up any further construction. Whereas during the pendency of the suit. Whereas immediately, whereas some documents that I have purchased, that is the plaintiff, has purchased the suit schedule property in year 2008, 2008.
From whom?
From my vendor.
What is his name?
It's Vinuta. Whereas the HS Vimala, sorry,
Yes.
HS Vimala. Whereas I have purchased the property on 2/4/2008. Whereas 2/4/2008.
Yes.
Whereas my vendor had purchased the property on 30/11/1992. 30/11/1992. Whereas the originally this property belongs to VR Saina.
Yes.
Represented by the GPA holder, it is very important. One BK Gopal Shetty was the GPA holder to the original owner. He has sold it to my vendor. We have plaintiff has purchased the property on 30/11/2008. After we have purchased the property, it's a vacant site. Adjacent to this property, we have the site and we have already constructed house and residing there. This site, suit schedule property, site number 112. It is very important. Site number 112. Where we are in possession, Kata is standing in the name of the plaintiff, taxpayer, all the documents stands in the name of the plaintiff. All of a sudden, in the month of March 2023, 16/3/2023, kindly see along with the documents, created the sale deed in respect of my property. 16/3/2023, there the document, my that's original owner BK Gopal Shetty. Again, as represented, executed the GPA in favor of Veerappa, that is defendant number 1. Respondent number 1 in the present appeal. He has sold it to the present second defendant, that is respondent number 2 here. In respect of my property, documents have been created. Executed the sale. On the strength of the sale, it created sale. All of a sudden, in the month of vacation, they are trying to interfere with my possession. Immediately, suit came to be filed. As on the date of filing of the suit, suit property is vacant. The court has granted time to comply the office objection. In the meantime, they have started construction day and night. Immediately, we have advanced the matter and filed this application along with the document, restraining them not to put up any further construction. As on the date of passing of the order, they have put up construction ground floor and first floor. Immediately, the IA number 3 that has been filed before the trial court, order came to be passed by the trial court that during the pendency of the suit, the construction had been put up. Therefore, the observation made by the trial court, page 26. IA number 3 filed by the plaintiff order that proceeding with further construction over the suit schedule property, that is second court. This order is not come in the way for the defendant number 2 to complete other major works in the ground floor and first floor.
Yes.
This observation, with regard to illegally, they have put up construction on the basis of created documents. Immediately, an order came to be passed. My submission, Lordship, has considered. Now, construction is completed first and ground floor. They should not enter into the house property because we have the documents and we have purchased in the year 2008. They have no documents. Let there be a not to. They should not enter into the house property. Let them the trial will go on. Direct the trial court dispose.
No, what is that order you are challenging?
Same order. Both we have challenged the same order. But
You are challenging that permission given to further construction here.
further construction and also to complete the measure work. In so far as ground floor and first floor is
No, you
concerned.
should not claim any equity. Let it complete. Tomorrow, if you succeed, you will get back that entire property.
Now, they are not in possession. Already, the building has been locked. No construction has been completed. Let there be a direct trial. But who will succeed? They will get it.
You complete that construction. I will direct them to dispose of the suit.
Yes, yes, sir. But they should not enter into the suit property.
House warrant.
No.
House warrant.
After lordship order has been passed, they are performing the puja immediately. Police complaint has been locked. Now, the entire house property has been locked. Nobody is in possession.
ಆಯ್ತು ಈಗ ಕಟ್ಟಾದ್ಮೇಲೆ let them decide what is their
Absolutely.
No, see, you will say there should not be any further construction.
That is their already so far as ground floor and first floor is concerned. Illegally they have put up during the pendency of this suit. Now it is no, they are not in possession of the property. Already it is locked. Let it be status quo with regard to possession is concerned.
See, let them occupy that. they should not create any further,
Yes, sir.
you know,
Not construct any building.
not further construction, not further
Yes, sir.
alienation.
Let's.
Let them,
My
if
submission
they are
was-
invested, let
We are
them,
in possession.
suppose tomorrow, if your suit is dismissed, are you ready to compensate what? he has
Definitely,
done?
when my suit is dismissed, definitely we will compensate whatever the amount when they have invested. But still then let there be an order of status.
No, if they are residing there, what
Fundamentally,
will cost to you?
They are, let's defendant, respondent number 2 is concerned. Let's on the strength of the created
No,
documents.
that has to be decided by the trial court, whether
But
created.
prima facie court has observed, prima facie court has observed that in respect of very same property, documents have been created by them.
That trial has to
That
be
shows,
done.
blood in respect of one side, 15 years back, we have purchased. Blood taking.
No, we don't know whether your sale deed may be fake.
No,
You
no,
are-
blood, I will
person
say
has-
that my GPA holder, how can they create a one more GPA?
ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾರೆ
ಅಲ್ಲ, GPA to
By
GPA.
the time you are
ಅಲ್ಲ,
reaching your home,
ಅಲ್ಲ,
you see that that is how that's.
Original owner
No,
GPA.
see, from last 2 months, I am sitting in this roster. I think
What is it?
no property in that Bangalore is without litigation.
Without litigation.
Blood, in fact, literally, blood, prima facie.
No, ultimately, what is happening? The person who is creating the documents, who is alienating that property to 2, 3, 4 persons, for them, nobody is prosecuted unless they have to be teased. This will not.
Blood is said literally, consenting
ultimately,
witness, consenting
Person who
witness
has
has received the
purchased
consideration.
by hard-earned money, they are fighting. Person who has alienated that, they are very safe.
ಇದರಲ್ಲಿ ಸೇಮ್ ಬ್ಲಡ್
Nobody is
ಸೇಮ್
going.
ಕನ್ಸೆಂಟಿಂಗ್ ಪರ್ಚೇಸರ್ ಹೋಗಿಲ್ಲ ದುಡ್ಡು ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ has received the entire consideration. GPA holder blood fake address has been given. GPA has been created. ನಮಗ್ ಮಾರಾಟ ಒರಿಜಿನಲ್ ಓನರ್ GPA holder ಅದೇ ಅಡ್ರೆಸ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಇನ್ನೊಂದು GPA ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅದರ ಮೇಲೆ ಬ್ಲಡ್ ಸೇಲ್ 2023 ನಲ್ಲಿ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ ನಮ್ ಪ್ರಾಪರ್ಟಿ ಬೇಕು ಅದು ನಾವು ಪಕ್ಕದಲ್ಲಿ ವಾಸ ಇಟ್ಕೊಂಡು ಸೇಮ್ ಸೈಟ್ ದೇ ಹ್ಯಾವ್ ಕ್ರಿಯೇಟೆಡ್ ದಿ ಸೇಲ್.
Now that I think how you only maintain under that this thing injunction suit, you have filed for an
Blood, I have not- blood already filed the
I want-
application. Blood already filed the application for amendment.
Because
with regard to.
No, I
this is
want-
a registered sale deed.
No, I want to make my submission, Lordship. My learned friend says that I should not be allowed to enjoy my property according to the sale deed executed by the party may not consent. One. Secondly, my lord, after obtaining the injunction order by the trial court, my lord, in the trial court, where the trial court suggested what your lordship now put, my lord, whether you are going to compensate the party in the event of succeeding, not succeeding in the suit.
Yeah.
Court asked him to file a affidavit. Yes, I am going to, going to compensate the party. That's mine. He has not filed any affidavit before the trial court. That is one. Secondly, after obtaining the injunction order, he says that I should not enjoy the property. I am in possession of the property. He is in possession of the property. After obtaining the injunction order, he filed an application for amendment.
Ultimately,
Well,
you
amendment.
are not losing anything.
Anything,
Because
right, but
yours is a vacant site.
yes, but
Yours
no,
is
no.
a vacant site. If you succeed,
Yes.
if you want that, he has to
Allah.
remove everything and give the
Yes.
vacant site or that constructed
No, no.
portions. But for him, if you fails,
Yes.
but if he is invested that money, if he has not utilized that, then he will be. in
Yes.
trouble.
let them produce single document that prior to.
No, it is not matter of trial.
23 said it,
It is
created said it in year 2020.
Well, now he has filed-
Prior to that, single document, let them produce before this court. But I will withdraw, absolutely, my lord, created the documents, my lord, by the local person
No,
to
that
grab
is-
this property.
No, that, see, we can't say that unless it is, because it is in a registered sale deed.
Registered sale deed.
Registered sale deed executed by the GPA holders to GPA.
ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಾ
ಅಲ್ಲ
ಅವ್ರ
ಅದರಲ್ಲಿ ಅಲ್ಲ ಇದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ ಸೇಲ್ ಡೀಡ್ ಜಸ್ಟ್ ಫಾರ್ ಮೂಮೆಂಟ್ ಕೈಂಡ್ಲಿ ಮಿಲಟ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಪರ್ಚೇಸರ್ ಹಸ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ದಿ ಕನ್ಸಿಡರೇಷನ್ ಮಿಲಟ್ GPA holder has not received the consideration received by the consenting witness ಮಿಲಟ್ ಚೆಕ್ಸ್ have been issued to the consenting witness in the sale deed ನಮ್ಮ GPA holder original ಏನ್
Is it prohibited under the law?
yes ಮಿಲಟ್ there is a GPA to GPA unless there is a clause mentioned in the GPA it cannot be an executed and another GPA.
Consideration on the GPA, they can.
There is no consideration. GPA mentioned.
I cannot decide on this.
My submission, but let them, now already the property has been locked by virtue of this order, lordship has granted the interim order. It is status quo with regard to possession is concerned. Let's now let the let's already
By deposit to 50 lakhs here,
Yes.
that compensate that loss we cost.
But let's.
Then
Yes.
we'll direct them to
But
not to utilize that.
But
Because
yes,
he has to take that rented house.
But
He has,
But prior to filing of the suit, if construction has already been started or completed, then pendency of suit, knowing the fact that the suit came to be filed, they have started the construction, pendency of the suit. Then trial court already only one defendant. Let the trial court will dispose of within 3 months. Already evidence has been commenced.
Supreme Court in cases said that they have been permitted to construct. They can also permitted to alienate, but it should be subject to the result of the suit. That's what Supreme Court said. I am restraining in all cases not to alienate.
But in case
If they are constructing, let it construct, because if you are unsuccessful, then that benefit will goes to them. If you fails, you can get it back everything. You will not losing anything. That is how that in all cases.
Admittedly, the sites in Partition are the revenue sites, your lordship, informed in the entire layout, your lordship. One thing. Secondly, what by Allotment has purchased, kindly see page 52, my lord, for a moment.
Just
The appeal itself is liable to be dismissed.
If he is allowed to reside there,
Yes.
how it will affect your
He
life?
is already residing
That's
under the same.
see, it is not your case that you are already taken the permission, you have taken a loan, you want to
No,
construct.
all documents stands in the name of this plaintiff
No,
only.
present situation now that
They have no
These are-
documents at all. They have no
He has
documents at all.
constructed.
Separate
Except
Kata has been
Malad,
given by the
create-
corporation.
Malad, except created said it, nothing, they have no documents at all. Kata Malad from since 2008, Kata standing in the name of the plaintiff.
ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ನಾವು ಲೋನು ತಗೊಂಡಿದ್ದೀವಿ.
yes, 230.
We are residing, your lordship.
Yes. Thirty-seven, ಏನಾಯ್ತು? ಏನ್ entry ಮಾಡ್ರಿ ಇತ್ತ ಮೊದ್ಲು? Yes, entry ಮಾಡ್ರಿ granted earlier is extended. If any is extended. till the state of-
My lord, serial number 58, my lord, for the respondent, I informed that.
Connected cases are there. Tomorrow, my lords.
58.
ಅವ್ರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ 2:30 ಏನೋ ಇದೆಯಂತ ಅದಕ್ಕೋಸ್ಕರ ಕಮ್ ಲಾಸ್ಟ್ ವೀಕ್ ಮೈ ಲಾರ್ಡ್ಸ್
Monday.
Monday. Tomorrow, my lords.
Tomorrow some other matters are there. Monday.
Tuesday, my lord.
Monday is
Monday.
Tuesday, my lord.
Tuesday.
Monday.
Tuesday. Yes.
Lordship, kindly serial number 62, please.
62.
After vacation.
62. Yes.
Serial 62, please.
62 are respondent.
I am for the respondent.
Yes,
I am for the,
Mr.
he is for the.
You have no objection. Yes.
Entry moderate to continue.
The request of the parties read this matter after 2 weeks. Interim order granted earlier, if any, is extended till
Please.
next.
Serial number 36, my lord. This has been complained. This is the matter.
Tomorrow. Yes, leave this matter. Complaint. Yes, leave this matter tomorrow or Monday. Monday, yes.
Thank you. ವಾಪಸ್ ಕೊಡ್ಬೇಕಂತೆ ಅಪ್ಲೋಡ್
Serial number 27, my lord. I'm sorry, my lord, I was not present when the matter is called out.
Yes.
There was an interim order till date, my lord, it may kindly be extended.
Already signed, huh? For retirement allotment. Let us see if there is any possibilities, we'll
Yes.
interim order granted earlier, if any is extended to next year.
Sorry, my lord, I was. Serial number 64. 2 weeks time may be granted. Respondent in this case.
64.
64, lordship.
Yes.
I am for the respondent. 2 weeks time may be
We had
granted.
to file memo, my lords. We had to file memo. I'll file.
File it in that
Registry.
office. Registry.
Yes, my lords.
Yes.
And in connected matter, we have already served the copy.
You are taking notice in that connected
Yes,
matter.
yes, lordship.
ಎಷ್ಟು ಜನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ ಒಬ್ರೆ.
Obre.
Yes. But here is undertaken by a power for respondent.
We already served the copy.
Office is directed to show his name. ಅದು 64.1 ಅಲ್ಲಿ.
Interim order may be extended, lordship.
Is this at the request of counsel for the petitioner in 67/2023. This matter of 2 weeks. Interim order granted earlier, if any, is extended till next month.
I appear for this matter.
Yes, let him file an affidavit before that trial court, undertaking that. In case you file an affidavit, is that in case if he fails.
So before that, I will do
claim
that.
any equity and without any obstructions, you have to leave that premises.
Yes, I will do that, your lordship. My lord, may kindly see the conduct. I wanted to, since my allotment was arguing the matter, I did not matter.
They should not indict any third parties.
That's what, you will not
No,
create third party.
I have built my house.
Even
not
they should not
for
indict
my-
any third party
No, no,
tenants
I-
also.
I have built my house for my living, not to let it out.
Yes, yes. that
I
will protect.
will just bring it to your lordship's kind notice to the conduct of this, to show the conduct of the appellant before this formal court.
Yes,
Kindly see, my lord, kindly note this, your lordship.
yes.
The sale deed, my lord, according to them, my lord, purchased the site number 1112, my lord, 112 on 2/4/2008.
Yes,
Kindly come to the schedule, your lordship.
yes.
What is the extent which they have produced? Why I should give affidavit, my lord, of undertaking is this
Yes.
could be, no, this could, page 25. Page 25.
Yes,
Schedule, your lordship, kindly see. Well, allotment did not disclose this extent of land, my lord, which he has purchased, site which has been purchased.
25.
25 in the sale deed. Schedule,
Page.
page 25, your lordship.
24.
24, yes, 24.
Schedule.
Schedule, 1 minute, 1 minute.
No.
Schedule.
You are referring to that which.
5198.
ನಮ್ಮ
ಅವ್ರದೇ appeal ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಕೊಡಿ. ಇನ್ನೊಂದು ಕೊಡಿ.
ಇರ್ಲಿ ಬಿಡಿ. 2/4/2008, they appears to have purchased the property from one Vimala,
Page number.
page number 70. Document number 1.
24, sir.
ನಿಮ್ 24. ನಿಮ್ದು ಶ್ವೇತಾನು ನಿಮ್ದು ತಾನೆ ಕೇಸ್ 5198.
Additional documents.
ಇದರಲ್ಲಿ 25. Schedule, my lord. Date of sale in their favor.
Ilri, it's not matching that this thing, paginess.
Yes. ನಮ್ಮ objection ಅದರಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ. ನಮ್ಮ objection ನಮ್ಮ objection ಇದೆ ಇದ್ರಲ್ಲಿ. 5198 ಅಲ್ಲಿ we have filed our objection on 20th September 2023.
Yes.
Kindly come to the sale deed, my lord, which is in their favor. Page 70. 2/4/2008, my lord, is the
70.
17.
Yes.
2/4/2008 is the sale deed.
Yes.
Under which, my lord, they have purchased the property, my lord.
Yes.
Extend, my lord, may kindly come to extend, page 25. Admittedly, the entire area is the revenue pocket, my lord, where the layout has been formed.
Yes.
page 25, the schedule, my lord.
Yes.
The extent which is said to have been purchased by them, my lord, 1,350 square feet. This is relevant, my lord, to be noted.
Yes.
In that, my lord, the boundary which is said to have been given, my lord, property bearing east boundaries, my lord, as shown in the schedule.
Yes.
By pursuant to this sale deed, without obtaining any license, without from the competent authority, they built the house in 2013. In 2013.
Yes.
After 2013, my lord, they did not do anything in the matter. After lapse of 15 years from the date of original sale deed purchased by them, after lapse of more than 8 years from the date of 10 years from the date of construction of their building, my lord, they go to their vendor's vendor to get the registered sale deed rectified. And in that, my lord, by that time, Kata, everything was changed in our favor, your lordship. Now kindly come to their rectification.
When that rectification.
Kindly see, my lord. Mane building cut 8 ವರ್ಷದ ಮೇಲೆ sale deed ಆದ 15 ವರ್ಷದ ಮೇಲೆ they go to the vendor's vendor, not the vendor. 16th March 2023. They have built the house they are living in an extent which they have purchased.
Now what is that?
Now they want to knock off my property, my lord. By getting this rectification deed.
What is the rectification?
Yes, page 48, your lordship. Page 48. Sorry, 26. 26, madam. Kindly come to page 32, madam. How got it? How they got the extent, my lord, reduced? 32. 32. Schedule, my lord, kindly see. Instead of 1,350 square feet, which they have said to purchased under sale deed dated 2/4/2008, my lord, it has been synchronized to 990 square meter to suit to my extent. They got reduced the site. ಮನೆನೂ ಹಂಗೆ ರಿಡ್ಯೂಸ್ ಮಾಡಬೇಕಲ್ಲ ಮಾಡ್ತಾರ ಅಂತ 1,350 ಮನೆ ಕಟ್ಬಿಟ್ಟಿವು.
Now whether that house has been constructed into that entire extent.
ಅಲ್ಲಿರುವುದೇ ಏನು ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ, ಒಂದು ಚೂರು ಸೆಟ್ ಬ್ಯಾಕ್ ಏನು ಇಲ್ದೇನೆ ಕಂಪ್ಲೀಟ್ ಮನೆ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. 1,350 ಕಟ್ಬಿಟ್ಟು ಮನೆನ ಅಂಡರ್ ದಿ ಸೇಲ್ 2/4/2008. How can they get a rectification deed from their vendor's vendor? Again, ಪೌರ ಪಟಾಟಿ ಹೋಲ್ಡರ್ again ಪೌರ ಪಟಾಟಿ ಹೋಲ್ಡರ್ ಮೂಲಕನೇ they get it rectified, saying that 990 square feet anta. This is the extent which has been purchased by us to suit to their convenience, to knock up my property also, in addition to the property under which he has built the house under the sale deed dated 2/4/2008. This rectification has been, deed has been obtained. Whether it is permissible under law after 15 years after constructing the land, constructing the building under their sale deed. And Kata has been changed in my favor. And now, my lord, after obtaining the injunction order, my lord did not disclose the fact, my lord, properly. He has filed an application for amendment in the suit to convert the injunction suit as a declaration suit, saying that declare that he is the owner of the property under the rectification deed. Yes. And who is the owner of the property in respect of sale deed by dated 2/4/2008, where he has built the property? That is one issue. Second issue is, your lordship, another issue, the property, my lord, which you have purchased, the application filed, my lord, we have sought for declaration and for recovery of possession, saying that I am in possession of the property. He admits, kindly see page 88, amendment application which he has filed, my lord, it starts from page 82, document number 7. 82. Kindly see the conduct, my lord. He files an application after obtaining the interim order in the suit filed by him, and after the order passed by the disarmal court also, seeking declaration. Kindly see the page 88 to declare that the plaintiff is the owner of the suit scheduled property. Andre ಈ 990 ಗೆ.
Yes.
Not for 1,350.
Yes.
He asked for declaration in respect of my property. He wants to knock up my property along with his property, which is the subject matter of the sale deed dated 2/4/2008.
Yes.
Under the guise of rectification deed obtained by the vendor of the vendor. Yes. Whether it is permissible under law, my lord, is the question. And the second prayer, my lord, to direct the defendant number 2 to hand over the possession of the suit scheduled property in his favor. He admits that after filing the suit for injunction, that I am in possession of the property. After getting the injunction order, he admits that I am in possession of the property, therefore recovery of possession has been sought. Then what is his locus standi, my lord, to file a suit under the rectification deed. Therefore, why I should be given undertaking, my lord, that I should not let out the property. He is enjoying his property. I am entitled to enjoy my property to the extent purchased by me.
Yes.
Let him get a declaration that he is the owner of the property. He cannot restrict me from not to alienate the property, not to enjoy the property, not to enter the property. I have invested my hard-earned money.
Yes.
I have purchased the property. Therefore, this is the conduct of the appellant in MFI number 5198 of 2023.
Yes.
It is in that regard only, my lord, in the trial court rightly asked them, you deposit an amount by filing an affidavit. He did not, but he challenges the very same order here. He wants to enjoy his own property and also try to knock off my property also under the guise of rectification deed. Where is the title passed in his favor? Under what deed right has been passed, my lord? In respect of 990. In respect of 990 square feet, which is the subject matter of my sale deed, he gets it synchronized to the extent of that. And he built the house in his own extent, 1350 square feet. You want to, that property, this property, both without any money, without paying any money. Why I should stop my construction? Why I should not enjoy my property is the question you will ask. That's nice. Page 25 sale deed referred. If I have already constructed the building, where is the question of they are constructing the building in my property? Page 25 may kindly see.
Yes.
The question is before the trial court, the subject matter of the suit is respect of site number 100. That is not in dispute.
Yes, I pass an order.
Yes, sir. But before that, just to clarify, because the correct facts are not
unnecessary and wasting the
correct facts have not been brought to the notice of.
I am not recording anything. I'm not recording anything. I will modify that order saying that he should not create any third party interest.
And they should not index.
He should not claim any equity.
But immediately after this.
No, he should not create any third party interest, including that he has not leased out property to
No,
anyone.
now, my lord, in case, my lord, if the suit decree, they have to hand over the possession.
Not to claim any equity.
No,
Yes.
my lord, Calagada shop already put this for me now.
No, whatever that.
They have not given any shop. They have not, still, my lord, it is locked, already there is an order of injunction. First of all, my lord, he has no locus standi to question the validity or otherwise of enjoyment of my property, my lord. Leave it to the lordship, my lord. Subject to what I said now, my lord. In 990 square feet where I have built my house, my lord. I am ready to enjoy, I am entitled to enjoy the property. I am ready, entitled to let out the property because I have invested the money.
Yeah,
And I have to borrow the loan also. I have borrowed the loan also, my lord. I have to.
No, he can.
ICICI
but
Bank.
He can't alienate.
Yeah, I will not alienate your lordship.
But he has to undertake that if you.
I will not sell the property, my lord. Suppose maybe recorded shops of it let out to the third parties. They will not vacate the premises.
No,
In
that
case
he has to file an undertaking that he has to.
Only second dependent can reside in the house, whatever the house. He cannot dictate the. He cannot indicate third parties and that if the tenants have been entered into the possession, they will not again multiplicity of proceedings. No. Kindly their document, page 48, for a moment kindly see, sale deed, page 48.
Yes.
They are relying upon this.
Why you have rectified that?
18 years. Rectification. Constructing the building. 1 second. Rectification not in respect of site, site number and extent. Still that is remains. Rectification only in respect of the extent only.
That is okay.
Not to so.
Site number will not be
The
changed.
site number we have purchased, it has not been changed. Nam sale deed aadmele. 112 site.
112 you said you have purchased 1,100.
350 square feet.
Yes, you have obtained the plan and
No
constructed.
plan illa. How plan not in respect of this property. That is in respect of site number 113. Before the trial court, they are misrepresenting in the court that we have constructed long back in so far as 113 is concerned. 112 it is vacant site. Subsequently, my lords, they have created in respect of my property, that is page 48. Kindly see for a moment, page 48. Their sale deed, how they have created. 130 page 48, they have produced the sale, their sale deed.
No, where is that Any document to show that 113 you have purchased?
Yes, my lord.
Yes, my lord, we have.
Consulted on the area.
That is not.
Let him show now.
113 is concerned, but that is
No,
not in this code.
113. Whether you have purchased
That
it
is
or you are in
Well, I have
a.
already constructed the house
Ah.
and yet, we are residing there. 112 also we have purchased in the year
I
2008.
say you just answer my question.
Yes, my lord.
If you have purchased also, all person has to keep their title deed.
Yes, my lord.
What is that sources of?
Yes.
title in respect of it?
113 is concerned, but it is not in this code.
I three
No,
non.
But I will produce that stated. I have the stated.
Yes.
ಅದರಲ್ಲಿ ಮನೆ ಕಟ್ಕೊಂಡು ಬಂದ್ರೆ ಸುಮಾರು ವರ್ಷದಿಂದ ವಾಸ ಇದ್ದೀವಿ. But my lord, they are misrepresenting that 112 they have purchased. So subject matter of the suit property. My lord, 48 page, my lord, kindly
No,
see.
I understood. You have purchased
My lord, ಇದರಲ್ಲಿ
113.
my lord,
You have constructed that.
yes, my lord.
After that, you have also purchased 112.
Prior to my lord, 2008 we have purchased this 112.
No, 112 also you have
113
purchased.
is concerned. Already we have constructed the house and residing
Where
there.
is
That is not in this code.
Where is that
My
document?
lord, I have produced the set. That is not in this code. 112, 13 we have produced the set.
You produced that.
Yes, my lord, we have said, my lord, before that, not they said it just for a moment, how they are missing, even before the trial court also. My lord, page 48. 48, my lord, they are said it.
Yes.
My lord, kindly see, the owner is, my lord, one VK Gopal Shetty according to them. My lord, VK Gopal Shetty, the same address residing at number 7 RK Puram, so and so, so and so. He is not the owner of the property, he is the, let's the GP holder, but the first document. He is the GP holder to the minutes, original sale date 30/11/1992, what we have produced, my lord. VK Gopal Shetty, then my lord, he has represented, he has executed the GP in favor of this one Veerappa.
That's correct.
My lord, kindly see,
No,
the
that
same
is-
day,
It's all correct.
nothing, my lord, nothing has been produced to show that.
112 is concerned, there is a dispute. You are also saying that you have purchased, he is also
Well,
purchased.
they have purchased.
Now, only thing is that to put him in a condition that we
Yes.
should not give it to that any. But
I will not sell the
to show
property.
that 113 you have
Yes, my lord, I have the
purchased
document.
and you have constructed.
Yes,
in accordance
yes.
with that, then
Yes.
you put in convert.
Yes.
That is the say.
The 113
not-
113 is concerned, but long back we have constructed, let him residing
Let him
there.
produce.
We have all the documents.
Yes, when you approve. Tuesday,
That's
next week.
It's 3-4 days.
Yes. Well,
12th or 13th.
In the meantime, my lord, ನಾವು ಮನೆಗೆ
No.
ಗೃಹಪ್ರವೇಶ ಆಗೋಗಿದೆ.
Lordship, already
ಅಲ್ಲ,
passed an order,
ಗೃಹಪ್ರವೇಶ-
they should
No, no.
not enter into the possession. Now immediately they want to occupy the
ಗೃಹಪ್ರವೇಶ
possession.
ಆಗಿದೆ.
And my
ಗೃಹಪ್ರವೇಶ
lord,
that we will have it on Tuesday.
Tuesday better. 12th,
ಮಂಡೇ ಇರಲಿ ಸ್ವಾಮಿ.
12th, my lord.
ಅಲ್ಲ, ಅವ್ರ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಇದ್ರೆ ನಾಳೆಗೆ ಕೊಡ್ಲಿ.
12th.
No, that 10. Yes, use this
Please.
matter on 10. Yes.
That's so- For not for partition and separate position
Yes.
in respect of 58 items, ma'am.
You are the plaintiff for a defendant.
But I am actually earlier, I am the 15th defendant. But you lordship, can you take page 84, madam? The earlier plaintiffs, 20 to 22, now defendants, they have withdrawn the suit.
Yes.
Thereafterwards, my lord, I filed an application at page 84.
Transposing as a-
84.
Hmm.
84, my lord.
Hmm.
DW 15 has filed the present application under order 1 rule 10-1, Draft order 23 rule 1 of CPC and 151 CPC seeking transposition of DW D15 as plaintiff. The plaintiffs have filed the present suit seeking partition and separate possession of their share in suit properties. They have also sought to the gift deed dated so and so executed by D1 in favor of D11 is not binding on them. D15 in their affidavit has contended that Anka Reddy is having 2 sons, Papa Reddy and Ramaswamy Reddy, and 5 daughters, and family members of the sons of original proposed themselves have filed the present suit without impeding the daughters, and later she has got impeded in the suit. DW15 has contended that now both the members have partitioned the suit properties through the registered partition deed, and plaintiffs now have filed a memo for not pressing their suit. They have filed a memo. In the suit, admittedly, DW is claiming to be the daughter of the original proposed Anka Reddy.
Yes.
The proposed defendant number 15 has also sought the counterclaim seeking partition and separate possession of her share in the suit properties. The plaintiffs in the suit filed a memo for not pressing their suit. In the facts and circumstances of the case,
IA filed by defendant number 15 is just to be allowed. Accordingly, pass the following. IA number 12 under order 1, rule 20, rule 10(1), read with 23, rule
Yes,
1A.
you have been transposed as an,
Defendant,
yes,
plaintiff.
yes.
And where the original plaintiff, they have been treated as respondent number 22.
Yes.
But now, after withdrawal of the suit, this defendant number 19 entered into a JDA on 27/8/2020
In respect of that very suit scheduled property.
in respect of 6 properties.
Yes.
6 properties.
No, that is also suit scheduled properties.
Yes, my lord. Yes, my lord. The admitted factor. And I filed an application. But issues have been framed by the trial court. But I filed an application. My lord, restraining the defendant number 19, who has entered into JDA with the contesting defendants. My lord, not to develop the property, not to alienate the property till the disposal of the suit. And my lord, earlier, when the original plaintiffs have filed the suit, they have not implemented me, and my daughters also they have not implemented. And immediately after my transposition as plaintiff, I filed an application to come on record, to transpose as plaintiff, and I filed an application again at defendant number 19, not to develop the property, not to sell the property. A learned real judge at page 23,
Yes.
23, my lord, he said, my sisters have not been made as parties to the suit. Therefore, injunction application is rejected, no prima facie case is made out. Para 7, page 23, my lord.
Yes.
The page 20, page 23, para 7, son.
Yes.
The transposer plaintiff has filed this IA against the purchase of the defendant number 19 contending now. The defendant number 19 is making active efforts in order to develop the suit properties 19, 21 to 23, 28 and 29, and also is ready to alienate them to third parties. The transposer plaintiff has filed a written statement claiming counterclaim. The transposer plaintiff, along with her counterclaim, has also furnished a genealogical tree. The genealogical tree furnished by the transposer plaintiff and the written statement governments make out that Anka Reddy and his wife Jayama have died, leaving their 2 sons, Papa Reddy and Ramaswamy Reddy, and 5 daughters, namely Narsamma, Gauramma, Ramakka, Akkayamma, and Sarojamma. Sarojamma is the transport defendant. The transport plaintiff hearing. The plaintiff have filed the suit contending their father Ramaswamy and the defendant number 1, both are brothers, and they are in undivided joint family, and on the basis they have filed the suit seeking partition, but on the other hand, they stand of the transport plaintiff is different. The transport plaintiffs have contended that their father Anka Reddy has died, leaving his 2 sons and 5 daughters, and she is one of the daughters, and the plaintiff have filed the suit without including them, and as such, she has been included in the suit. The parties who come to court seeking relief must arrange all the necessary parties and then only their claim can be finally adjudicated on merits. In this case, transport plaintiff has come to court and she has been included in the suit, but if the suit properties are to be partitioned, the legal days of Anka Reddy as per their case, or in an undivided joint family, and even the daughters of Anka Reddy are entitled for share, then other daughters, namely Narsamma, Gauramma, Ramakka, Akkayamma, are necessary parties. If they are not alive, their legal days are necessary parties to the suit. So, without other 4 daughters, and if they are not alive, without their legal age, suit cannot be finally adjudicated. Therefore, in this lecture, I am of the opinion that if an interim order restraining the other side, either developing or from alienating suitable property is granted, certainly it would put them irreparable injury. Therefore, I am of the opinion that.
No, you are a builder or an.
I am a builder, developer. But my, but see,
And
two items are about
trial court has framed the issue. There is no issue like suit is bad for non-joint of necessary parties.
No, in the partition suits, court can direct them to implement them as a
Correct,
party.
correct. Let them.
It's
Court
the
has not.
duty of the court.
House madam.
That is what that in the partition.
Yes, my lord. Court has not directed me to implement. Court directly dismisses my application, holding that
No,
necessary parties are not added.
Suit cannot be dismissed on that ground.
Yes, my
Can
lord.
be directed to implement that
Yes,
party.
my lord. Yes, my lord. That is the question. And what he says is, since.
No, what
But
is that when you have purchased this property?
my fair submission is not, there are about 57 items, which is nearly 100 acre of land, the entire scheduled property block. Now, this defendant has entered into a joint development agreement where I am entitled for 40% of the share, developer share. Now, the suit items, that is item number 21, 22, 28, 29, 19, comes around 1 acre 10 guitas approximately. But in fact, kindly peruse the page number 96
98 affidavit filed in support of the application, Lord. Irrespective of the contentions that, so there was a partition, all these things, Lord. Prima facie, my fair submission is not their affidavit at page number
No, what you want
98.
to say that even then that if there is a partition, his share will not be affected. That's what you are saying that.
Lord, they themselves in the affidavit, Lord, in the affidavit second
No, that-
page, Lord.
No, what is you are the developer? What is the stage? When you have
Lord, it is
purchased?
already developed, Lord. I can place the photographs on
When
record.
you have purchased?
Lord, I have entered into a joint development agreement in the year
2020, my lord,
20.
27/8/2020.
But the roads.
And this one is pending.
The development works almost completed, Lord.
No,
We
but
have entered into
no,
a sharing
you
agreement.
develop it, but you should not create third party interest.
Lord, my-
Otherwise, the
Lord,
purchaser will be that trouble. You
Lord,
do it.
I may be permitted. But for a moment, the affidavit filed in support of the application, that is page number 96, 98, Lord. 99, that is the para number 4.
Yes.
Lord, para number 4 is in the bold line.
Correct,
So
correct.
from last three lines, Lord.
97,
97.
98, affidavit.
Affidavit,
Hmm.
para number 4, Lord, next page.
Hmm.
But in the bold line, 3 lines from bottom, if this honorable court comes to conclusion that the plaintiff is entitled for any share in the suit item number 19, 21, 23, 28, 29, that is in respect of which I have entered into a joint development agreement, then this honorable court may please to allot the alleged share of the plaintiffs in the 60% of the cited area of the owners / defendants, so on, so on, so.
It is
But my
written-
submission is,
How the-
one ನಿಮಿಷ, sir. But my humble submission, it is not my written statement, it is a case of the petitioner.
ಅಲ್ಲ 19 ಅಲ್ಲಿ ಏನ್ ಮೇಲೆ ಓದಿಲ್ಲ ನೀವು.
Sir, this
Return
affidavit is
statement
filed by
filed by defendant number
Sarojamma.
19.
Sir, this affidavit filed by Sarojamma.
Yes.
But what the present plaintiff has contended that if at all, the plaintiff is entitled to share in this property, so she may be allotted out of the 60% share, because I am entitled for the 40% share. Lord, my submission is, Lord, the entire extent of the schedule in the IA that comes to 1 acre 12 meters, Lord. Assume for a moment the plaintiff is entitled for the share, even then
No,
she's
that's I
entitled
understood that.
around 7 guntas are claimed.
You say that only to that extent of your vendor's share, you may be permitted to develop, that your vendor's share will become to that 40%. Remaining percentage you can be.
Lord,
See, let that
Lord,
notice to
one
be.
submission. Lord, her entitlement, Lord, she is claiming 1/7 share. Anka Reddy is having 5 daughters, 2 sons.
Yes.
She is claiming 1/7 share. If she is at the most, she may entitle for 7 guntas, not more than that. In respect of the items of the JDS, at the most she may entitle for 7 guntas. Lord.
What is
So,
the total extent?
The total extent is 1 acre 12 guntas. Lord.
1 acre 12 guntas. Yes, you are saying that we will leave off that 7 guntas and remaining can be permitted to do it.
That arrangement also may kindly be.
See, let that others to be served. See, till then, you can proceed with the development, not to create third party interest. If all that served, then they are agreed that yes, this portion of the properties will
May-
not.
May
The
make
similar
another.
matter in the, like that only that 2 days back, that one matter has been.
May
settled
make
with the
another
parties.
submission.
Senior counsel Krishnamurthy was appearing.
May
He said
make-
that his portions of the property,
Yes, my lord. Yes, my lord. I agree with
ultimately, if he succeed in the suit,
Lord, I
he will
understand.
entitle for.
Only one submission. Lord, in that event, Lord, a particular item, Lord. Admittedly, if she succeeds, she is entitled approximately 7 guntas.
See, you are,
Lord,
wait, I understood. You are only a purchaser. Other shareholders has to be appear before the court. If they are agreed, see, we are ready to giving up that. Then the remaining extent, if they are ready to give up that builder, you develop it, remaining is property. Even if you succeed in the suit, he is extended for his only 1/7 share. You bifurcate that 1/7 share after consultation, leaving that portion, you develop it or you alienate it.
Lord, I
Let them
understand.
appear.
Lord. Only one submission, Lord.
Yes.
Out of 7 guntas, after development, she is entitled for maximum 2 sites, not more than that. After development. But my submission is, Lord, instead of passing a stay order in respect of the entire item, Lord, a particular item,
I will
Lord,
say,
particular item which
I
measures
will
12
restrain,
guntas,
I will restrain you to not to create third party interest till the service of notice. Yes, after service of notice, even next week, if all the are appear, they are agreed that we have no objection to give our share to the builders. His share will be determined and he will be agreed that, see, because property has to be marked and showing that. Suppose if you leave that 7 guntas, if it is a useless land, then he cannot be.
Blood. Now we have entered into a sharing agreement. Blood, my submission is at the stay may be passed in respect of not my share. Blood. Let the stay.
No, what you want to
because
do,
they are entitled for 60% share. Blood.
no, that other has to come before the court and say, see, what you want to do within 2 weeks.
Blood, because I have invested crores of rupees to
You
develop the
it,
property.
You
Blood.
develop it. What you want, you have to construct.
Blood, I may have to,
site
blood,
formation.
blood, I may have to enter into agreement of sale because to generate the funds. Blood, because I have invested huge amount. What my submission,
service.
blood, out of 60% of the owner's
Are you
share.
taking notice to other respondents?
No, blood,
Then they have to. come and say-
or else I'll take instruction. But if it maybe on Monday, blood, I'll take instruction. But yes, that can be clear.
If
The
all
problem
they
may be solved.
appear and you show me that east extent, which is the properties which we is giving to him. If he is satisfied that, yes, then remaining properties, you can do it. If they are agreed that to alienate, you alienate it, you mortgage it, whatever you want. Ultimately, if you succeed, he is entitled for 177. That you have to demarcate in his present. Then you have to do it.
Till then, let till Monday not alienate ಮಾಡದ್ ಬೇಡ.
Till
ಅವ್ರಿಗೆ
then-
ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ನಾನು ಅಗ್ರಿಮೆಂಟ್ ಅಂತಂದ್ರೆ ಸೈಟ್ ಮಾಡೋದು ಅಷ್ಟು ಈಸಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ನನ್ಗೆ ಏನಂದ್ರೆ ಪರ್ಟಿಕ್ಯುಲರ್
alienate ಮಾಡ್ಬೇಡಿ.
Now, Mr. Council, if you say, I will instruct your parties that till Tuesday, you will not create any third party interest. I will not pass any interim order.
my
In 2 days, if you are ready to do it in pendency.
ಅದು ಆಗೋದಿಲ್ಲ. ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ ಮತ್ತೆ
ಆಗೋದಿಲ್ಲ ಅಲ್ಲ, you have to assure before the court.
blood, I take the instruction whether we can appear on behalf of the landowner or not. I'll take instruction. Blood.
You take instruction.
My submission is blood
See-
for 2 days. Blood, it is blood. Monday it may be posted. Blood.
Till then, and you should not create third party interest in between today and Monday.
In 2 days ಅಲ್ಲಿ ಏನು ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ, ನೀವು assurance ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ assurance ನಾವೇನು
That's
ಮಾಡೋದಿಲ್ಲ.
what that I am saying that you given assurance. Yes, I am not recording. If you say before the court that you will not do it, I will not record. Yes, Monday.
Tuesday may
ಅಲ್ಲ Tuesday ಬೇಡ.
Tuesday. Monday ಸ್ವಲ್ಪ
Wednesday.
Wednesday.
Please. Is this matter on Wednesday?
56 are there. Same order.
56 on Wednesday, yes.
For that.
Yes, yes,
Now, this is a suit schedule property.
yes.
And 19
Suit for?
suit for partition.
Yes.
According to the plaintiffs.
Hmm.
In fact, 1970, now the appeal is from the defendants 8 and 9.
Yes,
Admittedly, as on the date of suit, that is, I have purchased this property
Hmm.
on 21/11/2022. Suit came to be filed on 19/1/2023. 2023.
after your purchase.
Yes. And but admittedly, this suit is for a partition, as if there is a vested particle interest in the suit property.
Yes.
In fact, it is my absolute ownership.
Yes.
Now, 1973, this site, a residential site, came to be allotted by the Chickpet House Building Cooperative Society,
Yes.
as back in 1973.
Yes,
After that, the one K.V. Shetty, the allottee,
yes,
had gifted the property, half of the property on 7/6/1999
yes,
in favor of his 2 daughters.
Yes.
Now the sons are before the court. Now again, my lord, balance portion of that property, your lordship sees the very plain itself.
Yes.
A schedule property is the entire property.
yes,
Kindly see. B schedule property is a gifted property in favor of his daughters.
yes,
Now they contend that so far as the balance portion, which is described in C schedule property, is the joint family property.
Yes.
First of all, your lordship, it is an allotment by a society.
Yes.
There cannot be a concept of joint family in respect of half portion of the property.
no, what is the measurement of the site which is allotted?
First, my lord, 75/55.
75 by 55.
Yes, my lord, A schedule property, kindly see.
ನಿಮಗೆ ಎಷ್ಟು ಸೇಲ್ ಮಾಡಿರೋದು?
ಅದು ಅಲ್ಲ, ಮತ್ತೆ 7/6/1999 ನಲ್ಲಿ my vendors, then the daughters of that, they are my vendors. They were allotted, gifted, admittedly half portion is gifted,
Gifted, yeah.
34.55 feet. B schedule ನಲ್ಲಿ ಅಲ್ಲಿ ಅದರಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ gifted ಅಂತ.
Yes.
ಈಗ C schedule property ಬರುವಾಗ, in fact what has happened is that KV Shetty had executed a will in respect of balance portion of his property as back was on 5/11/2007.
ಯಾರು
ಅದೇ balance father that allotee. Sir, ಅವರ ಈ half share gifted it ಕೊಟ್ಟರು without there being an objection from any of the sons.
Yes.
Then again on 5/11 during his lifetime, on 5/11/2007,
Yes.
he 1/8/2002,
Yes.
he executed a gift deed in respect of C schedule property.
C schedule.
Yes. Then on 5/11/2007, he died.
Yes.
So the joint legatees, the two daughters have become jointly the owners.
Yes.
And there was a partition amongst the children on 11/7/2008.
Yes.
They do not speak anything about this.
Yes.
But after that, on the basis of the joint big fest,
Yes.
I got partition, my lenders, on 25/5/2009.
Yes.
Kindly see, ever since 2009, my lord, Tata stood in the name of our vendor, there is no dispute. Now, on 21/11/2002, there's the present appellates, that is defendants 8 and 9, they sell it on 21/11/2022. And it is thereafter, the Kata is from 2009 to 2022, corporation records are there. So then, after the appellate, after 21/11/2000, what they say, the brothers, that it should be restored in the name of father. In fact, the will has been acted upon, they are aware of that will.
Yes.
Then the suit came to file for partitions. Now, I have no difficulty about the fact that since it's a suit for partition, they will get sure only if my sale deed is set aside.
Yes.
But notwithstanding that, I have no objection that the property shall not be alienated.
Yes.
I have no objection. Now, here 21/11/2022 is my sale deed. Now, as per section 149 of the.
Now, what is that order now passed by?
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ I have not even proceeded, I have not my Kata pursuant to sale deed dated 21/11/2022. It has not been affected. By virtue of section 149 of the TVM, it has to be transfer and transfer. So it ought to have been transferred. But the learned judge, while granting an order of injunction not to alienate the property, said they have indicated that I am proceeding with the construction. I am yet to get a Kata from BBMP. I am yet to get a license. I have not yet proceeded. Now what has happened is they have restrained me from proceeding with the construction. I have not even indicated, there is no prima facie material on that. Now, taking this ballot after, the corporation ought to have entered my names, at least it can write subject to the result of this OS number. So, but the corporation comes up with an endorsement that suit 495 of 2023. New approach again. Now, I am neither here nor there because now all that I am seeking for a accommodation. So this will not come in the way of my prosecuting before the BBMP for change of Kata and license. And so far as I have given undertaking, which is produced before the court. At least I am saying that I am not going to plead equity. Let me proceed with the BBMP to get a Kata.
No, that is not the issue here. You have to challenge that before that by filing in a writ saying that pendency cannot be restrained from entering that.
That's what I am saying. Now, in spite of my all these submission and undertaking, kindly see my undertaking, which is produced. This has not been advertised. Now, I have sought for vacating the interim order. Kindly see the undertaking of myself, the present appellants, defendant 8 and 9. Yes. Page 77, document number 4. This has been received. I said, my lord, kindly see.
IA 1 and 2 is allowed. IA number 3 filed by the defendant 8 and 9 under 14 read with section 6 is rejected. Your IA for vacating.
Rejected. Now, what I am saying.
What is that order of injunction they have granted?
No, not to alienate. Along with that, now what?
No, if law is just because pendency of the civil suit, corporation cannot.
Correct.
Reject.
I have no objection if they write that this is a Kata.
In spite of that, if they are issued an endorsement, you have to challenge that endorsement. But here you can't.
No. As far as their statutory duty 149 is concerned, they have not done it. I have filed a petition, it is pending. Otherly, why I am agreed, my lord? The corporation says that after the disposal of the suit, can we see the endorsement?
No, that is wrong.
That is wrong.
But I cannot decide.
Now, is
Yes.
So what you're saying that I want to got a question of getting license still now the report has said that you cannot feel 53 ownership frequency. What they have
No,
done.
if writ petition is before me, I could have passed an order saying that now in this I can't pass any order.
If there is now, the endorsement PMP is after this in 2023.
No, it is not before me to.
No, I'm not asking you to read from that.
No, what is that interim order now you are asking here?
What I'm saying, I just need, I request some report to read it. Now, without there being a semblance of activity of construction. It just said you shall not change the nature. Now this, taking view from this, the BPM test issue, that you read further until the suit is decided. Suit is decided. Not really, they are not in parties. All that I am saying that even I will pursue the matter that this order that not validate, and I also that I will not read it even after getting this. All that I am requesting is that it will not come in the head, prosecute people to BPM. What is the thing?
No, that order cannot be passed in this appeal. Appeal is only injunction has been granted. If you make out in a case, I can stay that order, but I can't say that. If BBMP is misunderstood, then that order has to be questioned and challenged. Yes.
Has remained unchallenged and acted upon the case claim absolutely ignorance of the same. The defendant number 4 has made objection for transfer. In 2029, discovered in the name of father and put it in the pending second. Thus, until writing and possession parties in the suit property are ascertained, the nature of the property cannot be able to change. Thus, the rights of the parties with respect to seizure property will be decided through the course of the plan, and at this stage, the purchaser defense of 89 are basing their right on the sale deed to the right to the defendant's right to the question is checked and proper to restrain the defendant even from putting up any construction outside property. I am hereby undertaking that I will not put up any construction without obtaining license. And at this time, I'm not delegating that. And my vendors, sisters of that, they have undertaken that they will not need.
No, then why do you want that change of kata in your name? No, you have to make this submission before that report, saying that I should not do it. My name has to be continued in the kata to pay that revenue. Not here. I can't do that in this. That I understood.
Yes.
You see, you are perfectly correct. There should be some name that I think there is a judgment saying that name has to be continued for the purpose of payment of the revenue. If there is any dispute, that has to be mentioned. That has to be stated in the writ petition, not here. Otherwise, I am passing an order in the writ petition.
Here, without there being a semblance of material, the court has restrained me from proceeding with the construction. This order is, I am undertaking that without license I am not proceeding. So this, we taking you from this order, the way you have decided, you see, decide.
Allah, you know. No, Mr. You have to be argued this point before that writ court, saying that not to construct will not prohibit that BBMP to change the katas. BBMP endorsement is contrary to that. ಅಲ್ಲಿ ಅವ್ರು ಆನ್ಸರ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು. ಇಲ್ಲ, how can I say that? in this construction ಅಲ್ಲ.
Don't tell me I am restrained from not to change the case again. This comes in the way because BBMP is the same that we decide to and they are not the parties. So
ಈಗ
this
no, if BBMP is wrong, then that order has to go. Is it not? Not here. Not here in that petition.
It cannot be a party interested. As a person, you have to restrain me from exercising my ownership.
No, I am avoiding only a civil matter. I can grant that order like status quo, not to create third party interest. I have no right to say that, ad interim order issuing the stay of that annexure so and so. It is all with that report. Alala. Yes, sir. That's in under 226 we can give any.
Now what I am saying is, these two, before this order, these two and undertaking, which are filed. Now I don't.
No, I understand.
In the entire order, what I am saying, I am not going to proceed with the construction. My vendors have said.
No, now you are saying that this finding is also wrong. If the other side comes, I can set aside and send it back.
No, that's fine. Finding is wrong, and the undertaking, now the trial court, at least my undertaking filed by me, I have produced before the Supreme Court.
Yes.
These two undertakings, consider interim order that the trial court can modify. It cannot shut its eyes. Is completely ignored. That's what my main point is that.
Yes.
To that extent is undertaking, consider if it is not equitable, ಅಷ್ಟೇ ಮಾಡಿದ್ರೆ ಸಾಕು. ಇದರಲ್ಲಿ ಇಡೀ ಆರ್ಡರ್ ನಲ್ಲಿ there is not even a reference, even though.
No, that is all equitable under all is under 226. Here I can say what is to maintain status. No, if you make out in a case, I can allow your application for staying that impugn order.
Yes, but my my contention is that my undertaking, now at the interlocutory stage, I have filed an undertaking. Don't restrain me from construction. Who undertaking? Myself and the vendors. In spite of that, the court says, no, the status of the subject matter has been preserved. But ultimately, as of the date of shoot, I am the absolute owner. That kindly see, 1 minute, then what other consider
ultimately, I can stay that order with a rider that not to create third party interest. If you want, take that benefit and do it for or notice stay up order dated 4th August 2023 passed by 41 additional city civil and session judge in case number 495 of 2023, subject condition appellant not create any third party interest in respect of suit.
You have the undertaking already.
Adalla ಏನು ಹೇಳಕ್ ಬರಲ್ಲ ಇಷ್ಟ. If you want to take any benefit, you take it that. Yes. Not to create any third party interest in respect of.
I request notice on the council secretary before the permit ಮಾಡಿ.
ಯಾರಿಗೆ?
Council
ಯಾರು ಬಂದಿದಾರಲ್ಲ? ಅಲ್ಲ ಯಾರು 1 to 4 ಒಬ್ರು ಇದಾರಲ್ಲ?
1 to 4
ಇದಾರೆ.
Yes, anyway, my lord,
till next date of hearing. Yes.
ಅಲ್ಲ rest of the defendants I may permitted to serve.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
11 ಜನ ಇದೆ.
ಹೌದಾ? Issue notice to other respondent. In addition, appellant is permitted to serve a copy and the council appearing for respondent number 5 to 9 before the trial court.
The defendants.
Other
11 already.
Yes.
Rest of the.
Yes.
Obliged.
I for the respondent number 1 and 2.
What has been granted?
We permitted to file my
Defendant's appeal. What has been granted in favor of the plaintiff? Defendant number 4, who is contesting defendant, has filed an application and also written statement, objections, everything is filed. Sought for hearing of the application on two applications. One is IA for injunction, where a temporary injunction is granted. And the IA number 2, so order odd 7 to 11A. Though the statutory period is expired, then a judge is not hearing the application. That's not my grievance. Now, respondent has appeared. I would be satisfied if a direction is given to the learned trial judge to dispose of the pending two applications.
What are
on
the
or before a
application?
particular date.
What are the applications? One and two as filed by the defendant.
Yes. Plaintiff.
Plaintiff.
Plaintiff has filed order 39 rule 1 and 2 application.
ಏನ್ ಮಾಡಿದಾರೆ ಬರೀ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದಾರ
Urgent ಮಾಡ್ಕೊಂಡು
ಎರಡು ಅರ್ಜೆಂಟ್ ಇದಾಗಿದೆ. In the meantime, may matter ಎಲ್ಲ settle ಆಗಿದೆ.
ಅಲ್ಲ ಅದು ಮಾತಾಡ್ತಾ ಇದ್ದೀವಿ.
ಮಾತಾಡ್ತಾ in the meantime 4 weeks of 5 weeks of time ಕೊಟ್ಟರೆ we will argue the matter or otherwise you will report the settlement ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Before final order has to be passed, first they have to decide on IA.
ಹೌದು.
Let him, I will direct that to dispose of that IA. In the meantime, you settle ಮಾಡ್ಕೊಂಡ್ರೆ
ಅಷ್ಟೇ.
There is a possibility of settlement.
Yes. This appeal is filed by plaintiff. What is that order you are challenging?
Order on IA number 1 at page 20, Mela.
The defendant, their agent hereby restrained by way of till next date of. ಆಮೇಲೆ ಏನಾಯ್ತು?
ಅದು ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ.
Extend ಆಗಿದೆ.
From time to time it is extended. Even now it is extended.
No, you are for plaintiff or defendant?
I am for the defendant number 4.
Defendant. That is extending your application for vacating is not considered.
It is not considered.
Yes. This appeal is filed by defendant.
Number 4.
Defendant number 4. Challenging ex parte ad interim order of temporary injunction granted by the trial court. The trial court by order dated 5/7/2023 has granted an ex parte ad interim order of temporary injunction restraining the defendant from alienating the suit scheduled property till next date of hearing. After service of summons, the defendant appear through their counsel has filed an IA under order 39 rule 4. Rule 4 of the
Objection.
In objection.
You have not filed any objection.
Because it is extended from time to time.
Yes.
So next date I am
Yes, appeared and filed an objection and insisted for final disposal of IA filed under 39 1 and 2. Instead of considering that IA, the trial court time to time as extending the same. Hence, he sought for direction to the trial court to dispose of that IA as expeditiously as possible. In view of the above appeal is disposed of, directing the trial court to dispose of the IA filed by the plaintiff under order
along with
39.
one more IA is there, order 7 rule 11A, which has got the goes to the root of the matter.
They are my file.
ಅದು ನಾನೇ ಫೈಲ್ ಮಾಡಿದ್ದೆ IA number 2. Along with the objection, IA number 2.
After appearing, they have filed an objection and also filed
IA
IA under order 7 rule 11.
A.
Under 7 rule 11. The trial court, instead of considering that applications, they are time extending that ad interim order of temporary injunction. She sought for the direction to the trial court to dispose of that application. In view of the above appeal is disposed of, the trial court is directed to consider that application filed by the plaintiff under order 39 rule 1 and 2, and also application filed by the defendant under order 7 rule 11 in accordance with law as expeditiously as possible, not later than 8 weeks from date of receipt of the copy of this order. In the meantime, we can settle the settlement.
Positively, we will settle.
All pending applications from this.
PFR. Suit for partition Millard, filed by the Millard, the first defendant hearing, first respondent hearing.
plaintiff has sought for my lord 1/6 share, my lord. Wherein, my lord, in item number 10 of the social property, it was given for development and it was developed, my lord. And developer has, my lord, handed over, my lord, 57 sites to, my lord, the owners, my lord. My lord, kindly come to page number 56. The plaintiff himself stated that, my lord, 50 super picker pen 57 site have been para number 6A, my lord. 56 para 6A. And under supplement agreement it is also 57 apartments consisting 40 of surplus area have been allotted towards owner share. My lord, she sought for, my lord, injunction, not in respect of, my lord, the developer, my lord. Developer share na markoli anta bittidare. Even in respect of, my lord, this 57 sites, she has sought for, my lord, income injunction, my lord. Before filing the suit, my lord, the appellant herein has purchased 2 sites, my lord, 2 plots in the above said area. ಇವ್ರದ್ದು 1/6 share ಅಂತ ಅಂದ್ರೆ ಇವ್ರಿಗೆ 9 ಇದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಹೋಗುತ್ತೆ.
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದಕ್ಕೆ
ಬೇರೆ ಶೇರ್, ಇವ್ರ ಶೇರ್ ಅಲ್ಲ, ಇವರ ತಂದೆ ಗಲಾಟೆ ಆಗಿರೋ ಶೇರ್ ಅಲ್ಲ.
ವಾಟ್ ಇಸ್ ದಟ್ ಇಂಜಂಕ್ಷನ್ ಹ್ಯಾಸ್ ಬೀನ್ ಗ್ರಾಂಟೆಡ್ ನೌ?
ಇಂಜಂಕ್ಷನ್ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಮೈ ಲಾರ್ಡ್, ಮೇ ಕಮ್ ಟು ಮೈ ಲಾರ್ಡ್ ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 106.
ನೌ ದಟ್ ಯು ವಾಂಟ್ ಟು ಎಲಿನೇಟ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ.
ಅಲ್ಲ, ನಾನು ಈ ಸೂಟ್ ಹಾಕೋಕ್ಕಿಂತ ಮಧ್ಯೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೀನಿ. ಇವ್ರಿಗೆ ಬರೋದು ಇವ್ರು ಫಾದರ್ ಶೇರ್ಗೆ 15 ಸೈಟ್ ಹೋಗಿದೆ. ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು ಮಾವನ್ ಶೇರ್ ಅಲ್ಲಿ, ಇವ್ರ ಫಾದರ್ ಶೇರ್ ಅಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡಿಲ್ಲ. ಇವ್ರು 1/6 ಅಂತ ಮಾಡಿದ್ರು 56 ಸೈಟ್ ಅಲ್ಲಿ 10 ಇವ್ರಿಗೆ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಹೋಗುತ್ತೆ. 15 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ. ಅದನ್ನ ಫಾದರ್ ಏನಿದೆ ಅದನ್ನ ನಾಟ್
ನಿಮಗೆ ಎಷ್ಟು ಅಪಾರ್ಟ್ಮೆಂಟ್?
2 ಅಪಾರ್ಟ್ಮೆಂಟ್. ನಾನು ಕೇಳ್ತಾ ಇರೋದು 2 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಈಗ ಅಷ್ಟೇ.
See, only court said not to create any third party interest.
ಹೌದು,
ನೀವು ಅವು ಎರಡನ್ನ ಸೇಲ್ ಮಾಡ್ಬೇಕಂತಿದ್ದೀವಿ.
ಹೌದು, ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೆ 2 ಇದನ್ನ ಅದಕ್ಕೋಸ್ಕರ. ಇವರು ಅಲ್ಲಲ್ಲ, ಇವ್ರಿಗೆ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಕೇಳೋದೇ ಇಲ್ಲ. ಅವ್ರನ್ನ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿರೋರು ಅವ್ರದ್ದು ಏನು ಕೇಳೋದಿಲ್ಲ. ಅವ್ರ ಶೇರ್ನ ಎಲಿನೇಟ್ ಮಾಡಿ ಅಂತಾನು ಕೇಳಲ್ಲ, ಏನು ಕೇಳಲ್ಲ. ಇವ್ರಿಗೆ ಬರೋದು ಇವ್ರ ಪ್ರಕಾರ ಇವ್ರು ಒಪ್ಕೊಬಿಟ್ಟಿದ್ದಾರೆ. 56 ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಮ್ಗೆ ಬಂದಿದೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಹಂಗಂತ ಬಂದ್ರೆ 9 ಸೈಟ್ ಬರುತ್ತೆ ಪ್ಲೇಂಟಿಫ್ಗೆ. ಅವ್ರ ತಂದೆಗೆ 15 ಸೈಟ್ ಅಲಾಟ್ ಆಗಿದೆ. ಅವ್ರ 15 ಸೈಟ್ ಎಲಿನೇಟ್ ಮಾಡ್ಬೇಡಿ ಅಂತ ಅಂದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇನೆ. ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಾನ್ ತಗೊಂಡಿರೋದು ಮಾವನ್ ಹತ್ರ.
Where is your IA for injunction? You have sought only 2 sites.
ಮೆಲಾಡ ಇದಕ್ಕೆ ಮಾತ್ರ ನಾನು ಕೇಳ್ತಾರೆ ಅಷ್ಟೇ. ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದಕ್ಕೆ ಮಾತ್ರ.
ಎಲ್ಲಿದೆ ಅದು?
ಮೆಲಾಡ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಮೆಲಾಡ ಪೇಜ್ ನಂಬರ್
ಐಟಮ್ ನಂಬರ್ 10 ಅದು
133 ಐಟಮ್ ನಂಬರ್ 10 ಅಲ್ಲಿ 2 ಮಾತ್ರ ಕೇಳಿದೀನಿ. 134 ಬನ್ನಿ ಸರ್.
issue notice. They aspirate for other IA number 1 of 2023. Pay for subject to result of this appeal.
Yes. ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಟು ಮೆಲಾಡ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಷ್ಟೇ. 2 to 31 may be discussed.
Yes, let me counsel for has filed a memo seeking dispensation of to respondent for 2 to taken on record, dispense with the risk of the appellant, issue referent notice to respondent number 1.
Okay.
I have petition under the appellant wanted point 1, 5 and 6 formed the trustee on 29/10/1990. It is a public charitable trust. In 2017, the respondent number 1 and 2, they carried out an amendment with the trustee, removing me and the respondent number 5 and 6, and they've inducted their children who are respondent 3 and 4 into the trust. Being agreed by the same, I prefer a section 92 petition along with my suit. My petition is at page number 29. My appeal.
Yes. What is the prayer in the?
My prayer, my lords will find it at page number 81. Yes. Bottom. Yes. Declaring that the amendment to the deed of trust dated so and so, register and so as null and void. Remove defendant number 1, who is respondent number 1, herein as managing trustee of defendant number 7 trust. Remove defendant number 2 as trustee of defendant number 7 trust. Direct the respondent number
1 to 4 to render accounts of the 7 defendant trust to the plaintiffs, grant permanent injunction restraining defendant number 1 to 4 from interfering with the management and other affairs of defendant number 7 trust. Appoint the first plaintiff as the managing trustee of the 7 defendant trust. Grant permanent injunction restraining the defendant number 1 to 4 or any other person claiming through or under them from acting as chairman, secretary, managing trustee, treasury or trustee of the 7 defendant trust and other such reliefs. What the trial court holds is that through this 92 petition, I'm attempting to agitate private rights, personal rights. Prima facie,
It is,
whatever.
it is not in the interest of the trust.
It
You
is
are
in
claiming in your personal right.
no.
Yes, you take notice. Yes, notice.
I represent respondent number 1 in this case, my lord.
Yes. Yes, Mr. We will have it after vacation. It requires hearing.
Also, requires.
Leave this matter. Hearing request ಮಾಡುವ?
ಆಗ್ಬೋದು. ಆಗ್ಬೋದು. In meantime, ಒಂದು 3 ಸೂಟ್ಗಳಿಂದ it's also put on my part to place 3 suits to plaintiffs ಎಲ್ಲ ಸಪ್ಲೈ ಮಾಡ್ತೀವಿ.
Yes.
NOC ಬಂದಿತ್ತು.
Yes.
So for better understanding of relationship.
Yes, heard admit. Hold this matter for hearing.
Trial court record ಬಂದಿದೆ.
Yes, we will.
Agreed.
Yes.
All those things can be done.
Yes. Interim order granted earlier is extended till next date.
Number 62, number 63, sufficient DJ for appellant.
Lord, I appearing for petition, appellant, my lord.
Yes.
But suit for partition, what the appellant is the plaintiff, my lord.
Yes.
The suit for partition and separate position. Lord,
Yes.
on appreciation of the entire material available on record and the plaintiff is himself examined as PW1, who is Padma TH. After appreciation of the entire material available on record, the suit came to be decreed partly. Well, there are 9 items of the property. Well, suit came to be decreed and 1 share is with respect to the item number 1 to 5 and item number 6 to 9 has to be rejected. Well, the decree has been satisfied by the appellant. Then being aggrieved by the judgment and decree passed by the trial court, well, the defendants has filed an appeal before the first appellate court. The trial court is will not kindly see the respective defendants has been filed a power through an advocate. But it was the ex parte decree came to be passed. Ex parte without passing application for seeking ex parte, well, the power has been filed. Well, kindly see.
No, that they have been placed ex parte before the trial court.
Well, the advocate for defendants filed a power, but he cannot make an application for seeking ex parte.
They have not filed written statement defendant number 1.
Please.
Here before the court, hence they have paid the ex parte. Yes, they have engaged the council.
Engage the council, but the power has been filed.
Appear before the court, but they have not filed any. Appear before the court and then person or the advocate.
Advocate through an advocate is filed a power, but the advocate has not filed an application for seeking ex parte. Then, my lord, the written statement is also not filed. Evidence has been not led. Well, appeal was filed in RA 53 of 2020. Well, the appeal has been remanded on the ground that well, in the memorandum of appeal memo, there was a earlier partition is pleaded by the appellant without there being any sufficient documents, without there being any order 41 to 27 application. The straight away the appellate court judge has been remanded the matter of fresh consideration. But kindly see.
Yes.
Observation.
Oh, what you want?
Page number 29. Page number 29, para number 22 is a bottom, my lord, the 4th line starts from 4th line. In the case on hand, para number 22, page number 29.
What is they are coordinated. 9th August 2023, passed by additional senior citizens Hassan in file number 53 of 2020. Until the next date of hearing.
Much obliged.
Upload manners. Number 15, number of years for opponent.
Finally, 2 weeks time is granted. Yes, oh, you are there.
Office objection is not, no. Value of the appeal to be correctly stated. If necessary, DCF to be made good. Look at the extent of land. And number of trees to be stated. They will last me kindly see page number 13.
ಎಂಬತ್ ಮರ ಎಲ್ಲಿದೆ ರೀ?
ಅಲ್ಲ ಇದು ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ?
ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 43 ಒಳಗೆ 43 ನಲ್ಲಿ ಕೆಳಗಡೆ ಲಾಸ್ಟ್ ಬಟ್ ಒಂದು ಪ್ಯಾರಾದಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಎಂ ಗುರುಶಾಂತಪ್ಪ ಅಂತಿದೆ. ಅದರಲ್ಲಿ ಮೇರಿ ಎಕ್ಸ್ಟೆಂಟ್ ರಿಸರ್ವ್ ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ 5.08 ಗುಂಟೆ ಕೃಷಿ ಜಮೀನು ಭೂಸ್ವಾಧೀನ ವಿರುದ್ಧ ಮೌಖಿಕ ತಕರಾರು ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಹೆಚ್ಚುವರಿ ಪರಿಹಾರ ಪಾವತಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಸಂಬಂಧಿಸಿದಂತೆ ಸಮರ್ಥನೆಗೆ
80 ಅಡಿಕೆ ಮರಗಳಿದೆ.
80 ಅಡಿಕೆ ಮರಗಳಿದೆ. 5.08 ಗುಂಟೆ ಲ್ಯಾಂಡ್. ಇದನ್ನೇ ನಾನು ಹೇಳಿದ್ದೀನಿ.
Submission of learned counsel for the appellant is accepted. Office objection is overruled. Issue notice.
Records.
Yes. What? Yes, records.
Number 20, Prakash Ambedkar give it for opponent.
If my lord, one office objection is complied, my lord, and one more office objection, that is with regard to arraying the respondent number 3 as party who was not in the trial court, my lord. I am filing a memo before the former court to delete the respondent number 3, my lords.
Complaints of recognition the memo. What are the office objection?
My lord, only regarding stitching of the certified copy of the
Now furnishing of necessary application regarding to the respondent number 3 before.
respondent number. Yes, my lord, that I could not file the application, my lord. I am filing a memo.
Now, who is respondent number 3?
Special Land Acquisition Officer, my lord, who was not a party before the district court, my lord.
Made him as a party here.
Yes, my lords, but necessary application could not be filed by me.
How can you make him as a party without that application?
My lord, necessary application I was supposed to file, my lord, and that I could not file. Because on his award only the reference application was filed and the arbitral award was passed and but he is a formal party, my lord. We are not claiming any relief on the formal party.
File an application tomorrow, we will have it tomorrow. We'll direct the government to take notice and will yes.
And the execution petition they have filed, my lord. And,
You file tomorrow, we will see that. Tomorrow or Monday?
tomorrow.
Yes.
Tomorrow.
Monday. You can file it tomorrow. We'll have it on Monday. Yes. This.
Number 21, Naveen GS for opponent.
Here for the appellant, my lords. It's an appeal, my lords, under section 94. He challenging the order under section 94A. Also, I filed earlier a petition, my lords. Coordinate bench of this honorable court had directed me to file an appeal, my lords.
Where is that?
That was recorded in the order sheet.
Where is that?
Petition is after Wakalat, my lords. Will be number 1.
No, you sought for a conversion, they have permitted, that's all. It's not an on merit saying that this is appeal is maintainable. You sought for a conversion. No, tomorrow, today, if you seek that I want to convert this as an SLP, I will permit it. That is for you to this thing. That you can't say that it's a court has permitted, therefore it is maintainable. How it is maintainable? What is the order you are challenging?
My lords, 94A, my lords.
94?
E, my lords, section 94E.
94E ಏನದು?
Prohibitory order, my lords.
Past order, where is that order?
My lords, order is produced, my lords, page number 113, my lords. Yes, my lords.
94 ಈ ಕೆಳಗಡೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಏನ್ ಬರುತ್ತೆ? ಅಪೀಲ್ ಬರುತ್ತೆ.
It's a writ petition, my lords, because under section 104 of CPC, my lords, there is no provision provided for to appeal.
ಮತ್ತೆ ಅಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ರಿಕಾಲ್ ಮಾಡಿಸಿ ಅದು. You have to see when court said it is not maintainable, you have to convince the court by showing that judgment. Then you have to take an order on merit. If court is not agreed merit, then you have to write an a challenge. ಈಗ ನಾನು ಅಪೀಲ್ ಮೇಂಟೈನೇಬಲ್ ಅಲ್ಲ ಅಂತ ಸಿಆರ್ಪಿ ಅನ್ನಿ, ಸಿಆರ್ಪಿ ಆಗ್ತೀವಿ. ಸಿಆರ್ಪಿ ಆದ ತಕ್ಷಣ for not that purpose advocate has been engaged. Advocate has to convince the court on law. Now if you are saying that writ is maintainable, why you have asked for conversion? Then you have to file an application for recalling that order. Yes. Then you convince that same before the court that that order is not correct. This is the law. Then you recall, then we can do it. Yes. Kindly. Great. At the request of counsel for appellant, please this matter of 2 weeks. Great. Yes. Yes. Good. Right.
Order 7 to 11.
Suit for?
Suit for, initially what happened was, a suit was filed by a son seeking the partition deed executed by the mother and along with his, her family members, brothers and mother and all, is not binding on her. And for a partition on the ground that she is of unsound mind, her mental status is not good and they have misled and they have taken a partition deed and all those things. While filing the suit, he himself has filed a suit without making her as a party, as an ex-friend. Normally, my lord, that person has to make a party, unsound person, and he should be represented as next friend for both minors as well as a person of unsound mind. That he has not done. On his own individual capacity, he has filed. Then we have decided on. And along with that, there was one application was filed under 32(2). 32(2) application also was filed. Then the notice was ordered. I entered appearance and filed objections for this thing and written statement contending that she is not of unsound mind. Her mental state is very good and he has no authority to represent, and the suit is not filed by the mother, and he cannot file. Leaving the mother, he cannot on his individual capacity cannot file. Then that objection was filed. Then what happened was, then my lord, the court also has found that then immediately what they have done, they have filed an application. Plaintiff Asha, who is a defendant here, has filed an application to implead her mother as a party for impleading.
Yes.
Then I opposed that also. Then that application, our lord, it was allowed, and she was made as plaintiff number 2. But what happened was, she has not represented by any counsel. And my submission was, without her knowledge, even that application was filed. She was very hale and healthy and everything was good. Then what happened? I filed an application and order 7 rule 11 only, that time only I have filed. At that time, what happened was, court has given a finding saying that based on the pleadings of the defendant, we cannot reject the claim. And it is for a trial, and 32 rule only trial has to take place. Once the trial is done, then we can consider your application, not now. Thereafter, what happened, my lord? Then without posting it for, though it was posted for trial, my lord, there was a COVID and all those things. And it was posted under the court without postings for inquiry on the application filed by the, about to find out whether she is of unsound mind or not. They have framed the issues for doing that. And it was posted for evidence.
Yes.
My lord, I opposed for that. And I also said she's of good sound mind and all those things. Then court has directed, based on that, court has directed the plaintiff to keep that mother present before the court.
Yes.
Then what happened? She appeared before the court.
Yes.
And court, the honorable the presiding officer called her in his chamber and spoke to them to find out whether her mental state is good. Then on 14/10/2022, my lord, the honorable court has recorded in the order sheet, about her mental status. My lord, I have said, para 12 may kindly be seen.
I said, I produced a certificate copy also, but in my readings I have extracted, para 12 may kindly see page number 16. Yes. Then my lord, para 12 I just read. It is relevant to state here that as per the order dated 69/22, Srimati Padmavati was brought to the Honorable Trial Court on 14/10/22, and the presiding officer of the Honorable Court has physically examined her in the chambers during the lunch session, and thereafter the order sheet recorded as under. Plaintiff defendant number 2 and the counsel both are present. The court examined the second plaintiff about the family relationship and native place of her parents and husband. The second plaintiff has given answer to those questions. Therefore, it appears of the court that the mental faculty of the second petitioner to be good, and she is capable of prosecute the case. The suit for partition, therefore, the defendants are directed to keep the present defendant number 1 to the next date of reconciliation. So, the finding of the court was, the observation of the court was, she is of unsound, she is not of unsound mind. So that means the very basis, the very foundation of the plaint my lord, which was filed, has gone. What happened thereafterwards? It was posted to next date of hearing. In the meantime, my lord, what happened? She fell ill, and this was on 14/10. Exactly at 14/11, my lord, she died. She died of heart attack. She is no more now. Thereafterwards, I filed an application after 7/11. On the ground, this was a contention, and this is a finding of the court saying that she is of sound mind, and suit itself is not maintainable. Please reject based on this. That came, though my lord, the trial court has accepted all my contradictions, it has rejected there. In the meantime, what happened? After the death, the first plaintiff's son has filed an application to bring LRs on record. My submission is the LR application itself is not maintainable because she was not a party at all. Though she was pleaded, she was not represented. Legally speaking, my lord, she is not a party at all. Then your lordship may kindly turn to the impute order, where the learned judge, my lord, though has accepted, read louder. Para 12 may kindly, my lord, para 11, para 8, my lord, I just read reasons. Page number 25. Although the suit was filed on behalf of Padmavati on the ground that she is of unsound mind, in the cause stated of the plaintiff, it was only the son of the Padmavati, namely Harsha, who was shown as the sole plaintiff. And now para 11 may kindly be seen. Thereafter, issues are framed and the matter reached the stage of further chief examination chief of PW1. At that stage, conciliation proceedings were read. At that stage, plaintiff number 2, Padmavati, was directed to be present, and on 14/10/2022, the order sheet reads that the presiding officer examined plaintiff number 2 and found her mental faculty to be good, and she is capable of prosecuting the case. Thereafter, the matter was posted for further conciliation, but at that stage, the death of plaintiff number 2, Padmavati, was reported, and at present, applications came to be filed. Then the next paragraph. In support of the application for rejection of the claim, counsel for the defendants argue that the plaintiff number 2, on whose behalf the present suit is filed, has passed away on 14/11/2022. The order sheet dated 14/10/22 clearly shows that the presiding officer has examined her and found her mental faculty to be good, and she is capable of understanding the worldly matters. Thereby, the very foundation of filing the present case, that Padmavati is of unsound mind and was incapable of understanding, does not survive, and on this ground, the continuation of the suit is uncalled for and therefore sought for rejection of the claim. Then, my lord, para number 14. Having considered the facts and circumstances of the case, it is to be noted that the contention that suit as originally filed was defective, since only Harsha was shown as the plaintiff and not Padmavati, on whose behalf the suit was filed, does not survive in view of the earlier rejection of IA under Order 7/11 of CPC by my predecessor by order dated 7/2/18. Anyhow, subsequently, Padmavati was brought on record. My lord, para 16 may kindly be seen, my lord. If the plaintiff can prove those facts, or in the other words, since the Padmavati is now dead, if her LRs can prove the above facts that the suit scheduled properties originally belonged to Padmavati's father, who has died intestate, and partition deed is fraudulent and obtained by deceit, then certainly the LRs of the Padmavati would be entitled for a share in the suit properties. No doubt, to prove that partition deed is fraudulent and not binding on Padmavati would be a difficult task
for the LRs of the plaintiff, because it is only Padmavati who would be capable of speaking whether she was subjected to any fraud by the defendants in obtaining the partition deed, and it is also an appeal task for the plaintiffs to prove that the Padmavati was suffering from mental illness, unsoundness on the face of the order sheet date 14/10/22, wherein my learned predecessor has clearly recorded the findings that on examining her, she was found to be capable of giving intelligent answers and capable of understanding the facts. However, this is what it says. The law is settled that at the stage of Article 7 Rule 11 of CPC, the plain government has to be accepted on the face of the value, on the face value, and merely because the plaintiff has a difficult task on hand for proving her case, it is not a ground for rejection of the claim. At this stage, my lord, there is an order, my lord, is there. 17 may kindly be seen.
That is what, that is their headache to prove whether she's in a
Unsound mind or not. Correct.
No, whether that without her consent partition has been done. That has to be trial. Your suit cannot be rejected, plaint cannot be rejected.
No, no. The thing is whether the suit legally, whether it's a suit in accordance with law or not. Because now what happened? Initially, Asha had filed, Sun has filed. Padmavati was not a party. Thereafter,
That is true. That defect has been cured by impleading her.
Allala, impeding her, she's not represented at all. Impeding adre, very impeding application, Sun has filed. But she was not represented by through any counsel. No power was filed.
That is a defect. That cannot be a ground for rejection of the claim.
Now the thing is, even except impleading her, all pleadings prior, everything was the same. There was no change in. So what is the foundation for the suit? For a son who has filed when he filed it, that my mother has unsound mind, and by cheating, they have taken the signature and all those things. So that is found to be wrong now because she's of not unsound mind at all.
No, court cannot, without going the trial, court cannot ask that to see that whether it's a sound mind or not. That is the burden on the plaintiff.
That's true.
Prove. No, court or Kardabutto, hey, seri idare anta. He has to prove by any evidence. He may prove tomorrow.
Tomorrow.
See, now you are saying that the foundation of the case that she is an unsound mind there. Now court has called her and said that she is sound mind, therefore suit has to be dismissed. That is nothing to do with the court duty. It is the plaintiff tomorrow by evidence show that yes, my mother is unsound mind, therefore that partition is not binding. You cannot on the basis of the court recording that statement, suit cannot be dismissed.
Though one can understand if she is alive and Dr. Kedwood could have been examined.
ಈಗ ಅವ್ರಿಗೆ ಇನ್ನೂ difficulties. They have to
burden ಜಾಸ್ತಿ ಆಯ್ತು ಅವ್ರಿಗೆ. ಹೌದು ಕರೆಕ್ಟ್ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು, ಅದು ಡಿಫಿಕಲ್ಟ್. ಬಟ್ ದ ಪ್ರಾಬ್ಲಮ್ ಇಸ್
that is their difficulties. Why are you worrying?
ಅಲ್ಲ ವೈ ಆರ್ ಯು ವೆರಿ ಅಂದ್ರೆ ಲೀಗಲಿ ಮೈ ಲಾರ್ಡ್ ಇಟ್ಸ್
this is dismiss. Rejection of the claim cannot be. If you want you take notice to some yes, notice.
ಯಾಕಂದ್ರೆ ಲೀಗಲಿ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಸೂಟ್ ಅಟ್ ಆಲ್.
ಕರೆಕ್ಟ್.
ಟೆಕ್ನಿಕಲಿ
ಅದು
ಈಗ
ಕೋರ್ಟ್ ಕರ್ಸ್ಬಿಟ್ಟು ನಾವು ಅವ್ರು ನೋಡಿದ್ವು, ಹಂಗಾಗಿ ಅವಳು
ನೋಡಿದ್ವಿ ಅಂತ ಮಾತಾಡಿ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
You are not an expert to say that. Either it has to be in that witness box or the doctor has to be seen.
In the meantime, what happened was
court ಬಂದ್ಬಿಟ್ಟು ನೀನ್ ಸರಿ ಇದೆಯಾ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು we cannot say.
Correct. Presiding officer cannot do that. But the thing is, prima facie to find out whether she is capable of understanding the things or not.
ಈಗ ಆ ಕೋರ್ಟ್ನರು ಅವ್ರು ಏನ್ ಕೇಳಿರ್ತಾರೆ ಅದ್ರ ಮೇಲೆ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಟ್ರೆ ನಾಳೆ who will answer before that appellate court saying that whether she is an unsound, whether court can go and stand in that high court as a witness.
ಅಲ್ಲ ಅದಾಗೋದಿಲ್ಲ. In the meantime, what happened was,
ಈಗ ಅದನ್ನೇನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ನಾಳೆ ಇಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಕೋರ್ಟ್ ನರ್ ಹೇಳಿದ್ರ ಅವಲ್ಲ, ಕೋರ್ಟ್ ನಲ್ಲಿ ನಾವು ಜಡ್ಜಿನ ಕರೆಸಿ ಕೇಳಕ್ ಆಗಲ್ಲ. Therefore it is the party who has to be proved. Anyhow, take note.
ಅಲ್ಲ ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ there is one more application was filed by the plaintiff Sananda to summon the doctor.
See, court ಏನ್ ಗೊತ್ತಾ, you produce a certificate.
ಅದು ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
ಅದು ಬಿಟ್ಬಿಟ್ಟು ಇವರೇ ಕರ್ಸ್ಬಿಟ್ಟು ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಕೇಸ್ ಕರೆದಂಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. That is how that these are all doing.
No certificate is produced here.
ಅಲ್ಲ ಅದನ್ನ ಹೇಳ್ಬೇಕು. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ then I will dismiss it ಅಂತ. ಅಲ್ಲ ಅದನ್ನ ಇವರೇ ಕರೆದ್ಬಿಟ್ಟು ಎಸ್ ಇಲ್ಲ ಸರಿ ಇದಾನೆ ಓಕೆ ಅಂತ.
ಅಲ್ಲ ಅವರೇ ಕರೆದಿದ್ದಲ್ಲ, but there is no certificate has been produced.
ಆತರ
without producing certificate, he has filed an application to summon a doctor. Court rejected it because you are not producing any documentary to show that prima facie that your mother is unsound mind.
ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
Let us see.
Because proceedings ನಡೀತಾ at least till the next date appearing, my lord.
No. Yes.
ಅಲ್ಲ, let there be entry model till.
No, it is not a case for stay also. Let us see, your other side ಬಂದ್ಮೇಲೆ ನೋಡೋಣ.
We are permitted to take notice on the council also.
Yes, in addition, petitioner is permitted to serve a copy on the council appearing for the respondent before the time. Council appearing for the respondent. Yes. Yes.
Appearing for the appellant, my lordship.
Yes, ready.
It is earlier, in this case, I have argued also, but the other side was not present on that day.
Yes, what is that?
This, my lordship, the 93 is the injury case. These two cases arises in the
Same extent.
same accident. One is the injury, 9193. In Mahalata, her daughter one Sahana died. Regarding that, 9194 has filed, my lordship.
How accident occurred?
This, in MFA number 9193, injured Mahalata along with her children. She was traveling from Majestic to Yelahanka. Unfortunately, she doesn't know the express train. She got the ticket, journey ticket also. She came from Chanpatna. So on account of her children's vacation, she had gone to her native place. So while returning from Chanpatna to her destination Yelahanka, she boarded the this Kurla Express at SBC, my lordship. So
No, what is the reason for rejection?
Rejection, the findings of the trial tribunal, my lordship, her own negligence, self-inflicted injuries. On that ground,
Read that finding.
my lordship.
Yes, read. Read, Mr. Kamran.
My lordship, kindly.
Para 9.
Para 9. Respondent relied on DRM's investigation report in which it was stated that the train in 11014 Express has no scheduled stoppage at Yelahanka railway station. And when the train was passing slowly through this station, in the meanwhile, the injured along with her daughter fell down while alighting from the running train at kilometer number so and so, and the lady was injured, whereas the girl died on the spot due to injuries. So it is further mentioned in the said DRM report that police had neither recovered any traveling ticket nor any traveling authority from the injured lady. Therefore, they were not bona fide passenger of the train. It is further mentioned in the investigation report that the respondent railway is not responsible for this incident. My contention and after investigation of the GRP, my lordship, this injured.
No, you yourself as
not at like that. The contention of the appellant is due to the rush when their destination has come. This deceased Sahana went near the door. She fell down.
She was traveling from where to where?
Channapatna to, they were come from Channapatna to Majestic. And from Majestic to the Yelahanka, they were got the ticket. But unfortunately, without knowing the halt train at Yelahanka, they boarded this Kurla Express train. This is their mistakes. I agree, my lordship. So when this minor girl went to near the door while the train was proceeding near Yelahanka, so at that time she fell down to rescue her daughter. This injured mother went to rescue her. At that time, due to the jerk and jolt and the loss of balance, she also fell down. But due to the fall from the train, her daughter.
Due to the jerk only, she fell down. What is the material?
The investigation agency fell down by the train. That is only, except that
because investigation, DRM, investigation inquest report, they have drawn, my lordship.
DRM investigation report says that she tried to alight from that moving train.
This is the second opinion, my lordship.
Now, where is that?
First
Police-
investigation.
Police has filed a charge sheet.
Yes, yes, my lordship.
What is that police?
Charge sheet also filed, but this case, the charge sheet. The LCR is also with the. I have read the. My lordship, last version.
That FIR is that there was trying to alight from that moving train. Earlier about 15 years was run over by the train. Just Panchanama deceased, so and so has fell down. During that alignment from the running, extinct and fell down during the injury. Yes, Poga train in the Kalagari, suicide, self-inflict.
My lordship, no one is the eyewitness because after fall from the train, the railway authority given a message because this is the non-scheduled stop. On that ground, they have given a message. On that basis, they have drawn this report.
No, is it not the burden lies on you to show that you fell down due to the jerk? What is that material?
Because the general phenomena, my lordship, no one is ready to lost his life, and also till the proof of guilty, every common man is a prudent man. So on that natural phenomena, so why they have tried to get down by the train while the train was proceeding? But they actually what happened, my lordship, when the train
she has boarded the wrong train.
Yes, I agree.
She wants to get down, even though there is no stop. When it is slowed down, she starts jumping.
Not jumping, my lordship. So where this lady Mahalata, the injured, while trying to rescue her daughter fell down.
But no materials to show that.
Because this
you have to prove hangare ellaru train inda bidaralla heltare. Adannella oppunagagalla.
My lordship,
if you show me any judgment and if you are traveling in the train, even if you fell down yourself, then also they are liable. Then I can accept.
And by respectful submission, as per the apex court, Rina Devi judgment, the negligence is not a ground to reject the.
Also reveals that when she was alighting from the running train, there is no dispute with regard to that other skills
Traveling in the train.
Then Rina Devi case will support that.
No, once you are traveling, if you jump from the train also, you are liable.
Because what happened, my lordship, once one entry comes in the investigation report, it will carry in all the papers. Unfortunately,
ಈಗ ಬಿಡಿ ಕೇಸ್ ನೀವು ಎಲ್ಲರೂ ಹೇಳದಂಗೆ ನಾವು ಜರ್ಕಿಂದ ಅಂತ ಅಕಸ್ಮಾತ್ ಅವ್ರು ಹಾರಿದ್ರು ಟ್ರೈನಿಂದ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ ದೆನ್ ಆಲ್ಸೋ ದಟ್ ರೈಲ್ವೇಸ್ ಇಸ್ ಲೈಬಲ್ ಅಲ್ಲ ಹಾರಿದೆ ಅಂತ ಯಾರು ಹೇಳೋದಿಲ್ಲ. See, now that document shows that she tried to alight from the train. That also their railway authority is responsible. They are finding see that paragraph.
Paragraph number 26, my lordship.
Yes.
Conflict of decision has been pointed out on the subject as noticed from the statutory provision. Compensation is payable for death or injury of a passenger in Rajkumar, referring to the scheme of the Railway Act 1890. It was observed that since traveling without ticket was punishable, the burden was to the railway administration to prove the passenger was not a bona fide passenger. The railway administration has special knowledge whether a ticket was issued or not. The 1989 Act also has similar provisions bearing section 55 and 137. The view led to an inference that the person dead or injured found on the railway premises has to be presumed to be a bona fide passenger, so as to maintain a claim for compensation. However, the Delhi High Court in so and so Singh held that initial onus to prove death or injury to a bona fide passenger is always on the claimant. However, such onus can shift on the railway if an affidavit of relevant facts is filed.
See, once the person who was traveling in the train who is dead, then it is no burden has shifted them. They have discharged their burden, showing that you have alighted from the train by FIR, police records, Mazur, everything shows that they have discharged their burden.
My lordship, then when I have
you need not prove that whether you have by jerk you have fell down or that by accident. When you show that you are traveling the train, death is occurred, for them to prove no, it is not our fault, it is your fault and our prove ಮಾಡಬೇಕಂತ ಹೇಳ್ತಾರೆ. Our prove ಮಾಡಕ್ಕೆ sufficient documents has been given.
Self-inflicted injury, the findings has given, but on due to the self-inflicted injury, as per this citation, the legislation has not permitted, my lordship. Yes. One 24A para first page, my lordship, 572, first page. B.
124A. Given incident. When it goes to the working of private, incident occurs, whether or not there has been a harmful act.
124, yes. 124?
Yes.
Compensation on account of untoward incident, where it goes working railway and untoward incident occurs, then whether or not there has been a wrongful act, neglect or default on the railway administration, such as the passenger who has been injured or the dependent of the passenger, been killed, maintain and recover damages in respect of thereof. The railway administration shall, notwithstanding anything contained in any other law, liable to pay compensation to such extent as may be prescribed, and to the extent only for loss occasioned by the death of or injury to a passenger as result of such untoward incident, provided that no compensation shall be payable under this section by the railway administration if the passenger dies of supposed injury due to suicide or attempted suicide by him,
self-inflicted injury is called criminal act. Any act committed by him in the state of intoxication or insanity, any natural cause or disease or medical or surgical treatment, unless such treatment becomes necessary due to injury caused by the self-inflicted incident.
Self-inflicted injury ಆದ್ರೆ ಅದೇ ಇಲ್ಲ.
ಇಲ್ಲ. ಇದು self. According to the records also.
Self-inflicted injury ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
But the
Laughed heart and the self-inflicted
para number 8 Panchnama. But it says inquest Panchnama of the deceased exhibit A3 also reveals that by traveling by the train Purva Express, the injured Mahadatta, Srimati Mahadatta and her daughter were gliding from the running train, slipped in and fell down. So therefore, my lord,
it's a self-inflicted injury only.
Self-inflicted injury, but my lord, it is not that as of the suicide or self.
No, suicide is different.
Suicide is.
No, suicide is suicide is A.
Suicide is A.
No, B is self-inflicted injury. That is what that if you have jumped from the train, that is a self-inflicted injury.
This is not.
But self-inflicted injury ಎಲ್ಲೋ ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಏನೋ ಒಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಮಾಡಿ ಏನೋ ಮಾಡಿದಾರಲ್ಲ ಎಲ್ಲಿದೆ ಅದು?
ಇಲ್ಲೇ ಹೇಳ್ತೀನಿ ಸರ್.
Somewhere I have said
It is not the ground 26.
self-inflicted definition. ನೋಡಿ ಪ್ಯಾರಾ 22 ಅಲ್ಲೆಲ್ಲ ಇದೆ. 22. Therefore, to the limb of the provision should be excluded to two different aspects of self-inflicted injury, not only from the sources put by the dictionary, but also from the self-inflicted injury used in the statute. Used as one which or a person suffered on account of one from the acts. The intention of self-inflicted injury is suicide ಅಂತಾನೆ ತರ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಹಾಗಾಗಿ let him consider this judgment and reconsider that matter. In terms of this was not cited before that ಇರ್ಲಿಲ್ವಾ ಅವಾಗ ಆಗಿರ್ಲಿಲ್ವಾ? 2000
ಕೇರಳ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇದನ್ನ ಸೈಟ್ ಮಾಡಿಲ್ಲ ನೀವು ಈ ಜಡ್ಜ್ಮೆಂಟ್. Dinadevi has not cited before the court.
ಏನು ಅದೇ ಇದು later on judgment.
There is one more judgment of 2023. That also, my lord, it can be treated as untoward incident.
No fault liability.
Even self-inflicted injury ಏನು ಹೇಳ್ತಾರೆ ಅಂತ self-inflicted injury statutes nothing more than the rash and negligence act, but it shall not be an see ಹೋಗ್ತಿರೋ ಟ್ರೈನ್ ಅಲ್ಲಿ ಇಳಿಬೇಕು ಅಂತ ಹೇಳಿದ್ರನ್ನೆಲ್ಲ self-inflicted injury ಅಲ್ಲ ಅನ್ನೋದ್ರಲ್ಲಿ ಡೆಫಿನೇಷನ್ ತರ ಹೇಳಿದ್ದಾರೆ. Self-inflicted injury ಅಂದ್ರೆ nothing but an suicide.
Suicide ಅದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ 124 who are not entitled ಅಂದಾಗ
suicide self-inflicted injury one and the same ಅನ್ನೋ ತರದಲ್ಲಿ ಅವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಅಲ್ಲ ಡಿಫರೆನ್ಸ್
ಸೆಲ್ಫ್ ಮೂವಿಂಗ್ ಟ್ರೈನ್ ಅಲ್ಲಿ ಇಳಿದ್ರು ಕೂಡ ನೀವೇ ಜವಾಬ್ದಾರ. ನೀವು ಗೇಟ್ ಹಾಕೊಂಡು ನಿಂತ್ಕೋಬೇಕು ಎಲ್ಲ ಕಡೆ.
That is the latest judgment relying upon the Reena Devi's case. That is not in support of my learned friend. To be fair with the court, I can.
Yes, we'll send it back and in terms of this judgment, let him reconsider.
My lordship already 10 years lapsed kindly. And in another one case, I would like to draw your attention to this honorable court. Again, they have preferred MFA by the railway. So till today it is not awarded. Thereafter, I preferred the MFA before this honorable Justice Shams Sahibar ಮಾಡಿದ್ರು. ಅದನ್ನ ಮತ್ ಬಂದು ಈಗ ಹೋಗಿ ಇನ್ನೂ 1 year ಆದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ.
No, if once you have succeeded, if they filed an appeal, then we will insist them to deposit that amount.
Because my respectful submission.
No, here, no, trial court has to see whether this is by jerk or that you have tried to align from the train, because of that you have boarded the wrong train, or you have tried to suicide. That has to be decided.
My respectful
There is no
submission.
finding on that. I cannot decide here.
My respectful submission. Already the evidence taken place, investigation papers are there. This honorable court has to intervene and the
Fix the time limit.
Please,
That will fix the time limit.
Again, it will take much time, my lordship.
Yes.
My respectful submission.
No,
Kindly.
find out ಮಾಡ್ಬಿಟ್ಟು you want to see that somewhat.
Please, my lordship, because this poor litigant. 2013 incident, my lordship.
Yes, we will do it. Yes.
That I cited the judgment, my lord, my objection to it not.
No, I will take that, since it is a self-inflicted and there is a report, DMA report saying that she tried to align from the train and there is no, this thing, traveling ticket. Yes.
A ticket, my lordship, entire luggage went with the train.
ಅವೆಲ್ಲ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಬಿಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ಟ್ರೈನ್ ಅಲ್ಲಿ ಟ್ರಾವೆಲ್ ಮಾಡ್ತಿದ್ರೆ ಸಾಕಂತ, ಬಟ್ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ಬೇಕು.
Para 9 is my objection. Yes. That will be considered, my lord.
Yes, I will pass on. Yes,
Please.
yes, your possess. Yes. Yes. Two appeals are filed by. Appeal number MFA 9193 of 2015 is filed by the injured. MFA 9194 of 2015 is filed by LRs of the deceased. ಹೆಸರೇನು?
Siddhappa, father of the
ಸತ್ತೋಗಿರೋದಾರ್ರಿ.
Sahana, daughter of the applicant number, appellant number 1 in the 9194 father, 9193 mother.
ದೇವಿ ಹೆಸರೇನ್ರಿ ಸತ್ತೋಗಿರೋದು?
Sahana.
LRs of Sahana, who died in railway accident. The case of the claimant that on 13/1/2013, the applicant what is that mother name? Mahalata. The applicant Mahalata
BL
was traveling from Bangalore city to Yelahanka by train number 11014 Kurla Express along with her daughter Sahana. This further case of the claimant that she was holding the journey ticket when said train slowed down at the Yelahanka. In the meanwhile, her daughter Kumari Sahana, due to jerk, fell down. She trying to catch her daughter, she lost her balance and fell down and sustained injury. After she recovered from injury, two claim petition has been filed. The mother Srimati, one claim petition has been filed by Srimati Mahalata. The other claim petition filed by unfortunately daughter died and daughter died, she is injured. The parents of
father of the deceased.
Father of the deceased, Sana has filed another claim petition. Petition number
9194.
9194. You to
9193 injured.
9193. Claim petition number.
Claim petition number 63 of 13 Mahalata injured myself.
63 of 13. How you do?
So 66 of 13.
66 of 13. On service of notice, respondent railways has appeared and filed a written statement, denied the allegation. Area contended that injury was not a bona fide, injured was not a bona fide passenger, and they have not produced ticket, and neither produced the ticket nor the number was furnished in their claim application. They have also contended that since they sought for, and also contended that as per proviso to the section 124A and 124C of the Railways Act, the instances occur not an untoward incident, but due to self-inflicted, due to her own criminal negligence act, resulted in self-inflicted injury. The basis of the pleadings of the parties that trial court has framed the following issues. Issue number 1 to 3 in application number, claim application number 2013. Application number 63 ನಾನು 63 ಇನ್ನೊಂದ್ರದ್ದು ನೋಡ್ಕೊಂಡಲ್ಲ. Appreciation of oral and documentary evidence has dismissed the claim petition agreed by the same. The claimant has filed these 2 appeals. So also learned counsel appearing for the claimant has contended that when the claimant was traveling in the train from Bangalore city to Yelahanka in a Kurla Express, due to jerk, her daughter Kumari Sahana fell down. She tried to catch her daughter. She lost her balance and fell down, sustained injury. The accident is occurred due to untoward incident. Immediately after, the police has filed a charge sheet, has registered a complaint and filed a charge sheet against the Railways Authority. Therefore, it is clear that the accident is occurred on account of untoward incident. The trial court has error in held that the claimant was traveling the train without any ticket, and they are not the bona fide purchaser passenger. He further contended that when there is no dispute that the claimants were traveling in the train, there should be a presumption that they are the bona fide passenger. The burden is shifted on the railways to prove that they are not a bona fide passenger. In support of his contention, he has relied on judgment of apex court in case of Union of India versus Reena Devi, 1903 SCC 572. So also learned counsel appearing for respondent has contended that after that incident, respondent has investigated that DRM report has been produced. As per that report, the train bearing registration number 1111 111014 express has no scheduled stop at Yelahanka railway station. The injured along with her daughter fell down while alighting from the running train. They got injured. That girl died on the spot due to that injury. It is further contended that even as per the DRM report and police records, it is mentioned that they have recovered the traveling ticket. Since it is a self-inflicted injury, 4A of the Act, the railway authorities is not liable to pay any compensation. The railway tribunal has rightly rejected the claim petition. Hence, they sought for dismissal of the appeal. Heard the learned counsel for the parties. There was statement and award and original records. The case of the claim is that Srimati Mahalata was traveling from Bangalore city to Yelahanka along with her daughter Sana. Train number 11014 Kurla Express. When they have reached near Yelahanka railway station, the said train was slowed down due to jerk. Her daughter Kumari Sahana fell down. While she trying to catch her daughter, she lost her balance and fell down and sustained injury. Her daughter Sahana, due to that accidental injury, she died on the spot. Mahalakshmi has suffered grievous injury. After recovering from the injury, Malata, yes, she has filed that claim petition. It is not in dispute that deceased Sahana and claimant Malata were traveling in the train bearing number 11014 Kurla Express. The next one, the case of Dina Devi, paragraph, as explained regarding self-inflicted injury, para 24, 22, para 22. The very same judgment also held that it is proved that the claimants are injured or deceased was traveling in the train. Presumption that they are the Bonafide passenger. The burden is on the railway authorities to disprove the same. The relevant paragraph is para 25. The finding given by railway tribunal is contrary to the judgment of apex court in Reena Devi case. Hence, the matter required to be remitted back to the tribunal with a direction to reconsider that matter, taking into the consideration of judgment of apex court in case of Reena Devi. Accordingly, the appeal is allowed dated so side. The matter is remitted back to the railway tribunal to reconsider the matter, taking into the consideration of judgment of Apex Court in case of Reena Devi. Lord Sitla, with 6 months from date of receipt of a copy of this.